came out here to support us. So, that she was crying and that he was a real perpetrator and has so compared to being picked, that was dismissed. And it's because you're in an airport. If you're in an airport and you do a disturbance there, they're going to change their rules.
Me too, but it's diminished.
But here's the real evidence.
I'll show you afterwards why it is so critical.
I literally
And after that, going back, she was basically lost her.
no, I think first week and a half. So actually, in between that, I got more information around the as well. Quite a few more. So not actually here from 2008 to 2022 on Amber as well, and saw that there were some bots back in 2013, even celebrity network bots. And that even, of course, amplifies this Michael Keaton on YouTube and like how it's like social media building company.
Circuit Court of Fairfax County is now in session. The Honorable Diana Sarabia presiding.
Good morning, Judy.
Please come along.
Good morning. All right. Do we have any preliminary matters at this time? Okay, sure. If you want to come forward. Okay. Thank you. All right. Good morning, ladies and gentlemen. All right. Have your seat. All right. Your next witness,
We call Dr. Richard Gilbert, Your Honor.
Dr. Gilbert.
Please raise your right hand.
Do you solemnly swear or affirm to testify truthfully in this case for penalty of law?
Good morning, sir.
Good morning. Good morning, Dr. Gilbert.
Good morning.
Would you please state your name for the record?
Richard Stephen Gilbert.
And what is your occupation?
I am an orthopedic surgeon and I have a subspecialty training in surgery of the hand and upper extremity.
Dr. Gilbert, where do you work currently?
I currently work in New York and Long Island at Northwell Health.
And you mentioned you have a specialty. Can you tell us a little bit more about what your specialty is?
So after medical school, I trained in orthopedic surgery and I did an orthopedic surgery residency. And for a year thereafter, I did a hand and upper extremity surgery resident fellowship. And so my practice for the past 22 years has been limited to surgery of the hand, wrist, and elbow.
And I think you may have gotten ahead of me there, but how long have you been practicing?
22 years.
Okay. What percentage of your practice over the past 22 years has involved surgery?
Approximately 1/3 of my practice.
Okay. And other than that 1/3 that involves surgery, what does the rest of your practice entail?
The rest of my practice entails some academic work, but mostly seeing patients in the office, seeing them either pre or post-operatively. A large portion of hand surgeons treat patients non-operatively.
In terms of the surgeries that you do, can you describe for us the types of surgeries that you will perform?
So again, I limit my practice to hand, wrist, and elbow. I would say approximately 75% or so of my practice is limited to the hand itself. And this really varies from anything from conditions like carpal tunnel syndrome to tendinitis to injuries such as amputations, fractures, sharp lacerations, etc.
Over the course of your 22 years of practice, how many surgeries would you estimate you've performed?
I perform about 300 to 400 surgeries a year, so a rough estimate would be approximately 10,000, maybe a little less.
Where are you currently licensed?
In New York.
And how long have you been licensed in New York?
I have been licensed in New York since 1994, so that would be 28 years.
And do you have any certifications?
Yes.
And can you tell us about those?
I am board certified by the American Board of Orthopedic Surgery, and I have a certificate of added qualifications in surgery of the hand from the American Society for Surgery of the Hand.
When did you receive your board certification?
2002.
And can you describe for us what current positions you hold?
I am currently an assistant professor of orthopedic surgery at Northwell Health, and I'm also the president-elect of the New York Society for Surgery of the Hand.
In what professional organizations are you a member?
I'm a member of multiple orthopedic organizations, including the American Board of Orthopedic Surgery, the American Association of Orthopedic Surgery, and the American Society for Surgery of the Hand, as well as the New York Society for Surgery of the Hand.
Have you published any articles in your field?
Yes, I have.
Have you testified as an expert before?
Yes, I have.
Can you ballpark for us how many times?
Certainly less than 10 over the past 22 years.
Your Honor, at this time, we'd like to offer Dr. Gilbert as an expert in the field of orthopedic surgery, specializing in the hand.
All right, any objection?
No objection, Your Honor.
So moved.
So Dr. Gilbert, what work were you asked to do in connection with this case?
So I was asked to review medical records, radiographs, pictures, as well as testimonies and depositions related to Mr. Depp's finger injury.
Okay. And to your understanding, what is Mr. Depp's explanation of how his finger was injured?
He describes that he was in Australia and his right hand was over the side of a bar when a vodka bottle was thrown at his hand, injuring his right middle finger. And he describes that the vodka bottle exploded.
Are you aware of other explanations for that injury?
There have been multiple other explanations, but I think the one that was brought out was by Ms. Hurd, who believed that Mr. Depp was holding a landline and out of anger was punching it against the wall, and this resulted in his right middle finger injury.
Okay. Based on your review of the medical records and other documents in connection with Mr. Depp's finger injury. How would you describe the nature of the injury to Mr. Depp's finger?
Well, the nature of the injury was he had what we describe as a comminuted fracture of the distal phalanx, meaning there was a fracture of the tip of the finger, and comminuted meaning that there were multiple pieces. So this is some type of blunt force with a high mechanism of injury. He also sustained loss of the tissue along what's called the ulnar side of the finger towards the little finger. And this appeared, based upon my review of the pictures, to be some type of sharp laceration because it represented a clean edges of the wound.
Can we take a look at Plaintiff's Exhibit 60? And pull up to go to page 3. And Dr. Gilbert, are you familiar with this document?
Yes.
And what is it?
So these are two radiographs, x-rays of Mr. Depp's finger, his middle finger.
Okay. Sorry, just to stop you, but Your Honor, may we publish this to the jury as a demonstrative?
Any objection? All right, we'll identify it as 60, page 3, and publish to the jury.
And Dr. Gilbert, sorry to cut you off there. Can you just tell the jury what we're looking at here in this X-ray?
Two X-rays of Mr. Depp's right middle finger after the injury, and towards the tip of the finger, there's a fracture. Again, what I described as a comminuted fracture, meaning there are multiple pieces at the tip. There's also a transverse component to the fracture closer to the joint.
In your view, what types of mechanisms can cause this sort of injury?
So this is a mechanism of injury that has high velocity or force, generally a crush type injury. A simple fall would not result in a comminuted fracture such as is seen in these X-rays.
And we're using the term comminuted fracture. Can we just define that quickly for us?
So again, comminuted, and it's not particular to a finger, is a medical term for a fracture that has multiple fragments.
In your opinion, could this injury have been sustained in the manner Mr. Depp described?
I do believe so.
And how might that work? How might a thrown vodka bottle produce an injury like this?
So vodka bottle, which is a hard object, would have crushed the tip of the finger, resulting in the comminuted fracture. And in addition, as the vodka bottle broke, the glass would have lacerated the finger, resulting in the soft tissue loss that was also seen with this injury.
What's your assessment of the description of the cause of the injury offered by Ms. Heard?
I think that's highly unlikely.
And why is that?
Because one, in general, when an injury is caused by punching against a wall or a hard object, it is extremely rare to see an injury to the tips of the fingers, which is seen with Mr. Depp's injury. Generally, you're holding something with a fist, and that in general leads to injuries most commonly of the knuckles here, or fractures of the metacarpals. We call these boxer fractures. Second most common after those would be injuries to these, but as you can see, if you're holding something and hitting against something, it is very unlikely that the tips of the fingers will be injured. In addition, just taking into account the radiographs and the pictures of the injury, I would not believe that solely a blunt force against a wall would result in the soft tissue loss.
What other injuries, if any, would you expect to see on Mr. Depp's hand if the injury had occurred as Ms. Heard described? So
if that were the cause of the injury, you would certainly, that would be a dorsally directed. So this is the dorsal in the back of the hand as opposed to the palmar side. So if you're punching against something, you would certainly expect an injury to the nail bed. And those are always seen in those type of injuries. If there is an injury to the tip of the finger, which again, I said is rare. So you would see either a loss of the nail or blood underneath the nail called a subungual hematoma.
In your review of the medical records, did you see any sign of anything like that?
None whatsoever.
In your view, is the injury, can you explain to us exactly why you think the injury is consistent with Mr. Depp's description?
Well, again, his hand, he describes his hand being held over a marble bar, which is a firm, something firm, unyielding, and the bottle hit against the finger. So basically the finger was crushed, resulting in, again, what I described as a comminuted fracture. And as Mr. Depp described, the bottle exploded. So it's certainly reasonable that the glass that exploded as well led to the soft tissue loss along the ulnar aspect of his finger.
Now, did you observe the testimony of Dr. Richard Moore?
Yes, I did.
And he testified about Mr. Depp's finger injury as well?
Correct.
Right. Did you agree with Dr. Moore's testimony?
Certain parts of his testimony I did, yes,
Okay.
but not all of it.
Focusing on the parts that well, first of all, why don't you tell us what you agree on?
Well, I agreed in terms of his interpretation of the x-rays, saying that he had a comminuted fracture and this was some type of high force injury.
Okay. What did you disagree with?
Well, I disagreed with several things that he said. He first said that he does not believe that the mechanism of injury could be, as described by Mr. Depp, holding the hand on the side of a marble bar, because he said it was all a palmar injury, and there was a palmar component to the injury. I'm talking about the soft tissue loss, but there was also a dorsal, meaning the back of the finger. So the soft tissue loss was actually, if you looked at the pictures which were shown when Dr. Moore testified, the injury goes like this. So it's an angled or an oblique type injury. And there's no way that anybody could determine whether or not it was a palmar directive force, meaning from the palm side, or a dorsally directive force. But certainly either are plausible.
Okay. Anything else come to mind that you disagreed with?
Well, he also described that this was definite. Well, he thought that this was a pinching, or what he described as an avulsion type injury. And that's referring to the soft tissue loss. That's certainly possible, but if you look at the pictures that were shown when he testified, the laceration looked fairly clean. There were clean edges, it was not jagged. And generally when you have an avulsion or a pinch type injury, you see a very irregular border to the skin. It's pinched off, you can imagine, as opposed to something that's cleaner that would be lacerated by, let's just say, a piece of glass or a knife or whatever. And that's more consistent with the pictures of Mr. Depp's injury.
And we're using the term soft tissue loss, and just to make sure we're on the same page, can you just tell us very quickly what you're referring to there?
Right, so there were two components to this injury. One, the fracture of the bone, and two, he had loss of the soft tissues so that the bone was exposed. So that amputated part that was found at the bar.
Now, you were saying that Dr. Moore testified that this was an avulsion, and meaning a pinching injury, right?
Correct.
Why do you believe it's more likely that it was a laceration?
Well, again, in general, a pinch type injury results in one, much more damage to the remaining tissue, but the remaining tissue is usually very irregular. The borders are jagged, and that's not what was depicted in the pictures.
Dr. Moore also testified that he thought a vodka bottle might not have sufficient force to cause the injury here. Is that your understanding of his testimony?
Correct.
What's your response to that?
I certainly believe that a vodka bottle that was thrown from a distance, against a hand that was resting on the marble bar is more than sufficient force to result in this fracture and soft tissue loss.
Now, in looking at the medical records and the pictures of Mr. Depp's hand, what was the condition of his nail?
There was no injury to the nail.
And other than what you've already told us, how does that factor into your analysis, if at all? The fact that there was no injury to the nail?
Well, it makes it highly unlikely that the mechanism of injury described by Ms. Heard resulted in this injury, because you really would always see an injury to the nail and or nail bed.
Do you have any opinion regarding the direction of the injury?
Well, it's certainly based upon the soft tissue loss. It's an angled injury, or what we call medically an oblique injury, because the soft tissue loss is at an angle. He lost some of the tissue on the back of the finger as well as the palm side, primarily along the palm side. But other than that, you can't make any assumptions. Unless you saw a videotape of this injury, nobody could tell you definitively what the direction of the injury was.
Dr. Moore also commented on the absence of fragments of broken glass in Mr. Depp's injury. Do you remember that?
Yes, I do.
And how does the absence of glass fragments factor into your analysis?
It really doesn't. I've seen hundreds, if not probably at least 500 or more glass injuries, and I would say probably the majority you don't see glass in these injuries. It is much more common to see glass embedded in the wounds when you're talking about very fine glass. So if, just say a wine glass would explode or something of that nature, where you get little tiny shards. But in general, when you have thick glass, such as you see in a bottle or a pane of glass, you generally don't see, because they break into bigger pieces, and you generally don't see the glass. But you certainly can, but it's not surprising that you don't.
Can you definitively state how this injury occurred?
No, nobody can definitively state.
I have no further questions, Your Honor.
All right, cross-examination.
Thank you, Your Honor. Good morning, Dr. Gilbert.
Good morning.
Now, you're being paid $1,000 an hour for your work on this case, correct?
Correct.
And you agree, just to sum up how Mr. Moniz finished, you agree that the finger injury could have been caused by any number of things, right?
Yes.
And you're not offering an expert opinion on what you believe caused the finger injury, correct?
Correct.
And you're aware, you said a few times Ms. Heard's account or Ms. Heard's explanation, right? You remember saying that?
Yes.
You're actually aware that Amber has said she doesn't know how he lost his finger. You're aware of that, right?
Yes.
So when you were just talking about Ms. Heard's account or Ms. Heard's explanation, you're aware she's never actually given an explanation for how she thinks he lost his finger, correct?
No.
Yeah. You're aware that Ms. Heard testified, and this was from your deposition, you're aware that she testified she doesn't know how he got his fingertip chopped off. You're aware of that, right?
Asked and answered, Your Honor.
Overruled.
No, I'm not. I reviewed the records, and in one of the testimonies depositions that I reviewed, it was described that that potentially it was lost when he was punching against the wall with a phone.
And on that, the last point there, I think we agree. Ms. Heard's testified in this trial and previously that she saw him smash a phone to smithereens, a wall phone. You'd agree with that, correct?
Correct.
But she doesn't know if that was what caused him to lose his finger. You agree with that, correct?
I agree. I cannot speak for her, but yes.
Okay. May I approach, Your Honor?
Yes, sir. Thank you.
Dr. Gilbert, you gave a deposition in this case on March 17th, correct?
Correct.
You were under oath in that deposition. You swore to tell the truth, correct?
Correct.
Okay, if you could turn to page 61, please. You see there are four pages per page of paper. It's on page 16 of the document.
Okay.
Okay, and line 9, you're asked a question, and then Amber's response to that question, that's the line 9. Can you read that, please? Answer, I do not know. I did not see his finger go off. Question, and Dr. Gilbert, are you aware that Amber did not see Mr. Depp's finger go off? Answer, I mean, I'm aware that, well, I am from reading this. I'm aware of the mechanism that she claimed would cause the finger injury. Question, but have you read anything so far that indicates she doesn't know how the finger injury happened? Answer, so far from what I'm reading here, yes. Did I read that right?
Yes.
And you've heard no testimony in this trial from Ms. Heard that the finger injury was definitively caused by the phone, so that she doesn't know, correct?
Correct.
And you'd agree that the fingernail was uninjured. You said that, right?
Correct.
And the nail bed was uninjured.
Correct.
Correct. But the area under the fingernail, in the pulp of the finger, that's where the injury took place, right?
It was not isolated to the pulp, no.
But it didn't injure the fingernail. That's my
Correct.
question. Okay.
Yes.
And under Mr. Depp's alleged theory, Amber threw a vodka bottle at him from 10 feet away or so, right?
Correct.
And you testified you have no way to determine the angle that the bottle was coming from.
Correct.
Right? But she threw it on a downward trajectory, correct? She didn't, there's no allegation, you've never read anything that she somehow underhanded it so it came up to his finger, right?
Correct.
And there's no way to tell, as you testified, what exact direction it came from, right?
Correct.
And the glass exploded, but you've already testified there was no glass in the wound, right?
Correct.
You haven't read any record of that in any medical records, correct?
Correct.
You also haven't read anything about there being cuts on the rest of his hand, right?
Correct.
And there was no glass found anywhere on the rest of his hand, correct?
Correct.
No bruising or injury on any other part of his hand other than the tip of his middle finger.
Correct.
And somehow, under Mr. Depp's theory, that bottle hit the bar and his fingers, but didn't damage the fingernail while it amputated the area under the nail, correct?
Correct.
And your explanation of that is that you believe that his hand must have moved at some point during the force of the injury. Isn't that correct?
No, I said it could have, but I did not say that it did.
No, you believe that it did, don't you?
I said that it likely did, but I was not there and I don't have videotape of the injury, so I can't determine that definitively.
Okay. Well, let's turn to page 25 of your deposition, please, on page 7.
Sorry,
Page 25 and 26, so it's page 7 of the document.
Okay.
Sorry if I was unclear on that.
No problem. I'm there.
Okay. Line 18, question, and to be clear, by, quote, sitting in that position, you mean hand down, palmar side down. Answer, that's what he claimed. I mean, according to the history, yes. Question, and would it matter if Mr. Depp's hand was palmar side down? Answer, not really, because it really, and I discussed this, it really just depends upon the angle at which the injury occurred. And as well, you can't determine if his hand had moved at some point during the force of the injury, which I believe it probably did, which I didn't get into in my note here. But question, and why do you believe that? Have you read anything in any of the materials to suggest that? Answer, no. Just that if it completely hit on the back of the finger, then he would have had a nail bed injury, which he did not. Did I read that right?
Correct.
That was testimony you gave under oath a month or two ago, right?
Correct.
So even though you have never read anything that suggests Mr. Depp's hand moved, his hand moving is the only way that you can fit your testimony into what Mr. Depp wants you to testify to about how the injury occurred, isn't it?
No, that's incorrect.
Okay, that's what you testified to, that if his hand hadn't moved, that there would be a nail bed injury, correct?
That is incorrect. That's not what I testified.
In
That's not
fact,
what,
Dr. Gilbert, there's another explanation for how Mr. Depp somehow suffered an injury that didn't injure his nail one bit, but injured underneath the nail. And that explanation is that it didn't happen how Mr. Depp says it did, correct?
I cannot make that assumption, nor can you.
No further questions. Thank
All
you.
right, redirect.
Dr. Gilbert, just very briefly, the absence of other cuts on Mr. Depp's hand, how do you factor that into your analysis?
You certainly can see an isolated finger injury with any type of injury, and I would say any other host of mechanism of injuries, you'd more likely see other. So again, if you're, I'm just using this as an example, if you're punching against a wall, you would more likely see multiple injuries to multiple fingers. It really just depends upon how the bottle or how the mechanism of the injury impacted the hand at that point in time.
Ms. Heard's counsel made a point of emphasizing that there were no bruises or other injuries on the hand, right?
Correct.
And how does that fact affect your analysis, if at all?
Well, it doesn't discount anything, but it certainly makes other potential causes of injury more unlikely, meaning punching against a wall or getting the hand slammed in a door or something like that.
And your discussion of Ms. Heard's explanation of the alternative cause of the injury, was that based on anything other than Ms. Heard's statements?
No.
No further questions, Your Honor.
All right, thank you. Doctor, you can have a seat in the courtroom or you're free to go. Thank you. You can just leave it there. That's fine. Thank you, sir.
Thank you.
All right. Your next witness.
Plaintiff rests, Your Honor.
All right. Plaintiff rests the rebuttal case. All right. Defendant counter plaintiff rebuttal case. Sure. All right, rebuttal evidence.
Yes, Your Honor.
Mr. Murphy?
We call Mr. Julian Acker.
All right. Mr. Ackert? Yes, be sworn.
Do you solemnly swear or affirm to testify truthfully in this case for penalty of law?
Good morning.
Morning.
Can you please state your name?
Julian Ackert.
And can you please describe your educational background following high school?
I have a Bachelor of Science in Computer Science from the University of Virginia.
What is your profession?
I am a computer forensics investigator.
Where are you employed?
I work for a company called iDiscovery Solutions, or IDS.
And what is your title?
I'm a managing director at that company.
What services does IDS perform?
IDS provides consulting, expert testimony, forensic analysis, data analysis, electronic data review and production services, all to the business and legal community.
What, if any, of those services performed by IDS have you performed?
I perform all of those services.
How many years of experience do you have in computer forensics investigation?
I've worked in the industry for 20 years.
Can you please describe that experience to the jury?
I have experience creating and implementing data preservation and collection strategies, doing data collections in a forensically sound manner, extracting data from collections, as well as analysis and metadata analysis of the evidence that I extract.
You mentioned collecting data from forensic collections. What material are you forensically imaging?
This would be any type of material that stores digital evidence, an iPhone, an iPad, a tablet, laptop, a cloud account, your Gmail account, anything that has digital evidence.
Have you published in your areas of expertise?
Yes, I've published on data preservation and collection and analysis strategies.
Have you ever given any trainings or presentations to other individuals in the e-discovery area?
Yes, I have. I do trainings and presentations to lawyers through continuous learning education.
What, if any, professional certifications do you have?
I have a GIAC GCFE, that's the GIAC Certified Forensic Examiner certification.
And what were the requirements of obtaining that certification?
To obtain that certification, you need a minimum number of hours in the field, as well as you need to pass a test with a certain degree of, a certain percentage of passing.
Do you belong to any professional organizations?
I do. I'm a member of a conference called the Sedona Conference. It's a conference that is a group of legal professionals, judges, and technologists, and we discuss the intersection of law and technology issues in the legal community.
Have you previously served as an expert witness?
Yes, I have.
And when did you first serve as an expert witness?
I believe that would have been around 2009 was the first time I served.
Have you previously been qualified as an expert witness in the field of computer forensics?
Yes, I have. I've been qualified probably a half dozen to a dozen times in both federal and state court, including this court right here.
And has a court ever declined to qualify you as an expert witness?
No, they have not.
Your Honor, I offer Julian Acker as an expert in the field of computer forensics.
No objection, Your Honor.
All right, so moved. Could you just spell your last name for me, Mr. Acker?
Ackert, A-C-K-E-R-T.
Thank you so much, sir.
Mr. Acker, what is forensic imaging?
Forensic imaging is the process of capturing the data on a digital device in a forensically sound manner.
And how is a forensic copy created?
Using specialized software that's available to forensic investigators, we're able to collect the data from devices, and that software may vary depending on the device, like a phone or a laptop.
What type of information does a forensic image collect?
It's meant to really collect everything on the device. So for example, on a laptop, it's going to collect your documents, your emails, your photographs, your documents like Excel spreadsheets, PDF files, any applications that you ran, the history of what you've opened or looked at on the laptop, as well as all of the metadata for these different types of electronically stored information files.
And does any other information accompany that information that's collected?
Typically with a forensic image, you're also going to get log files. Log files are files that help you validate the forensic image and verify that it was a forensically sound data collection.
And how do log files enable you to do that?
Log files list information within the files. Sometimes they're even embedded within the images themselves, but they provide verification information that allows you to authenticate the image and the data on the image.
What is the purpose of creating a forensic image of devices or data?
In order to extract and analyze data forensically for the courts, you need to create a forensic image of the data first and gather the data from the forensic image.
And what, if any, specific types of data are collected in that image and extraction?
It's going to be any type of data that comes from the image, whether you're extracting photographs or documents or spreadsheets or anything of that nature.
Do you recall Mr. Neumeister mentioning the term hashing yesterday?
I do.
What is that?
Hashing is essentially a digital fingerprint of a file. It's an evaluation of the binary ones and zeros, or how the file is stored on a hard drive, and it examines the ones and zeros in a manner that gives every file a digital fingerprint, essentially, and identifies the uniqueness of the file.
And what, if any, applicability does hashing have to the visual appearance of data?
Hashing has nothing to do with the visual appearance. For example, if I had a Word document that I printed and then saved, therefore I haven't visually changed the Word document, the metadata of that Word document indicating that I printed it would be different, and therefore that Word document would not hash to the version that I used before printing.
Can you give any examples of digital photographs that visually appear the same, not hashing?
I believe Mr. Neumeister included 3 of those in his demonstratives yesterday, 3 side-by-side photographs that looked visually the same but did not hash. It made sense that they wouldn't hash. Each of them had different file sizes. And a file size can change for a photograph depending on what you do with the photograph. So for example, maybe you want to take that photograph and email it to somebody, and on your phone, you choose to use a small, medium, or large, or different size of photograph when you email. When you send that email with that photograph, you've changed the hash value because you've changed the ones and zeros because you've changed the size of the photograph.
And what, if anything, do you recall from Mr. Neumeister's testimony regarding Photos 3?
Mr. Neumeister was concerned about a particular metadata field, EXIF metadata, which there's 2 types of metadata for files. There's the embedded metadata, which is what we're discussing here, the EXIF metadata, and external metadata. And Mr. Neumeister was concerned with embedded metadata within the file that indicated that the software version that the file last ran through was Photos.
What is Photos 3.0?
Photos is actually the software application that's built into the Apple Macintosh operating system for laptops. This is the application that launches by default when you're on an Apple computer and use Photos.
What are the capabilities of Photos 3.0?
There's multiple capabilities for it. You can, for example, create an album with it and put multiple photos within an album. You can organize or sort your photos by date and time taken or place. You can also use that to edit photos.
You mentioned metadata earlier. What is that?
Metadata is information about a file. For example, with a document, it could be when was the document created or last saved, or who saved it, who was the author of the document. For photographs, metadata includes information that you've seen on demonstratives before, including when was the image taken, what kind of phone took the image, what software was originally used for that image. Any type of information inside the photograph, the EXIF data that you've heard, is metadata.
Did you form any opinions in response to Mr. Neumeister's testimony regarding Photos 3.0 appearing in a software EXIF metadata field?
Yes, I did.
And what are those?
My opinion is that for each of the photos that he identified, for all but one in his demonstrative, I actually found the equivalent original photo that did not have photos in the EXIF metadata. In other words, those are the photos that he was indicated he would have expected to see the iOS or the phone software version on those photos.
How do you know it is an original version of the photograph?
This is a little bit dependent on the Apple ecosystem. Amber uses Apple devices, and those devices, by definition of how Apple works, synchronize your information from device to device. So for example, if you take a photo on your phone, you see that same photo on your tablet or your iPad or your iCloud account or even your MacBook. And that's all because of user experience. Apple wants you to be able to see and visually have the same experience on all your devices. So the photo that was originally taken traverses or gets synchronized to other devices by design of Apple. And that synchronization process does not affect the metadata that we're talking about here, which is the embedded metadata.
When you say that a version of iOS software was listed in the software exif metadata field, what does that mean?
That means that the photo was not saved using the Photos application.
And what, if any, data sets did you use to come to that conclusion?
I used all of the data sets that I collected or were collected for Amber, including mobile devices, tablets, laptops, etc.
Michelle, can you please pull up Defendant's Exhibit 1671? Do you recognize this chart, Mr. Eckert?
I do.
What is it? Without yet saying the contents, just generally, what is it?
This is a chart I created as part of my report.
Your Honor, permission to publish Defendant 671 is a demonstrative.
Any objection?
No objection, Your Honor.
All right. It'll be published as a demonstrative.
Mr. Acker, can you please describe in more detail what the information in this chart? Michelle, if you could just stay at the top for a quick second. A little further up. Great.
Thank you. This chart represents for each of the items in Neumeister's report, which his demonstrative was based on, the page number of the item on his report and the items that I found on Ms. Hurd's devices that did not indicate the software metadata field showing photos. Rather, they indicated that they were the original software metadata field of iOS.
And do you see the second column titled Neumeister Report Date Captured?
Yes, I do.
The information in that column mean?
This is the date time metadata of the particular photo on Neumeister's report. So for example, the first row, 23, the date time captured or the date captured is December 16th, 2015. The second row, 24, you see that the date time is May 21st, 2016. Third row, May 21st, 2016. Fourth row, May 21st, 2016.
You just scroll to the next page, please, Michelle. Please continue for the items on this page.
The top row of this page, the one that came from Neumeister's report, page 30, shows December 16th, 2016. And then finally, 32 shows March 23rd, 2013.
Do you see, can you scroll back to the top, please, Michelle? Do you see the, all the way to the top, I'm sorry, the right-hand column of this chart?
Yes, I do.
And where it says device ID and file name?
Yes.
Can you please explain what the information in that column means for each of the items identified for Mr. Neumeister's demonstrative?
So these are the evidence IDs, and evidence ID is the ID value I give to a particular piece of data that I collect, for example, a phone or a laptop, and the matching file name found on that evidence ID that indicated the original version of the same photograph that Neumeister identified that did not show photos in the software metadata and rather showed the iOS version in the metadata.
And what do the little A's followed by numbers back up, what does that mean?
Those are evidence IDs. Anything with an A number is the evidence ID of an actual device collected. Anything that starts with a backup and follows by another number is an iTunes backup.
So what, if any, what items in this right-hand column, based on the coding you have here, are iTunes backups?
Only the ones that start with the word backup. Even the ones that start with an A number are actually an iTunes or an iOS backup in iCloud. So your phone can actually be backed up to iCloud, and those are coming from an iOS backup in iCloud. Everything else is coming from an actual physical device.
Can you just take this down for a second, Michelle, and pull up 1675, please? Defendant 1675. And do you recognize this chart, Mr. Eckert?
Yes, I do.
Without yet getting into the contents, can you please describe generally what it is?
This is a chart that I prepared as a summary of my findings.
Permission to publish defendant 1675 is a demonstrative, Your Honor.
Any objection?
No objection.
All right, 1675 will be published as demonstrative.
Can you please describe in more detail what the 3 columns you can see in this chart represent?
Sure, this starts to give some detail about the particular evidence ID. So for example, A001 was an iPhone X of Amber's that was collected. A002 was an iPad of Amber's collected. A11, 12, and 13, slightly down, are 3 different laptops that were collected for Amber.
And do you see the IDS evidence number column?
Yes, I do.
Do you see the source type column
Yes, I do.
and the source details column?
Yes, I do.
Can you please describe what those columns mean?
Generally, the IDS evidence number is the evidence number that we assign to a particular piece of evidence, and the type and details come from a description of that type of evidence based upon the collection set.
And Michelle, can you please do a side-by-side of 1675 and 1671? Thank you. So, Mr. Acker, can you please describe the relationship between these 2 demonstrative exhibits?
Certainly. If you look at 1671, the one on the left, you can see in the 4th column the different evidence IDs where I identified the original versions of those same pictures that Mr. Neumeister had specifically identified and the sources of where they were identified. So if you look at the first one, for example, the picture Neumeister referenced on page 24, or I guess that's the second one, there are equivalent versions or original versions of those that do not show the software EXIF metadata field of photos. Rather, it shows the original iOS version on A001, which was Amber Heard's iPhone X, A002, which is Amber Heard's iPad Pro. Scrolling on down through there, you see it on A0011, which is Amber Heard's laptop, same with A0012 and 13. You can see this again with the next row that's visible at the very top. Neumeister identified a photograph on page 30 taken on December 16th, 2015. And he was concerned about the EXIF metadata of that, showing the software version of photos. The original versions of those were found again on A001, that's her iPhone X, A002, her iPad. And it's not surprising to me that I found all these on all the devices because that's how the Apple ecosystem works. It replicates your pictures or synchronizes your pictures across your devices when you take them.
Mr. Acker, you can take this down, Michelle. Do you recall Mr. Neumeister's testimony regarding what he claims of EXIF metadata modification?
Yes, I do. This is a completely hypothetical scenario. Mr. Neumeister never specified any pictures with specificity that had EXIF metadata modification, and it's a hypothetical in my opinion.
Mr. Acker, did you form any overall conclusions in this case?
Yes, I did.
And what were those?
The images that were created in this case included log files that allowed me to validate and verify the evidence collected. I validated and verified the log files of the evidence for which I found Mr. Neumeister's original photos that he had concerns about, specifically the ones that had iOS in the software metadata field. I validated that those came from devices that had log files that were validated by me. In other words, they came from original evidence files, and in most instances, they came from more than one file.
Mr. Acker, the opinions you have testified to today made to a reasonable degree of forensic certainty.
Yes, they are.
No further questions, Your Honor.
All right. Cross-examination, sir.
Thank you, Your Honor. Good morning, sir.
Good morning.
You've worked with opposing counsel's law firm approximately 20 times before?
Give or take, yes.
For more than a dozen years?
Those 20 probably would have been spread out over more than a dozen years.
Okay. As you sit here today, you cannot testify that all of the photographs produced by Ms. Heard are authentic originals, correct?
Now, I can testify to the ones that Mr. Neumeister identified with specificity.
Right, but there were thousands of photographs provided that Mr. Neumeier didn't testify about, right?
I have no opinions on any photographs that the opposing expert has no opinions on.
All right. My question to you, though, is as you sit here today, can you testify that all the photographs produced by Ms. Heard are authentic originals?
As I sit here today, I cannot opine to photographs that have not been presented to me that are not authentic originals.
All right. You'll agree with me that in some instances, Ms. Heard produced multiple versions of the same photograph, right?
Yes.
Yeah, you just talked about it, right?
Yes.
All right. And you'll agree with me that the XF data of some of the photos produced by Ms. Heard reflect the use of a photo editing application.
No.
No?
I'll agree that they show the use of the Photos application, which is a sorting and editing application.
Okay, so what you were quibbling with is that it will both sort and edit.
That is correct.
Okay. Are you prepared to swear under oath that each and every photograph provided by Ms. Heard and entered into evidence in this court is an authentic original?
Based on the metadata that I have reviewed of the specific photographs I have reviewed, I can confirm that those are authentic original photographs. For the ones that Mr. Neumeister identified, I identified photos that were authentic originals.
No, I'm asking you a broader question than that. There were multiple photographs that Ms. Heard provided that were entered into evidence in this court. Are you testifying that those are each authentic originals?
I have no testimony or opinion on those because nobody's provided me opinion that they're not.
Okay. Mr. Gibson, will you pull up Defendant's Exhibit 712 and Defendant's 713 next to one another? Your Honor, these have already been admitted, and I ask that we publish it to the jury.
Okay, if they're admitted, we can publish.
Can you see those, sir?
Yes, I can.
You'll agree with me that those are different pictures?
Visually, they look different to me, yes.
All right. We can take that down. Mr. Gibson, can you pull up Plaintiff's Exhibit 1308? This has not been admitted, Your Honor, and I propose to use it as a demonstrative.
Any objection?
Not as a demonstrative, Your Honor.
All right. Be identified and published to the jury as a demonstrative.
Any objection to entering it into evidence?
I would object it's cumulative, Your Honor. Actually, no, no objection, Your Honor.
No objection. All right, it's in evidence then.
1308 is in evidence. Mr. Gibson, can you blow up the time, date, and file name? Sir, you just agreed with me that those two photos are different photos, correct?
I agreed that they were visually different, yes.
Right. So they are two visually different photos that were created at the exact same hour, the exact same minute, the exact same second as each other, correct?
And that's what the daytime metadata shows, yes.
And the metadata shows something else too. They have the exact same file name, don't they, sir?
Yes, but that's not embedded metadata.
Right. How would you have this jury decide which one is real?
I think you would need to look at the software metadata field, which I haven't looked at. I don't recall if I looked at for this particular field, but I think that's what even Mr. Neumeister said, that you need to look at the software metadata field.
But we have two photographs entered into evidence in this court that have the same identifying information, but in your view, look visually different, correct?
I don't agree that they have the same identifying information. I don't see a software metadata field here.
The identifying information includes the hour, minute, and second they were taken, this picture were taken.
I see that.
No further questions.
All right, and just for the record, since we already have 712 and 713 in evidence as redacted, now this will be 712 and 713A. So 712A and 71213A are now in evidence, just to keep the record clean, okay? All
Thank
right,
you, Your Honor.
redirect.
Mr. Acker, you just mentioned embedded metadata. What is that?
Embedded metadata is metadata inside a file. I talked earlier about the date printed of a Word document. That's embedded into the file, and that traverses with the file wherever it goes.
And based on all of the photo metadata you have reviewed, do you have any reason to question the forensic authenticity of any photos Mr. Neumeister testified to for which you are responding to?
Can you repeat that question, please?
Yes. Based on all of the photo metadata you have reviewed, based on the photos Mr. Neumeister testified to, do you have any reason to question the forensic authenticity of those photos?
I do not.
Following your cross-examination, Mr. Acker, have any of your opinions in this matter changed?
They have not.
And is it still your testimony that the opinions you testified to do today are made with a reasonable degree of forensic certainty?
Yes.
No further questions, Your
All
Honor.
right, thank you. Sir, you can have a seat in the courtroom or you're free to go. All right. Did you want to approach just for a moment? All right, your next witness.
Your Honor, we would like to call Dr. Don Hughes to the
All
stand
right,
again.
Dr. Hughes. Thank you, Doctor. Just a reminder that you're still under oath, okay, ma'am?
Yes, Your Honor.
Thank you.
And could you please just remind the jury who you are again?
Sure, I'm a clinical and forensic psychologist. I am board certified in forensic psychology. I am the president-elect of the trauma division of the American Psychological Association. And I evaluated Amber Heard over 6 visits for approximately 29 hours.
And why are you here today?
To offer rebuttal testimony to Shannon Curry's testimony of yesterday.
Okay. Now, Dr. Curry said you used improper methods. Would you agree with that?
No, I would not.
Why? Please explain.
As I testified to you all several weeks ago, I used a standard forensic procedure that is well established in our field. It is a multi-method, multi-hypothesis driven procedure where you're looking at a variety of different details and tests and external data to arrive at an opinion, and you're looking at the consistency across that data. There are three sort of sets of tests that we use as forensic psychologists, and I think that's where it seems that Dr. Curry seems confused. We have forensic assessment instruments. Those are instruments that are very neatly tied to a legal criteria. Those are most notably done in a criminal court for competency. If someone has competency to stand trial, we have very clear measures that can track that legal criteria. The next level are forensically relevant instruments. And those instruments are not linked to a specific legal criteria, but they do have information that's germane to that finding. And that can be an example of a risk assessment measure and a malingering measure. So the malingering measure that I utilized was the MFAST, and that was the only malingering measure in this case. The third category are clinical assessment instruments, and those are instruments that are validated and well-researched and used in the clinical realm as we understand people's symptomatology and diagnostic and functional capacities. Those are things like the MMPI, the PAI, the CAPS, the TSI, because they are clinically relevant and they still give us very valuable information to individuals who are involved in a court case. And the reason that we do that and we use these clinical measures is because the majority of the people that we see are in a clinical realm. They're not in a courtroom. So they're well-validated and well-researched methods. What we also do is use a very different types of tests within that category. We use some checklists, some face valid checklists. We use some tests that are those broadband personality inventories. We use structured clinical interviews. And then we look for the consistency across those data points. And when we use different types of tests, it gives us information about the individual, how they go about these tests in these different modalities.
Now, Dr. Curry seemed to suggest that Amber Heard tested the most extreme category in all of these different tests. Is that accurate?
Objection compound.
Overruled.
That is not accurate. They were not on the checklist. I mean, people sometimes do. They go, all the time, this happens to me all the time, frequently. And that is not how she endorsed these tests. She endorsed them in a very moderate way, in a very nuanced way, describing her symptoms that I determined was accurate and reliable.
Now, Dr. Curry also suggested that Amber Heard was tested very, very high, 98 percentile, I think, on malingering and feigning. Could you speak to that, please?
Sure. So, I mean, she said a lot of things. So let's go through those tests. The first was the PAI, and that's that other broadband psychological
Objection
measure.
non-responsive.
I think it's very responsive.
Sustained.
Okay. Could you tell the jury about the PAI test that Dr. Curry
Yes.
addressed?
So, yes. Thank you. So that's the broadband measure that has validity scales built into it that gives us indications about how the individual goes about the test. I told you last time that there was no evidence of malingering or exaggeration or feigning on that test. What Dr. Curry was talking about was this tendency to put your best foot forward to minimize faults on this PAI. That scale was right at the cusp. And then there are two other measures that we look at that to say, you know, is this enough for an elevation for me to consider that as a serious response distortion, of which Dr. Curry was saying, and it was not. What was relevant on this test was there were elevations on anxiety, on affective anxiety, meaning anxiety, tension, worry, on traumatic stress, on hyperactivity, and on affective instability. Those were the four scales that were elevated on this test. The borderline scale was not elevated on this test. And this test—
Objection, Your Honor. May we approach?
Yes.
So Dr. Curry, let's move to the TSI-2. Dr. Curry testified about your findings on that. Did you agree with her testimony yesterday?
No,
Please
again,
describe why. Explain why.
what Dr. Curry went back to, which is this 98th percentile, which I told you in the manual, all you have to do is read the manual. It says specifically that we do not use the percentile ranks for this test. That indicates to me that, Dr. Curry does not know the psychometric properties of this test, and then she then is therefore not qualified to interpret it. That score, the one that's elevated, which she's talking about, that percentile rank, has a raw score. Amber's raw score is a 10. The cutoff score is a 15. She's nowhere near that level of exaggerated symptoms where I can't further look at that test. Secondly, there are 3 scales out of maybe there's about 20, a little more on the TSI that were elevated. Intrusive experiences, that's when thoughts and memories of the trauma come into your mind when you don't want them. Defensive avoidance, sort of behavioral ways that we try to push out those memories and not think about them. And then relational avoidance, a way of having difficulty in interpersonal relationships. Those are all trauma-based symptoms, and those were elevated on this test.
Thank you. Dr. Hughes, the MFAS, Dr. Curry addressed that as well and had criticisms for your interpretations. Do you agree with that?
No.
Please explain to the
So the MFAS, as I told you last time, is a measure of malingering. It's the only measure of malingering that was done in this case. Dr. Curry did not independently administer measure malingering, and there are other ones that she could have done to augment her evaluation. And she kept saying something that MFAS is not for malingered PTSD. That's wrong on a couple levels. People who are going to malinger and feign don't only feign one diagnosis. They sometimes talk about all different symptoms that they have, and they exaggerate and they make themselves seem much worse than they are. So when you're doing an evaluation, you're giving a malingering measure to get a sense of how this person is responding to this evaluation. Now, what you do is you take those 3 tests that I talked to you about, the PAI, the TSI, and the MFAS, all with valid validity scales, you have greater confidence in your results. And that is in the literature, and that's literature that Dr. Curry cited in her report. That bolsters the methodology that I used. That in the study that had the PAI, the MFAS, and the TSI in the title of detecting feigned from bona fide PTSD.
Thank you. Now, Dr. Curry also talked about the danger assessment scale and suggested that you had inappropriately interpreted that. Do you agree?
That's also incorrect.
Please describe for the jury.
Which I told you last time, the danger assessment scale has statistically validated risk factors for serious or lethal domestic violence. Those risk factors exist whether we go forward, we're sitting with someone in an acute setting and assessing them right now, or if we look backward and we look retrospectively about what factors may have been present in a case that indicated severity. That instrument is used in what we call, there's called domestic fatality review boards. Those are boards after somebody has been killed, a homicide has occurred in a domestic situation. They look at these risk factors to see what was there and what could be done.
All right. Dr. Curry also criticized your administering of the CAPS-5. Do you agree with her criticisms?
I do not.
Will you please explain to the jury?
So the CAPS-5, as you all have heard multiple times, is a structured clinical interview in determining PTSD according to DSM-5 criteria. On this measure, Amber Heard scored in a moderate range. She did not over-exaggerate on this test. She could have said no, mild, moderate, severe, and extreme. All of hers were either 2s or 1s or 0s, not above that. So she's scoring in the moderate range, which still has functional impairments. I mean, we don't want someone to be having moderate PTSD, but that's not an exaggerated profile or exaggerated response style of someone who's answering an instrument.
Right. And the last of these Dr. Curry referred to was the PCL-5. Do you agree with her criticisms of your administration and interpretation of that?
No, so the PCL-5 is a checklist of symptoms of PTSD. It is, as she said, it is a face valid instrument. It seems it's very clear about how you can endorse this. But what the person has to do is say, how disturbed am I by these symptoms? And when you have face valid measures with these other measures that have the built-in sort of ability scales, you're sort of controlling for that response bias error. You're controlling for that individual to sort of over-exaggerate. But then what you do with that test, because this is, we're not just administering them like robots, is you go and you do a clinical assessment. And that's what I did. I took what she wrote, what she endorsed on that test in January of 2021, and I did a clinical assessment of those symptoms to see if they meet criteria for PTSD. That is something we do clinically, and I do in my office all the time. And yes, she did meet PTSD from that in January 2021.
Thank you. Now, Dr. Curry said you misinterpreted her test results. Do you agree with that?
Yeah, I agree that I agree that I interpreted them, that she misinterpreted them.
Okay, and please explain.
Yeah, so I said that before. My stance on the MMPI and how she interpreted it is, I believe, wrong, and I think most.
Objection, Your Honor.
All right.
That's the issue we just addressed.
All right.
I don't.
If you want to approach.
Now, Dr. Hughes, Dr. Curry also testified that a victim of PTSD has to effectively be prone and unable to function at all. Would you agree with that?
Objection misstates the evidence.
She said they couldn't hike, they couldn't move, they couldn't function in any way, shape, or form.
Objection.
Thank you.
No, that is not correct. That is often actually a myth and misconception about individuals who were struggling with PTSD or trauma-based disorders. And I'm often called to answer that and speak to that. People who are struggling with trauma and PTSD are very strong, courageous, resilient people, even though that they're struggling. They get up, they have to go to work and drop their kid off at school and go to the market, even though they're struggling with these symptoms. So I often talk about it as this sort of walking around with a 50-pound bag of flour on their backs, just sort of trying to get through the day, where sometimes that button's going to press play and the trauma is going to start activating in their head, and then they're going to be having to think about it and have startle and have physiological reactions until they can find a way to hit that pause and shut it off again. So they still have, impairments in other ways, but they go about their lives. They're not, totally debilitated. If you have someone in that high range, the highest score is an 80 on the CAPS. Ms. Hurd had a 28. If you have someone in the higher range, we have seen people who are, severely disabled because of it, but that's not the norm of people who have this moderate PTSD.
And did you find functional impairment with Amber?
Yes, I did.
Now, Dr. Curry also said that it is not within the scope of a psychologist to evaluate domestic violence. Do you agree with that?
Of course, I don't agree with that. This is what I do for a living, day in, day out, for 25 years. We are specifically trained to understand the profound impact that trauma has on people's lives. That's what we do in the trauma division of the American Psychological Association. We disseminate that knowledge. And domestic violence is one of those profound traumas. Domestic violence is part of state licensing boards, that you can't get licensed in some states unless you take training on domestic violence. You can't renew your license unless you get training on domestic violence. So people who have, specialized training in this area, it is, beholden upon them to accurately assess for intimate partner violence and sexual violence. And it's more important to assess for the sort of scientific understanding of what domestic violence is. So you have to assess for the physical violence, the psychological violence, the surveillance, the economic, the emotional abuse, and the sexual violence. That is not gratuitous. That is
Objection.
understanding.
Narrative.
All right. Next question.
Okay. Now, Dr. Curry suggested that you made a determination just based on personal opinion and just on checklists and a couple of tests that you misinterpreted. Would you agree with that?
I vehemently disagree with that. As I stated to you, over 29 hours and 12 psychological tests and reviewing a slew of documents in this case, most importantly, therapy records and interviews, collateral interviews with therapists, using all that data. That is what a solid forensic methodological exam looks like. And then I made my conclusions based on my clinical education, knowledge, and training to come up with a professional expert opinion.
And just to remind, to make sure we're reminded here, you were qualified in this court, in this case, as an expert in forensic psychology, in specifically in domestic violence and in no, I just lost it. And in violence, correct? Intimate and in trauma, correct?
But I believe
Objection,
it-
Your Honor, misstates the record.
If you want to ask the question again.
Yeah, I probably should do that. You were qualified. I got to find my note. You were qualified as an expert in forensic psychology with a specialty in domestic violence and in trauma, correct?
Correct.
Okay, and that was in this case.
That's correct.
Okay. Now, do you still hold the same opinions you did that you gave the jury earlier?
Yes, I do.
And do you still hold them within a reasonable degree of psychological probability and certainty?
Yes, I do.
Thank you.
All right, cross-examination.
Yes, Your Honor, but can we approach quickly?
Sure.
Good morning, Dr. Hughes.
Good morning, Mr. Dennison.
The last time you were here, I believed that you testified that you had diagnosed Ms. Heard with PTSD before you gave the gold standard CAPS-5 test.
That's correct.
Right. And that diagnosis is actually reflected in the first of the disclosures you put forward in this case.
I believe the first disclosure was February 2021. And at that point, I had done 11 psychological tests. That's correct.
Right. And your disclosure reads, Ms. Heard's responses on the PCL-5 support a DSM-5 diagnosis of post-traumatic stress disorder with an etiology of intimate partner violence she experienced by a former partner. Remember writing that?
That's correct.
Okay. You just testified that you need to read the manual, right?
Yes.
Okay. Can we put up 1311 as a demonstrative?
Any objection to
I don't know
1311?
what it is, Your Honor.
All right, if you want to
May we
leave,
approach?
you want to approach?
Tom,
Thank you.
I don't see this in my document either.
They're getting the right one up.
Yeah, we got it. Let's use 1312.
1312, okay. And that, any objection to that demonstrative?
No, Your Honor.
Okay, 1312 can be published to the jury.
Dr. Hughes, do you recognize what the National Center for PTSD is?
What it is?
Yeah.
Yes, I do.
And they publish the PTSD checklist for DSM-5,
That's correct.
that what we've been calling the PCL-5.
Correct.
All right. And are you familiar with the document that's on your screen?
Yes.
What is it?
It's the instruction manual to how to administer the PCL-5.
Okay. I'd like to move for the admission of 1312.
Any objection to 1312 coming into evidence? All right, 1312 in evidence.
All right. Can we go to the second page? Can we blow up the second paragraph on the right? That's the PCL-5 should not be used as a standalone diagnostic tool. When considering a diagnosis, the clinician will still need to use clinical interviewing skills and a recommended structured interview, e.g., the CAPS-5, to determine a diagnosis, correct? That's what the manual says.
Right, and this manual
Okay.
also says that this is a screening instrument, so when you do the clinical interviewing, you absolutely can determine diagnosis
So the
after
answer is
somebody
yes. The manual says you
still
the
need to use
PCL-5
clinical interviewing skills, which I used.
Let me finish my question. The PCL-5 should not be used as a standalone diagnostic tool, and they recommend using the CAPS-5 to determine a diagnosis, correct?
It does say that, yes.
Yeah, and you made your diagnosis before you did the CAPS-5.
I made my diagnosis doing clinical interviewing and 11 other psychological tests that supported diagnosis of PTSD and symptomatology consistent with PTSD.
Okay. You said that we should read the manual. Would you also agree with me that we need to read the directions on these tests?
Sure.
Okay. Tom, can you pull up 1309 as a demonstrative?
Yes, sir. Thank you. Any objection of 1309 as a demonstrative?
May we approach?
Okay. Nine and publish the jury as demonstrative.
Doctor, do you recognize the demonstrative that's in front of you?
Yes, but I didn't put the red lines on that.
No, I did.
Yes, I know.
Okay. So this, what do you recognize this as?
I recognize that we previously discussed this, and I told you that I oriented Ms. Hurd to a different time frame because she was already out of the relationship.
Okay, maybe we should back it up a little. This is the CTS-2 that you administered as part of this battery of tests that you indicate you did in relationship to your diagnosis.
Right, this is the conflict tactic scale too.
All right. And you'll agree with me that this test specifically asks, in front of every single question, How often did this happen in the past year?
Correct, and I
Right.
oriented
And
the
you know-
individual to not limit
it's
herself to the
correct.
last year to get an accurate assessment of the violence and abuse that she experienced in the relationship.
Objection, Your Honor, move to strike.
All right. I'll move strike the last part of the answer. Strike the last part of the answer. Thank you. Next question.
Yeah, and you know that at the time that you gave this test to Ms. Heard, she had been away from Mr. Depp for far longer than a year, correct?
Which is why I oriented her to a different
Yes or no,
time
ma'am?
frame in answering the questions.
Doctor, yes or no?
So, of course,
Okay, you knew she was gone for more than a year.
of course.
All right, let's look at another one of these. You talked about the danger, I'm sorry. You talked about the danger assessment test.
That's correct.
All right.
What number is this? 13, plaintiff's 1310.
Thank you.
Any objection to 1310 as a
No, Your Honor.
demonstrative? Okay. You publish to the jury.
Dr. Hughes, this is a blank form, but this is the danger assessment test that you also gave to Ms. Heard, correct?
I didn't give it to her. I filled it out based on the data that was provided to me.
Oh, so you asked her the questions and then you filled it in.
It was somewhat collaborative.
Okay. Can we blow up the second full paragraph? It says, using the calendar, please mark the approximate dates during the past year when you were abused by your partner or ex-partner. You didn't use any calendar, did you?
I did not use a calendar because she was already out of the relationship. As I said, these are static risk factors, so they don't change. So I
But these
orient her to the
exams-
time of the relationship.
Ma'am, it's fair to say that this examination that you gave specifically indicates that you were supposed to look over the past year. And
That's
not the
one,
language?
no, that's one administration. People use this instrument for if you're in an acute situation in a relationship, trying to get a better assessment of the current behaviors. We can use it retrospectively, like I just stated, and in homicides and looking back about what are the serious risk factors that were in this relationship.
I didn't ask you about anything other than, don't the instructions limit this test to the previous year?
You can give this test not only on the previous
Nope, asking
year,
you about the instructions.
but I'm telling you how the test is administered in clinical practice and in forensic practice.
And opposing counsel can come up and ask questions about it. I'm asking you about the instructions. And the instructions say, look over the past year.
Yeah, on this, yes, that it says that.
And you had actual knowledge when you gave the test that Mr. Depp was gone way more than a year before this test.
That is correct.
Right. All right. Let's look at more instructions. Can we look at 1247, which is already in evidence? Dr. Hughes, you recognize this one too, right?
Yes,
All right. This is what everybody calls the CAPS 5.
correct.
All right. Can we go to the first page? Let's blow up the instructions. Standard administration and scoring of the CAPS 5 are essential for producing reliable and valid scores and diagnostic decisions. Correct?
Correct.
And you know you have to do this in a standardized way because it is the first instruction, correct?
Correct.
Can we go to the next page? One more. Oh, wait, that's good. This is a page on scoring, and we talked about this last time.
Yes,
You score these tests by frequency, and intensity.
Correct.
And you'll remember that in every single instance that you were asked to fill in the blank about frequency, you failed to do so, correct?
That's not correct.
Oh, you filled in any blank on this form with respect to frequency?
I filled in the frequency on the side of the caps where I am actually scoring the caps.
No, I asked
Where it's
you whether
relevant.
you filled in a single blank on this form with respect to frequency. Is the answer to that yes or no?
I don't know what you mean, a single blank.
All right, let's keep going. All right, we'll stay at this page for a second. This is the very first box you're asked to fill in as to, I think, a fairly fundamental question, right? What happened?
We talked about this before, Mr. Dennison. I had 88 pages of notes of what happened. It would have been redundant to put it there.
You know that you are obligated to produce this test in a way that other people can meaningfully review them. Yes?
The people in this case who are meaningfully reviewing them have my 88 pages of notes.
Right. But you chose to put absolutely nothing in the box, the standardized box that said what happened.
You don't have to put it in the box if you have it somewhere else. It's not
Because this is not a standardized test?
Well, if it's not a research instrument that is used for research, if you're using it for a clinical diagnostic purpose, no, you don't. If you have that data elsewhere.
Okay. Let's go another page or so. All right. Let's go another one. All right. Let's look at item 4B4. And I asked you filled in the blank about frequency. And there's a blank in many of these items that asks number of times. You didn't fill a single one of them in, did you?
Right, because I filled them on the right side of the instrument where I am scoring it.
And that is the way that you believe that you followed the instructions of a standardized test.
Yes, correct.
No further questions.
All right, redirect.
Very briefly.
You used the term
Static risk factor. What did you mean by that?
Static risk factors are risk factors that don't change. It's maybe if you smoke cigarettes, you may have a risk of lung cancer, right? That's a factor that doesn't change. You can look forward if someone's smoking, you can look past if someone's smoking. So these lethality risk factors are present whether you're evaluating them in the last year or 5 years ago.
And when you're trying to assess for trauma related to the interpersonal violence that we discussed, why is it important to get a time frame in which the relationship was in existence?
Well, you want to see the amount of trauma that the person experienced. The longer that they're in a relationship, you have more successive trauma. And one of the things that we know from the research is more trauma is not better. So the more successive traumas that you have, the greater likelihood that somebody's going to have psychological consequences and symptomatology as a result.
And therefore you need to get it within the relationship.
Objection leading.
And so how does that relate to needing to get the time frame in the relationship?
Well, you need to understand when you're trying to evaluate the impact of something, you have to understand what happened to the person. And that's sort of the core and the basis of trauma-informed care and of trauma diagnoses. You have to understand, the traumatic event and how it transpired and how it played out for that individual so that you can better assess for the symptomatology that's falling from it.
You said you had 88 pages of notes. What were in your 88? And without going into the specifics, can you just describe what was included in the 88 pages of notes?
In the 88 pages were many of the documented incidents of intimate partner
Objection, Your
violence.
Honor.
She's just describing it. That came up. He said you didn't fill those in the boxes. She said it was in my 88 pages. I'm just saying what was in your 88 pages. I'm not asking her to give each of the specific events. She can describe the summary of it.
Can we come up?
Okay.
What is the difference between clinical scoring and clinical evaluation and research evaluation with respect to the CAPS-5 and the other tests?
When
It's in compound.
Sustained.
Your Honor, when it's compounded, it's because it might be confusing to the jury.
Sustained. Next question.
Okay. Can you explain to the jury what the difference is between clinical scoring and evaluation on a test and research?
Objection, Your Honor, compound.
Overruled. Good.
Sure. So the PCL and the CAPS-5 are frequently used in research. And when they're used in research, that means the document stands alone. They don't have 88 pages of notes to help understand the background of the trauma and what the person has experienced. And why those boxes may be relevant in research is because, you know, back in the day when I was a research assistant, I had to input that into the computer. And then they would maybe look at some of that data for the research study. So that becomes very important in research.
All right. Thank you. I have no further questions.
All right. Thank you, Dr. Hughes. You can have a
Thank
seat in
you.
the courtroom or you're free to go. Okay.
Thank you very much.
All right, ladies and gentlemen, let's go ahead and take our afternoon recess. Our morning recess. Let's take our 15-minute recess. Do not discuss the case with anybody and don't do any outside research, okay? All right, why don't we just come back at 11:05 then? All right, excellent.
Please be seated.
All right, are we ready for the jury? Yes, yes, sure. All right, thank you, ladies and gentlemen. You may be seated. All right, your next witness.
Your Honor, defendant calls Amber Heard.
All right, Ms. Heard, if you come to the stand, please. Yes, ma'am. Water. All right. Thank you, ma'am. And just a reminder, you're still under oath, okay?
Of course, Your Honor.
Thank you.
Thank you.
All right, your question?
Amber, just to orient you and the jury, at this time, we are in the rebuttal to your counterclaim against Mr. Depp. So I'm going to confine my questions to that, okay?
All right.
How have you suffered publicly as a result of the Depp Waldman statements?
Objection, speculation.
Overruled.
I am harassed, humiliated, threatened every single day. Even just walking into this courtroom, sitting here in front of the world, having the worst parts of my life, things I've lived through, used to humiliate me. People want to kill me, and they tell me so every day. People want to put my baby in the microwave, and they tell me that. Johnny threatened, promised me that if I ever left him, he'd make me think of him every single day that I lived.
Objection, Your Honor, non-responsive.
All right. I'll sustain the objection as to that. If you want to ask the question.
Amber, how did Mr. Depp's statements and threats to you that you were discussing, how do those continue to manifest themselves today?
In the harassment and the humiliation, the campaign against me that's echoed every single day on social media and now in front of cameras in this room. Every single day I have to relive the trauma. My hands shake. I wake up screaming. I have to live with the trauma and the damage done to me. My friends have to live with a set of unspoken rules about how to not scare me.
Objection, hearsay.
Yes, sir.
Unspoken rules
Overruled. Go ahead.
about how to not touch me, not to surprise me. My intimate partners have rules about how they can deal with me, how they can touch me. I have rules for doctors and medical professionals I see, gynecologists I see. I live my life with these sets of rules that I have to follow, my friends have to follow for me not to have a panic attack or a triggering event where I relive the trauma. Even if I'm training to do my movie, for instance, if I'm training for Aquaman, a combat scene and a trigger happens, I have a meltdown and have to deal with that. The crew I work with have to deal with that because of the damage I walk around with every single day from what I've lived through, from what I've survived. I'm not sitting in this courtroom snickering. I'm not sitting in this courtroom laughing, smiling, and making snide jokes. I'm not. This is horrible. This is painful. And this is humiliating for any human being to go through. And perhaps it's easy to forget that, but I'm a human being. And even though Johnny promised that I deserve this and promised he'd do this, I don't deserve this. I want to move on. The statements, the attacks on me, the campaign, that Johnny has elicited millions of people to do on his behalf when he himself
Objection, Your Honor,
couldn't do
lack
it.
of foundation.
Torture me every day.
Speculation.
I'll sustain the objection. Next question.
Amber, how have the Depp Waldman statements impacted your ability to do charitable work?
You know, the only reason that people like Dr. Curry can sit up here on the stand and say I'm high functioning and I do things like have hobbies and have interests is
Objection,
because I'm not.
non-responsive.
Your Honor, Mr. Depp gave long-winded responses yesterday.
Overruled. Good.
It's because I found a solution to that pain. I woke up every morning with panic attacks and trauma until I realized I could do something with it. So to answer your question, Ben, I was able to turn the things that I've lived through, my pain, my life experiences into work, into action, into providing a voice for other people. I'm not a saint. I'm not trying to present myself as one, as you all know, but I selfishly found relief in being able to use what I've lived through to advocate for others, to bring light to these issues, to give a voice to people who don't have the voice and the platform that I have. And while I would not wish this situation on my worst enemy, if it gives a voice to someone who doesn't have it, but I now, as I stand here today, can't have a career. I can't even have people associate with me because of the threats and the attacks that they have to endure.
Objection,
where they are.
non-responsive.
And I can't do my charity work.
Sustain the objection.
Amber, other than the threats that you've described, what other threats have you endured since the Depp Waldman statements were made?
I receive hundreds of death threats regularly, if not daily. Thousands since this trial has started, people mocking my testimony about being assaulted, making fun of my...
Objection, relevance, non-responsive.
Goes to damages. You can continue.
It's been agonizing, painful, and the most humiliating thing I've ever had to go through. I hope no one ever has to go through something like this. I just want Johnny to leave me alone. I just want him to leave me alone. I've said that for years now, and I thought he would after 2020.
Objection, non-responsive.
All right, I'll sustain the objection. Next question.
What do you hope to reclaim after this is over?
Protecting the secret that I did for as long as I did has taken enough of my voice. Johnny has taken enough of my voice. I have the right to tell my story. I have the right to say what happened to me. I have the right to my voice and my name. He took it long enough. I have a right as an American to talk about what happened to me, to own my story and my truth. I have that right. I hope to get my voice back. It's all I want. And I've said that from day one.
Thank you, Amber. I don't have anything else.
All right, cross-examination.
Actually, Your Honor, may we approach very
Yes,
briefly?
yes. Yeah.
Ms. Heard, you just testified that this case has been very hard for you. So let's talk about that and why.
All right.
Your lies have been exposed to the world multiple times, right?
I haven't lied about anything I've been here to say.
You sat here and told this jury that the events in Hicksville started with Mr. Depp getting really upset about a woman leaning on you. Is that correct?
Yes, that's effectively what happened, yeah.
You testified that he actually grabbed that woman's wrist and twisted it, right?
And told her that he could effectively break her wrist by saying he knew how many pounds of pressure, or asking her how many pounds of pressure it took to break a human wrist.
But your own witness, your former best friend, Rocky Pennington, she didn't corroborate that, did she?
I'm not quite sure what part of that night she saw. There were a lot of people there.
She didn't testify that Mr. Depp grabbed anyone's wrist in Hicksville.
Again, I don't know what Rocky saw. There were a lot of people there that night.
You testified that once you brought Mr. Depp back to your trailer, he trashed it, correct?
That is correct.
And the manager of the Hicksville trailer park was furious that Johnny had wrecked the whole thing. Do you remember that testimony?
That's correct.
Well, we heard from that manager of the Hicksville trailer park, Morgan Knight, on Monday, didn't we?
I'm not quite sure who that guy was or if he had any involvement in this. I know a lot of people have come out of the woodwork to be involved.
So you're accusing Mr. Knight of testifying and committing perjury?
I'm not accusing anyone. I just don't recognize that man.
You heard Mr. Knight testify that it was actually you who was upset with Mr. Depp spending time away from him. Isn't that correct?
How would he know? He wasn't there.
You heard Mr. Knight testify that it was actually you who was yelling at Mr. Depp.
Again, I've heard a lot of people say a lot of things to be involved in the Johnny Depp show, but he wasn't there. He doesn't know. And he certainly doesn't know what happened behind closed doors, like most people.
So you're calling Mr. Knight a liar?
I am saying he wasn't there, and what he testified to doesn't match what I know happened. But I don't fault him. He wasn't there, so how would he know?
He testified he was there, Ms. Heard. Did you hear that?
That's his testimony, yes.
So you're calling him a liar?
I'm just saying he wasn't there.
You heard Mr. Knight testify that the trailer wasn't trashed, and that's why you're calling him a liar.
He testified that a light fixture was broken, similar to the way that
yes,
Johnny's
other than a light
employees
fixture, that was
testified
the
to
only
my
thing that was
closet
broken,
being
right? Ms.
rearranged
Heard?
and things
Ms.
like
Heard,
that.
the only thing that was broken in the trailer, according to Mr. Knight, was a light fixture. Yes or no?
I realized that he summed it up by saying a light fixture was broken, just the way his security guard summed up him trashing my closet as being rearranged.
Your Honor, I'm going to move to strike everything after he summed it up, that it was a light fixture, as non-responsive.
She answered the question, Your Honor.
Overruled.
In the security guard testimony, Your Honor?
I'll allow it. Go ahead.
Mr. Knight also testified that he charged Mr. Depp only $62 for the damaged light fixture. You heard that, correct?
I did.
In Hicksville, you were the only one that was jealous that Mr. Depp was spending time from other people. Isn't that correct, Ms. Heard?
That is incorrect.
In Hicksville, you were the one who was upset that Mr. Depp wasn't giving you enough attention.
Incorrect again.
Ms. Heard, you told this jury that you had no idea the press was going to be at the courthouse when you got your TRO on May 27th, 2016. Do you remember that testimony?
I said I did not have anything to do with it. Yes.
No. My question again. You told this jury that you had no idea that the press was going to be outside after you got the ex-party TRO on May 27th, 2016. Do you remember that testimony?
I apologize. I must have misunderstood Ms. Vasquez. I actually had no idea whether they were going to be there or not. When I walked into the courtroom that day, it was completely quiet, still, empty. Even though I had given Johnny's team notice that I was filing the
Objection.
TRO,
Your Honor, this is not
we had no
responsive.
reason to
Move to
believe the
strike.
press knew.
And Your Honor, I would also ask that you instruct the witness to please stop talking once I lodge an objection.
Your Honor, she's trying to answer the question as best she can, and Ms. Vasquez is misrepresenting to her what she testified to.
Well, I'll strike the last part as non-responsive.
Thank you.
Just if you could just answer the questions asked. Okay, thank you, Ms. Heard.
In fact, you testified that you were, quote, shocked when you saw press when you were leaving the courthouse. Yes?
Yes.
You weren't shocked at all, though, were you?
Incorrect. It was
You knew the press
horrifying.
would be at the courthouse, right, Ms. Heard?
No.
Well, you did bring your publicist to the courthouse with you on May 27th, 2016, didn't you?
I sure did. I'm a public figure. I brought my publicist in case it blew up. in case. And
You
I'm
actually
glad
had
I did.
alerted TMZ that you would be filing a TRO against Mr. Depp that very
No,
day,
I did
didn't
not.
you?
No, I did
The
not.
one day you didn't bother to wear makeup to cover up the mark on your face.
I did not call TMZ or any other news source or paparazzi source. No one.
Well,
I
we
never
heard
did that.
testimony from former TMZ employee Morgan Tremaine yesterday, correct?
Did I hear his testimony?
Yes.
Yes, I was here.
Yes. And you heard Mr. Tremaine's testimony that he knew to dispatch the paparazzi to the courthouse on May 27th, right?
I heard him say that he knew that, yes.
Yeah, and that he dispatched paparazzi to the courthouse to capture a picture of an alleged bruise on the right side of your face. Do you remember him saying that?
I remember him saying that.
That information must have come from your team, right, Ms. Heard?
Absolutely not. Why would I want that? What actual survivor of domestic violence wants that?
Now, the video of Mr. Depp beating up some kitchen cabinets, you admit that you took that video, correct?
Yes, I did.
And you acknowledge that the video was released online the day before you were deposed in connection with your divorce from Mr. Depp in August of 2016, right?
I believe it was, yes.
But you testified that you had absolutely nothing to do with the video's release, right?
Absolutely not.
And you testified that you learned about it when you landed after flying into LA. Do you remember that testimony?
Upon touchdown is when I was alerted to the video's
You
existence
heard Mr.
online.
Tremaine testify that about this video as well yesterday, didn't you?
Yes, I did.
And you heard Mr. Tremaine testify that TMZ received the cabinet video the same day you landed at LAX. Yes?
I don't know if that I don't know if that's what his testimony was. I'm sorry.
You heard Mr. Tremaine testify that the cabinet video was posted 15 minutes after TMZ received it. Yes?
That's what I heard him say.
And that this could only have been possible if the video was received directly from the source. Yes?
I heard him say that. I don't know if that's true or if that's possible because
you
it didn't
heard
come from me. I was
Mr.
flying.
Tremaine
So
testify.
I know that's incorrect is what I mean to say.
Another liar on the stand.
I just know that that's incorrect.
Right. And you heard Mr. Tremaine testify that TMZ owns the copyright to the cabinet video, right?
That's news to me.
The cabinet video you filmed of your then husband. Yes?
The copyright ownership of that is news to me. I learned that yesterday.
It's the cabinet video that you captured of your then husband. Yes?
That is correct. I did capture that video. And
The
yes,
cabinet
that was my
video-
husband.
The same cabinet video that was released the night before you were deposed in your divorce. Yes?
That's correct.
You must have also heard Mr. Tremaine testify that the version of the cabinet video that TMZ received was incomplete compared to the video the jury saw in this trial. Did you hear that?
The video that that you have seen is complete.
Right. But the one TMZ got the day before your deposition in the divorce was incomplete.
I don't know. I haven't seen it.
He testified that at the beginning portion of the video where you set up the camera, that wasn't included in the video that TMZ received.
I don't know what video TMZ
I'm talking
received.
about Mr. Tremaine's testimony, Ms. Heard. Let's just
You're
focus on
asking me to
Mr.
repeat
Tremaine.
his testimony?
No, I'm asking you if you recall hearing him say those words to this jury.
Yes,
Under oath.
I heard his testimony. We all did.
And he testified that the end of the video where you can be seen smirking. I know you testified earlier that you haven't been smirking in this trial, but you sure were caught on camera smirking in that video.
I disagree with that.
Was also not included in the TMZ video.
Everyone can watch that video and you can determine whether you think it's funny to me or not.
That's because the video came from you, right, Ms. Heard?
No, it did not.
You
That
edited
video
out
did
the
not
portions.
come to me. I
Ms.
mean, come
Heard,
from me.
Ms. Heard, you edited out the portions that made you look bad before sending it to TMZ.
You're very wrong about that.
So that
If I
only
wanted to
Mr.
leak
Depp
information, I
looked
could have
bad.
done it in a more effective way, a lot sooner and a lot more.
Because you
I
knew
was
exactly
living
how to
with
do
a
that,
mountain
right?
of this evidence. If I wanted to leak it, I could have done a lot more with it.
I thought you testified earlier in this trial that you didn't know how to leak things.
I
Remember
don't.
that? Right. You edited that video before you gave it to TMZ so that only Mr. Depp would look bad. Yes?
That's absurd.
Right in the middle of your divorce proceedings.
Again, you're very wrong.
I'd like to show you a picture from that's already admitted into evidence. It's Defendant's Exhibit 799. This is you at the courthouse on May 27th, 2016, when you got your domestic violence restraining order against Mr. Depp, right?
It is.
And next to you is a woman named Jody Gottlieb, right?
Yes, yes.
Jody Gottlieb is your publicist.
And dear friend.
Now I'd like to show you what's been marked as Plaintiff's Exhibit 1316. This is a picture of you and your friend Rocky Pennington, right?
That is correct.
Your Honor, I'd like to move to admit this photograph.
Any objection to 1316?
No, Your Honor.
All right, 1316 in evidence. You can publish to the jury.
This is a picture of you on May 28th, 2016, right, Ms. Heard?
I don't know when this was taken.
This is the day after you obtained the domestic violence restraining order against Mr. Depp, right?
I have no idea when this image was taken. I did not take it.
There's no bruise on your face in this picture, is there?
Again, I don't know when this was taken, and also I'm outside. I was obviously wearing makeup. I have no idea when this was taken, so I have no idea if I can speak to what bruise you can see or
Let's
not.
refresh your recollection about when this picture was taken. Can we please pull up Plaintiff's Exhibit 1315, just for the witness? This is an article dated May 30th, 2016, right, Ms. Heard?
That's what it says, yes.
And this article contains the same photograph of you and Ms. Pennington we were just looking at, yes?
Yes, I see that. And
The article is entitled, Amber Heard Smiles as She Puts Arm Around Friend One Day After Getting Restraining Order Against Johnny Depp. Is that what the title says?
I know that's what the title says, yes.
Your Honor, I'm going to move to admit and publish the article with everything but the headline and date and the photo redacted.
Objection, Your Honor. That's inconsistent from the way you've treated all of these.
I'll sustain the objection. All right, next question.
Let's take a look at picture Plaintiff's Exhibit 1317. This is also a picture of you and Ms. Pennington on May 28th, 2016, isn't it?
I don't know when this photo was taken, but it looks like the same outing as the picture prior.
Your Honor, I'm going to move to admit and publish Plaintiff's Exhibit 1317.
Any objection?
No, Your
All
Honor.
right, 1317 in evidence. You can publish.
There's no bruise on your face in this picture either, right?
I disagree. If it is taken when you represent it was taken, then obviously there's a bruise on my face. It's covered by makeup as per usual.
Let's zoom out of that picture for a moment, please. Thanks, Tom. That's Josh Drew in this picture, right?
Yes, that's correct.
And Ms. Pennington
That is correct.
in there too?
That
Ms.
is correct.
Pennington submitted a sworn statement on your behalf in support of your domestic violence restraining order, didn't she?
I believe she did, yes.
Mr. Drew also submitted a statement in support of your domestic violence restraining order.
I believe they both did, yes. Mhm.
Ms. Heard, I'd like to show you Defendant's Exhibit 512, which is already in evidence. You've seen this photograph before, right?
I have.
On the second day of your direct testimony, you testified that this was taken in the downstairs of the main apartment on December 15th, 2015. Do you recall that testimony?
Yes, I believe so.
So it's your testimony that Defendant's Exhibit 512 reflects damage to Penthouse 5 that occurred during the December 15th, 2015 incident. Yes?
I'm not quite sure from what incident this is when I see this photo in a vacuum without context.
Let's give you that context. Can we please, thanks. If I could have day 16 trial testimony. Your Honor, may we approach?
All right.
Could you please turn first to page 4585?
Sorry, one second.
Specifically starting on line 16, where it says, let's talk about December 15th, 2015.
You said 4585. I'm on 4485. Sorry, you said 4585.
4585.
Pardon.
line 16. Line 16, where it says, let's talk about December 15th, 2015. You see that?
Yes.
And then do you see that your testimony about December 15th, 2015 follows?
Let's see. It's just the first line or two. Yes.
Okay. Now I'd like you to turn to page 4603. Starting at line 12. 4603. Starting at line 12 and going on to page 4604, line 4.
Okay.
And do you see that you testify that defendant's exhibit 512, which is on the screen,
Yes,
is a picture of the downstairs of the main apartment?
that's correct.
And the main apartment is penthouse 5 in the Eastern Columbia building, right?
No, depends on what, the main apartment's penthouse 3 generally when we say main apartment.
Penthouse 5 was where you had your closet?
The downstairs was kind of like had some of my painting studio set up and a reception area. Upstairs was the closet.
Got it.
Mezzanine office was in between.
All right, so it's your testimony that defendant's exhibit 512 reflects damage to the penthouse 5, that occurred during the December 15th, 2015 incident, right?
I'm just not sure from which incident this is a picture of, since I'm only looking at
Even
a
though your
partial
counsel
floor.
was asking you questions about December 15th, 2015, and then admitted this picture into evidence
Again,
in relation to that incident.
Sorry, go ahead.
In relation to that incident on December 15th, 2015. This exhibit, defendant's exhibit, you are the defendant, number 512, was admitted into evidence in this court. You testified that this was the result of damage that occurred on December 15th, 2015. Yes or no?
I just need to orient myself because I'm just looking at a picture of a partial picture of a
Ms. Hurd,
floor,
you didn't just
so
look
I
at a
can't.
picture. You looked at your testimony.
You pointed me towards the page and then asked me a question. I haven't actually reviewed it. I don't know if this was submitted in relation to that incident.
Let's actually leave up defendant's 512 and please pull up defendant's exhibit 725, which is already in evidence
Thank you.
in redacted form, Your Honor.
All right, thank you. You can publish.
Just side by side. You've seen this photograph as well, right?
I have.
On the third day of your direct testimony, you testified that this photograph reflected spilled wine in Penthouse 5 on May 21st, 2016, didn't you?
Again, I don't know because I'm looking at a partial picture of a floor. So unless you remove the metadata you've covered up, we could then tell. If you
I didn't cover it up, Your Honor.
Could we unredact
Your Honor
them
did.
so we could get context?
That's how it's in evidence.
That's how
All
it's in
right.
evidence.
Next question.
Well, the metadata next to it is so that
Ms.
to
Hurd,
avoid this
Ms.
sort of
Hurd,
confusion.
there is no question pending, and I would appreciate it if you wouldn't be making argument to the jury.
Sorry, I
It's
thought you had
inappropriate.
asked me about it.
No, I didn't ask you about anything. Let's look at your direct testimony from the third day. May I approach?
Yes, ma'am. Thank you.
Thank you.
Let's turn to page 4750 in day 17 transcript.
Sorry, can you repeat that?
4750. Specifically line 16. Do you see where Ms. Bredehoff asked you to describe for the jury what took place on May 21st, 2016?
I see that.
And do you see that your testimony is reflected about May 21, 2015?
Yes.
That follows? Okay.
Yes.
Now let's turn to page 4804 at line 14. 4804. Starting at line 14
Yes.
through 4805, line 4.
Going to what line?
Line 4 at 4805. Do you see that you're testifying that defendant's exhibit 725, which is reflected on the right side, reflects spilled wine on the floor in penthouse 5?
That's correct.
Okay. And defendant's exhibit 512 and 725 seem to be different versions of the same picture, don't they?
That's correct.
Okay. So which is it? Which one was taken on December 15th, 2015, or May 21st, 2016?
If you remove the redacted metadata, you can find out. It's right there.
Or if you're telling the truth, you would know.
Recognize a portion of of spilled wine on a floor, and I'm supposed to know off the top of my head when you've
No.
lived through 5 years of this stuff? I don't think so. That's not how that works.
Okay. Thank you, Tom. Ms. Hurd, at the beginning of your cross-examination
Your
last
Honor, may we
week,
approach?
Yes.
All right, ladies and gentlemen in the gallery, I would ask that there be no words or no phrases, no words, no sounds at all coming from you. If I hear one more sound, I will clear the gallery and we will continue this testimony without anybody in the courtroom. Understood? Good. All right, your next question.
Ms. Hurd, at the beginning of your cross-examination last week, I showed you an audio where you told Mr. Depp to tell the jury, tell the judge, tell the world that he is a victim of domestic abuse. Do you remember that?
That's correct.
And you testified you found it hard to believe that Mr. Depp would tell the world that he's a victim of domestic abuse, didn't you?
I said I find it hard to believe that he would do that knowing that he himself had beat me up for 5 years.
But he has told the world that he's your victim of domestic abuse, hasn't he?
Well, he started to say that only recently. He didn't make that claim up until very recently. So when we signed our divorce agreement and we signed a statement saying that neither party had ever said false claims for financial gain, it was relevant and important to me because I was the only one making the accusations. I was the only one making those claims. He wasn't doing that at the time, and he signed his name to it.
You didn't expect as many people to show up and testify on his behalf that did you?
Incorrect.
When you told this jury under oath that you never assaulted, actually, strike that. When you told this jury under oath that you punched Mr. Depp because you thought of Mr. Depp pushing Kate Moss down the stairs, you didn't expect Ms. Moss to agree to testify that never happened, did you?
Incorrect. I know how many people will come out of the woodwork to be in support of Johnny.
So
It
you
is
think
clear
Ms.
by this
Moss
courtroom
needs
how
to
many
come
people
out
will
of the
do that.
woodwork to testify for Mr. Depp?
Everybody who was around in the 90s and the early aughts knew that rumor. I had heard that rumor from multiple people. Of course, that's what flashed through my head when my violent husband not only swung for me, but all of a sudden swung for my sister. Of course, I thought of that. I did not expect her to show up or not expect her to show up. It didn't matter. It doesn't change what I believed at the time when we were on the stairs and I thought he was going to kill my sister by pushing her down the stairs.
You told this jury under oath that Mr. Depp was aggressive and trashed a trailer in Hicksville. You didn't expect the manager of the Hicksville property, Morgan Knight, to come forward and testify that that was untrue, did you?
Incorrect. I've already been through trials with this man. I know how many people will come out in support of him.
When you told this jury under oath that you had no idea that the paparazzi would be at the courthouse on May 27th, 2016, you didn't expect a TMZ employee to show up to testify that TMZ had been alerted that you would be at the courthouse and knew exactly which side of your face to take a picture of, did you?
I know how many people will come out and say whatever for him. That's his power. That's why I wrote the op-ed. I was speaking to that phenomenon. How many people will come out in support of him and will fall to his power? He is a very powerful man, and people love currying favor with powerful men.
Currying
And I know
favor
that
and
firsthand. I've
risking
lived
jail
it.
time for committing perjury?
Excuse me? I didn't hear your question.
You didn't hear
Excuse
my
me?
question?
Ms. Vasquez, if you do mind,
Curry-
please just repeat the question. I didn't hear you.
Curry favor and commit perjury in this courtroom
I have
for
seen
a
people
powerful
do this.
man?
I have seen people do this time and time again. That's why I wrote the op-ed.
You didn't expect Ben King, the house manager in Australia, to show up from England. He flew from England to testify that Mr. Depp's fingertip was found exactly where he said it would be. Did you?
I have never heard Johnny testify to knowing where his finger was, or really, frankly, making a claim that he knew where it was when it was found. I've never heard Johnny claim that.
You didn't expect
Johnny
Keenan
doesn't-
Wyatt.
Johnny has never
Ms.
actually
Heard.
said that.
Ms. Heard.
And
I think the
Ben
jury
King,
can,
yes.
Ms. Heard, there's no question pending. You didn't expect Keenan Wyatt, Mr. Depp's longtime sound technician, to show up and testify that Mr. Depp is not being fed lines through his earpieces, but instead music, did you?
Not that it matters much, but of course I did. I know how his employees treat him.
So you
I know how
probably-
his team treats him. Of course I expected that.
Okay, so you probably expected Isaac Baruch to come and testify for Mr. Depp, right?
I'm not sure I thought about that.
Yeah, but you didn't expect Mr. Baruch to weep for Mr. Depp after what you've put him through and so many others with your lies.
I
did you?
relate to Isaac because he and I are
There's
the
no
only
further
ones who
questions, Your
cried
Honor.
on this stand.
Nothing further.
All right, redirect.
Thank you, Your Honor. Ms. Heard, if Mr. Baruch felt misled, who misled him?
Johnny, and I don't blame him. I don't blame him from crying. This is horrible.
Ms. Vasquez has suggested that you faked bruises on your face. Is that true?
Absolutely not. I didn't need to.
Did you ever fake an injury caused by Mr. Depp?
No.
Is any of the evidence of your injuries that has been put to the jury in this trial fake?
No, absolutely not.
And to the extent that there may be some confusion over when a picture of spilled wine was taken, why might that be?
Objection,
Because there's so
lack of
many-
foundation.
Overruled.
Because there's so many incidents of violence. There's so many pictures. There's so much evidence. Most people don't have this kind of evidence for years, 5 years. And when I was saying that to Johnny on the phone in that recording, I was saying for years, this has been going on. And I have pictures, we have texts, we have everything. Normally you don't get this amount of evidence. That's what I was pointing out to Johnny. It would be crazy to try to challenge this in this way. It's crazy. It's easy to not know the context of a picture of spilled wine because there are so many more important details, pictures, and also so much I didn't photograph, so much I didn't have the presence.
Objection,
of mind to
non-responsive.
document.
All right, I'll sustain the objection. Next question.
Did Mr. Depp abuse you physically?
Yes,
Verbally?
yes,
Emotionally?
yes,
Psychologically?
yes.
How did the threats that Mr. Depp made against you individually years ago resemble what you've endured as a result of the Depp-Waldman statements?
Beyond the scope of cross, Your Honor.
Overruled.
Johnny promised me he would ruin me, that he'd ruin my career, he'd take my life from me. Death was the only way out. And if I got out, this is what he'd do to me. He'd make me think of him every single day. He promised me global humiliation. You saw those texts. What he couldn't do, the work of one individual, meaning Johnny, when he was inviting a disgruntled employee over for a spot of purple to fix my flabby ass up. That revenge that he sought back then was just what he could do as an individual, calling the studio to get me fired, trying to block him.
Objection, Your Honor, lack of foundation, speculation, hearsay,
all in
non-responsive.
I'll sustain as to non-response.
Ms. Hurd, how did those things that you just testified to that Mr. Depp did, how did those resemble what happened to you after the Depp-Waldman counterclaim statements were made?
Those are
Objection, Your Honor, lack of foundation.
She's
overruled.
Thank you. Thank you, Your Honor.
Those are just an echo of what I'm living through today. It's like what I'm living in right now. What you see in this courtroom is an echo. This courtroom and the other courtroom he dragged me into to do the same thing again. That's just an echo of the violence and the abuse that I suffered within our relationship. The campaigns to have me fired, the blocking me to try to ruin my career, the threats he's made to humiliate me globally are being lived out in real time in front of you, ladies and gentlemen, for the past 6 weeks and for the whole world since our camera's here.
No further questions. Thank you so much, Amber.
All right, Ms. Hurd, you can have a seat next to your attorneys. If I could have the attorneys approach. Witness?
Your Honor, the counterclaimant Amber Heard rests.
All right, thank you, ma'am. All right, ladies and gentlemen, you have heard all the evidence in this matter. What I propose doing is to go ahead and give you the rest of the afternoon off so you can have a good restful afternoon and evening, and we will do closing arguments tomorrow morning at 9 a.m. and then the case will be submitted to you for deliberations. Just to give you a little logistics of how that will go. Tomorrow, I won't give you a time limit as far as how long you can deliberate in the afternoon into the evening. I will tell you, within reason, I will tell you I do not serve dinner, so keep that in mind, okay? You will not be deliberating on Saturday or Sunday or Monday, because Monday is a holiday. I would like you to have you back here Tuesday morning, at least by 9 o'clock. If you want to come earlier, that's up to you. You can decide as a group if you want to come earlier than 9 o'clock, but you have to be here at least by 9 o'clock to resume your deliberations again. And again on Tuesday night, and if you have to go to Wednesday or Thursday, that the time that when you take your breaks is up to you, as long as you take them together, as far as not having any deliberations unless all of the jurors are in the room at the same time. When you take your lunch is up to you. And then again in the evening, within reason, I'll let you go as long as you'd like to go, okay? So have a good evening and we'll see you tomorrow morning, okay? Do not discuss the case with anybody, don't do any outside research.
Y'all, what? If I'd known this, I would have stayed up this morning and then taken a nap right now. What the hell? Good Lord. I swear.
All right. We'll go ahead and take a modified lunch recess just till 12:50. We'll come back at 12:50. We just have a few jury instructions left we have to do. Make sure we get the verdict form taken care of. I want you to review the laptop that we have mocked up and make sure everybody agrees what's on it. And also I want you to look through all your exhibits and make sure we're all on the same page. Before you leave, I'll make sure you have copies of the jury instructions in the order that I'm going to read them, and you should be able to prepare for your closing arguments for tomorrow, okay? All right, we'll see you at 12:50 then.
All rise.
Wait, I've been dead to the world. Are they showing are they going to talk about jury instructions on the camera, or is this stream about to end? Somebody fill me in. She sent the jury home, but I'm wondering if Law and Crime is going to stick around in the courtroom today and film them discussing jury instructions, or if they're going to call it a day and go home. Because personally, I would like to hear what they have to say about jury instructions. Oh, we're taking a vote. I'm pissed. I missed everything. Go to freaking Duggar sentencing, and per usual, they ruined fucking everything. I missed all the good shit. I'm pissed. I told y'all, did I not tell y'all 2 days ago? The second I get off, all the good shit's gonna happen. The second I got off 2 days ago, all the good stuff happened. And yesterday, apparently, it was a free-for-all. So, I mean, I've had FOMO for a legit reason. From yesterday, TMZ guy from yesterday. I mean, clearly I need to wake up, brew this coffee, and then we can rewatch and have whatever shithead sidebar we need to have. But I am pissed that I missed yesterday. I know. I heard everything that happened and I was like, really? Really? I mean, I knew it. I knew that's how it was going to be because that's always how it is. But I was like, the damn Duggars ruining everything per usual. But if I knew they were going to do a break, I would have just stayed up this morning and napped later. Damn, y'all. I'm pissed. Depp got back up there. Amber got up there. TMZ guy apparently was good. Kate Moss. Meanwhile, over at Duggar, closing will be Johnny Depp, Amber Heard, back to Johnny Depp. Well, it's weird because Also, I just woke up, so bear with me. But normally it would be prosecution, defense, back to prosecution because the prosecution put on the case so they get the last word. This is a counterclaim, so it makes it a little bit more complicated. But it should be 2 and 2, I think. Y'all are asking questions that I don't know because I didn't see what went down yesterday. Oh, yeah. If we rewatch, we will not be losing brain cells that are not needed to spare. Okay, so this is how it would typically be with closing. Johnny Depp, Amber Heard, Johnny Depp, because he put on the case, so he would get the last word. But if her counterclaim's been accepted, then she would also put on her counterclaim. So does she not put on closing? Or she does not? She doesn't get to, like, that's what's confusing to me. She's got her counterclaim. I agree. I agree. Yeah, let me get some coffee and whatnot and wake up. And then we can hash this out. I'm going to leave this up because I want to know if they're going to come back and show all the good stuff. I do want to hear what they want in and out for jury instructions and how they'll be, because I think that's telling. So let me brew some coffee and I'll BRB.
Now, I will stop at nothing. Let's see if Mollusk has a pair. Come see me face to face. I'll show him things he's never seen before, like the other side of his when I slice it off. Did I read that right?
You did.
And that certainly did not look good for Johnny Depp there. So let's bring back our guest to discuss this. Catherine, how does this text make Johnny Depp look in the grand scheme of this case?
When he was being questioned by Mr. Rottenborg regarding that, it does look at first glance to be very detrimental for her because of the language and the obscenity in it. But then he was redirected by his counsel, and he explained what that was, which made perfect sense. In that he said that he wrote that text because he was so angry. And anyone in his position could probably relate to what he's saying, that sometimes I presume all of us have written a text in a very angry demeanor, and it comes off like that. So I think it's understandable after he explained what that is.
Matt, could this text fuel Johnny Depp's motive to be involved in the defamatory statements Amber Heard is suing for in her counterclaim?
Well, I think it can. It can relate to that. But what I think this text does is that it exposes sort of the real Johnny Depp. I mean, we've observed Johnny Depp on the witness stand in this case talking, crack jokes. And I think, that's kind of what the jurors see of him on a daily basis. But in actuality, this is a glimpse into what Johnny Depp is like when he's sitting in his living room with a phone in his hand and jotting off, some text. And I think what it also does is today's testimony by Amber Heard, the jurors can look back at that text and say, well, yeah, we see a pattern here of trying to, attack Amber Heard at every level, even after their relationship has long ended. So I think when you juxtapose that text with what we heard from Amber Heard today, it doesn't have a good look for Johnny Depp.
Okay, so now let's listen to Depp's team trying to clear this text message up on redirect.
Mr. Rottenborn referenced that you were on the stand for multiple days.
4.5, I believe, yes.
Yeah. What was the nature of that examination? Or excuse me, who was conducting that examination of you?
QC Sasha Was.
And whose attorney was that?
The Son's.
Can we please pull up DX 857A?
All right, it's already in evidence.
Mr. Depp, do you recall seeing this text message when Mr. Rottenborn was questioning you?
Oh, yes, I do.
Can you explain what you're conveying to Mr. Carino in this text message?
I'm in total shock that this is happening to me, that my entire life on the planet has been brought to the head of a pin with all this completely, utterly false information. So I am, when you're accused of horrific acts and things that you have not done, when it's actually some very ugly things that are going out there into the world about you on a nonstop basis by Ms. Heard and her team, you have a tendency as humans to get very, very irate and angry, not to the point where you go out and hurt someone, not to the point even where you assault a cabinet. But you do get irate. You do wonder why this person is doing this to me. So many things go through your head. And then you've got your family, you've got your kids, you've got your parent. My mom, thankfully, didn't get to read any of this because that would have killed her. But my father, my family, everyone that I've met, the people that have supported me, suddenly I'm
scum. Why? Never had to happen. One little lie. So yes, very angry.
All right, so you just heard what Johnny Depp had to say about that text. And when you see something in the courtroom like that and you read it, it really is hard to unsee it, though. So, Catherine, with that being said, do you think the jury will disregard the text on the basis that Depp was just expressing himself?
As I mentioned earlier, I think they would likely do that. And let me back up and say that I agree with my colleague Matthew that something like this is indicative of how probably Johnny Depp presented himself. So we get a view of that. But at the same time, when Johnny Depp explained it in the way he did and the manner he did during that redirect, it sounded very authentic and very clear as to why he sent that text. I think all of us have had an instance in our life where we are very angry and we sent an angry text explaining our anger. I think that would come across as common sense, and the jury will just have to weigh whether or not what he's doing right now in the defamation case is indeed the global humiliation he's trying to threaten, according to Amber Heard.
And we've talked about this before. You know, a lot of legal analysts like yourselves have said that, you know, the first time Johnny Depp was on the stand, he seemed a little more genuine, a little more authentic, and he did a little bit better than he did the other day. Now, Matt, do you think Johnny Depp's team should have refrained from putting him on the stand in their rebuttal case?
Well, I mean, that's a tough decision. I mean, he did well when he testified in the past. He seemed to, win over the jurors with his humor and the other things that he talked about in the manner in which he presented himself. I don't think he did as well the second time around. And sometimes you don't want to take two bites of the apple. Be happy with where you are and what you got. Don't try to replicate it. But here again, I think the fundamental issue with regard to this text is that Johnny Depp was angry. Okay, he was angry. He was angry enough to send this profanity-laced text to someone because of the circumstances he was in. Now, should we believe that Johnny Depp never gets angry any other time? That Johnny Depp never got angry when he was physically in front of Amber Heard, and that instead of being able to text out a message, he could physically act out against him? I think that's the fundamental issue in this case. You know, Johnny Depp, we know, used a lot of drugs, a lot of alcohol, and we know he can get pretty darn angry. Could that result in the threat of abuse or physical abuse or sexual abuse of Amber Heard? I think the jurors have a lot to think about when they put together what Amber Heard has said and what the way that Johnny Depp has acted out in other circumstances.
Catherine, what do you think? Do you think that Johnny Depp's team should have refrained from having him on the stand again?
As Matthew mentioned, that's a tough call. I think it was good for them to bring in Johnny Depp back because he needed to rebut what Amber Heard testified to and a lot of the other witnesses. One thing that stood out for me when in that clip that we just showed, he said that, yes, I am angry. And it made me think because like you mentioned, and like most people watching his rebuttal testimony, he sounded to be less, he sounded to be more impatient. And then when he used the word angry, it clicked to me. He sounded angry at this time that he's in rebuttal. And if we put ourselves in his shoes, he's been listening to all of this for now, 6 weeks and hearing more and more of whatever testimony from Amber Heard's side and also from his side, from expert, from lay witnesses, that could make someone really angry. And so when he is there now for rebuttal, I think that anger showed and we can see the shift in his mood and said, I am really angry. now I'm really, really angry after hearing all of this. So I think that's the fundamental difference of his testimony before, during direct, and now in rebuttal.
All right, thank you for your perspective. You both, great analysis as always. We're going to have to take a quick break now here on Law and Crime, but don't go anywhere because on the other side, we'll be taking your questions as we have a live Q&A session with Law and Crime's very own Jesse Weber. So stay tuned. More from Fairfax, Virginia in a bit.
And welcome to a very special For the Record, everybody. I'm Jesse Weber. Thanks for joining us. We are live right now in Fairfax County, Virginia, outside of the Fairfax County Courthouse, where earlier today both sides officially rested in the Johnny Depp Amber Heard defamation trial. We're waiting for a lunch break to finish up. We're going to hear the attorneys speak with the judge about some administrative matters, possibly some motions. The jury has been excused. They'll come back tomorrow for closing arguments. But right now in this lunch break, this is the time when we take your questions. So if you're on YouTube, Twitch, Twitter, Facebook, you email us, any which way you can get our questions to us in this next half hour or so. We are going to answer your questions in real time. I'm back here with Catherine Lizardo, Matthew Mangino, and Jeanette Levy. We're going to take your questions right now. And Jeanette, I start with you. Something that you and I had talked about earlier. This is a question from Facebook. Felicia Horvath says, why do you think Johnny was asked questions about Amber's team about incoming text messages? Was that a trip him up? Was that a trip to trip him up, or was it a mistake on their part? The messages he denied ever saying, and I understand you also received a message about this on Twitter.
I did, Jesse, and I received this message actually late last night, and I didn't really have a chance to look at it closely. It was one of those things I just kind of glanced at it and thought I'll get to it in the morning, but I want to show you what one of our viewers sent to us, and this is our footage. They took it directly from our YouTube channel. So remember that whole line of questioning yesterday by Ben Rottenborn about these sexual texts talking about, Molly's, what, is rightfully mine. Should I not just bust in and remove its hinges? And I want to change her understanding of what it's like to be thrashed. And it was like, I need, I want, I take, all this stuff. Well, I want to show this to you. It's talking really derisively about women. Well, these texts were extracted from Johnny Depp's phone, right? This is an incoming text. Johnny Depp said that he didn't write it. He said he didn't write this text. He doesn't have enough hubris in him to write something like this and to think that any woman he wants is there for his taking. So it says direction incoming. So these are incoming text messages. The one Johnny Depp said he wrote yesterday, the one where he said that sent to Christian Carino and said that Amber Heard is begging for global humiliation, total global humiliation, highlighted, outgoing. He admitted to writing that text message. So we don't know if that was a mistake on Ben Rottenborn's part or a mistake or if it was intentional. We just don't know. I would love to ask Ben Rottenborn about that. But this clearly is an outgoing text that Johnny Depp said, yes, I wrote that. The ones about the really graphic sexual stuff, incoming, it's stamped. So it appears possibly that Johnny Depp did not write that.
It's a bit curious. I mean, people, our loyal trial watchers were actually catching that. A few of them caught it as well. Catherine Lizardo, a question that was emailed to me from Evanescence Fan. Do you actually believe that all of the jury members respected the honor system during the trial vacation? There was a week off, but also think about this. They're off now for the rest of the day. They're going to come back tomorrow. And even during the course of this whole case, do you think they're really not reading anything about this case? Do you think they're not talking to anybody about this case? This is the biggest trial that we've ever seen. I mean, what is that a realistic possibility?
I have faith in those jurors that they are following strictly what the judge mentioned. The reason is because if they got found out that they didn't, then they will be booted out as a juror here. And there are alternates to this, to the panel of jurors that we have. So I think every single juror right now are heavily invested, having listened to this for the past 6 weeks. And like you said, it's the biggest case so far that everyone is watching. So they would not want to not participate in the deliberations. So it behooves them to really follow that strictly, although it will be very difficult, especially during Memorial Day weekend, if they happen to have any parties or gathering with their family for the long weekend. So everyone just really needs to tell their family and friends to do not talk about this trial with right now.
Yeah, I hope the jury is never watching any of Law and Crime's footage. I hope they are not. I hope they're not seeing any of this. I hope they're not on the Q&A session right now and trying to get questions in. But Matthew, we have a question right now from one of our followers on Twitch, 3FM7DB3. If that is your username, I have no idea what your password is, but it's probably very well protected. The question is, Matthew, How does Amber Heard calling all of the other witnesses liars reflect on her own testimony on cross-examination? And does taking the stand again have any effect on her case, and how so?
I think it has an effect on her case. We talk in the law about primacy and recency. So she is the last voice that the jurors are going to hear from the witness stand. And I think that her testimony today was powerful. She stood her ground. She made it clear that this abuse, not only abuse 5 years ago, but ongoing abuse in terms of wanting to humiliate her worldwide and those types of things. She stayed on message. She was forceful. She certainly wasn't passive. I think she did herself a service by coming back and testifying today.
Catherine, we have a question from Facebook, Reem Wael. Can TMZ sue their former reporter? I believe they're talking about Morgan Tremaine. Can TMZ sue their former reporter who testified in court yesterday, or did he not divulge any information that be considered private?
Whether or not TMZ can sue him, TMZ can sue anytime, anyone can sue, but I do not think that they will do that here. One is because TMZ has just been put in this position where everyone was watching the motion that the judge denied for other legal reasons. And second, I do not think that reporter actually revealed his source. And the way they examined him was very strategic and very precise. They just wanted to point out to the jury that someone leaked the information about the TRO and the video of the cabinet to them, and the person who has the copyright actually gave them that ownership. And who owns that copyright other than the person who shot that video, and that would be Amber Heard. So I think they did that very well without revealing his source, because this journalist too, former employee of TMZ, would want to keep his integrity as well and not be sued or not be banned by other media as well for having a reputation of revealing sources. So I think they did that well, and he did that well as well.
Yeah, he had said on the stand that, he has nothing to gain from this. TMZ is quite litigious, so it's something to think about. So we have a question, Anjanette, from Soph on YouTube. So what happens with the rest of the hours that Johnny's team still has left? Does it not matter anymore? Because remember, there were time limits on the presentation of their case.
It doesn't matter. It's over. So they budgeted their time very wisely. Who knows what they would have needed on rebuttal? They had to do that. They had to bank some minutes and some hours. So I think they did a good job of doing that. I don't know what the final count was, how much time Amber Heard's team used, but they used up quite a bit of time, as we've discussed many times.
Well, Matthew, I have a question from one of our YouTubers, Pranav Gosalia. How much does the likability and believability of the witnesses affect the jury? What are your opinions about this regarding Johnny Depp's witnesses versus Amber Heard's witnesses?
Well, they have everything to do with the success of the case. The likability, although, we should be listening, or the juror should be listening, to this technical evidence and how it applies in this case, and not really, thinking about, well, this guy seems like a pretty decent guy who's talking right now, or this woman is really friendly and I like her. But that's the reality of it. I mean, that's the reality of jury trials. Jurors are looking at this from their own personal lenses as well. And whether they like somebody, it might tend to let them believe that person more than someone that maybe they didn't care for. So, as trial attorneys, we deal with these issues all the time. We might have a great case, but we have poor witnesses, and that has everything to do with success. And I think it will have an impact on this case as well. The other issue is the two parties in this case. Who was likable, who wasn't likable, who did you like more, who did you dislike? I mean, that's going to have a significant impact on the outcome of this case, and it always does.
Well, speaking of the outcome of the case, I had a question emailed to me by Sean Hilgenberg. And the question is, I'll throw this to you, Catherine. What happens if Johnny Depp wins? Will there be an appeal? Will it become a long, drawn-out verdict? Can Amber Heard afford the payments?
If Johnny Depp wins the legal case of defamation against Amber Heard, yes, Amber Heard can appeal. Whether or not she will do that, we'll wait and see. And whether or not she can afford that, that's a question too, because she has testified that Johnny Depp's current lawsuit has made it difficult for her financially, specifically also in terms of complying with her pledge to ACLU. And the fees and costs relating to an appeal is also very expensive. So tack that on to the fees and costs she's already incurring with this trial. That is going to be a huge amount for her to take on. So on appeal, that is definitely something to think about when you're thinking of appealing whatever the jury decides in this case.
So, and Jeanette, we have a question over to you. This is from, actually, I should tell you, the question for you was from OC Cali Girl 49 on Twitter, and it's about you being in the courtroom, but my understanding is that we couldn't get in the courtroom today because people were actually cutting the lines. The question was, how was the jury reacting during the cross-examination between Amber and Camille? I'm dying to know this, but I won't ask you that. I'll ask you this question from Starberry on YouTube. Can something be concluded from the way Heard behaved depending on the attorney's questioning? She was so vulnerable and emotional with Rottenborn, but extremely defensive with Vasquez. What's your thoughts there, Jeanette?
Well, she was being pinned down on some pretty, I think, key points by Camille Vasquez. The TMZ stuff. The TMZ testimony is so damning for Amber Heard. Morgan Tremaine said that he was dealing with the copyright holder because it was such a quick process. So I think that was very damning. The stuff about, the TMZ being there for the photographing of the bruise, and then the next day this photograph of her with Rocky Pennington without the bruise, and she said, "Well, I must have been wearing makeup." I think these are key points, and they're key points for the Depp team. So I think that Amber Heard, we've seen and we've heard in the audio recordings, is not somebody who backs down and doesn't back down easily. And so I think that's just going to be something the jury is going to have to look at. And the fact that she never concedes that she's made mistakes or done anything wrong. That's something I've noticed throughout her testimony. We all do things that are wrong. We all screw up. We all mess up. So none of us is perfect. So I thought that was interesting. I just do want to point out, though, as I was walking off the 5th floor of the courthouse, I walked past a gentleman who had been in the courtroom, and he said that Whitney Enriquez walked past him, and he looked at her, and she looked none too pleased. I won't use the word that he used. I tweeted it out, but he said she looked pretty angry.
All right. Well, that's an interesting, observation of what's happening with other people there. It's interesting. We're taking more of your questions. We are waiting to jump back live. We're going to see what happens next with the attorneys and the judge. Matthew, we have a first-time chat question from one of our Twitch followers, Harshad Laki. Could either party contest the verdict in a higher court, or is this decision on the case final?
Well, no, there's always available in any trial appellate review. So either party could appeal this case to a higher level. Again, don't forget, we're looking at sort of two cases in one. We have the original defamation case and we have the countersuit. So there's a lot of opportunity here, for review. Depending on what the verdict is on the original claim, depending what the verdict is on the counterclaim. So yeah, this process will probably not end here. The other issue is if there's a verdict and there's a significant award to one party or the other, that's certainly going to trigger the losing party to file an appeal. It's not as though once this case is over and the jury says you owe $10 million that you got to pull your checkbook out and write a check for $10 million. That's not the way it works. So yes, there is going to be a review of the verdicts in this case.
Will our cameras be set up at a higher, outside of a higher court? I don't know. We'll wait and see. In the meantime, we're going to take a quick break. We are waiting to jump back live into that courtroom that you see right behind me. So we'll take a quick break. We'll take more of your questions on the other side before we have to jump live. Right now, outside of the Fairfax County Courthouse, we're covering the Q&A session where we are taking your questions on YouTube, Facebook, Twitter, Twitch, however you can get your questions to us on the Johnny Depp Amber Heard defamation trial. Both sides have officially rested. We're waiting to jump live with the attorneys having a meeting with the judge. We'll hear if there's going to be any motions argued. Right now, we have a question to you, Catherine Luzardo, from Roni Anaya on YouTube. Amber previously testified that she did not write the op-ed about Johnny. During cross today, she just admitted she did write it about him, and he was why she wrote it. How do you think that's going to affect things?
It will significantly affect things because the core of Johnny Depp's defamation trial and claim is about the op-ed. And in the defamation case, in a defamation claim, one of the elements you have to prove is whether or not Amber Heard wrote the op-ed. Now, we've seen a lot and heard a lot of testimony about that. We know from the ACLU's general counsel, they testified that it was written by ACLU, but at the same time, it was also approved by Amber Heard, and it was a collaborative effort between the two of them. I think there would not be any dispute that Amber Heard wrote the op-ed.
We're just going to pause this.
Oh, JK, we're back. Never mind. Ignore me.
To do anything about it. So I think it might just be that it's in evidence. However, it's not going to go back to the jury because it's corrupted. Okay, does everybody agree to that?
Yes, Your Honor. Thank you. It's
Okay.
just an Eastern Columbia building video, so that's fine.
That's just, it's corrupt. Okay, do you have more exhibits to give? Good, let's get Jamie here. All right. All right, so these, you want to get your list, Jamie, and make sure? All right, it's defendants 393, 821, 857, 857A, 883, 1859, 1905. Make sure that's nothing. The second page of that. 1050. This seems to be a longer one. Hold on. And I think that is it, correct? All right, are you missing any other exhibits?
Your Honor, if I may approach.
Yes,
we
you have some?
something
Okay.
today.
Let's
Yes.
go ahead and get those.
I missed y'all.
All right, so these
much
were the
yesterday.
2 through,
And this morning.
oh, these, all right, so we have, okay, I think this one's theirs. All right, so I have plaintiff's exhibit 1316 and 1317. Yeah.
I still need 1301.
1301, does anybody have 1301? Plaintiff's 1301?
It was an Instagram post.
An Instagram post.
We'll get it, Your Honor.
And then that 711A and 711B today.
711A and 711B, the one without the metadata, and one with the metadata showing. It was the same pictures, but it showed the metadata.
I believe that was 712A and 712 and 713A.
Yes, 7,
I don't have those.
we just don't have them, 712 and 713A.
Understood, okay.
Can I get them now? Yeah. Trying to get all the exhibits together right now, so we have them all together so we can review them.
And then the other one is 120D is not in evidence, but it's on their list as in evidence.
120D, is it David?
Yes.
So 120D was listed as, you had it as an evidence, but we do not have it in evidence. All right, is that all the pieces of evidence? Excellent. That's good. Good, okay, so we are very close to getting all of that. I don't want to leave here until we have every piece of evidence with Jamie and everybody has reviewed it, so we don't have to review that tomorrow and waste time with that, okay? All right, so now I think we can do jury instructions, correct? All right, let me just go over the ones that we had a few issues with. At the first one I'm going to go over is the self-defense. There's two, that would be number 28 and 29, correct? And I took those under advisement. Do you still have an objection to the self-defense? All right. So what evidence do we have in trial that would allow to have these two jury instructions?
Sure, Your Honor. So I think there's evidence in the record showing that, Mr. Waldman was Mr. Depp's agent, that, he was retained in connection with the UK litigation and with this litigation. There's evidence that he engaged with third parties in that capacity, that he met with the Daily Mail with Mr. Depp, and that he believed Mr. Depp's version of events. And so I think all of that, is relevant evidence to a self-defense, that Mr. Waldman made those statements in self-defense on behalf of Mr. Depp.
All right, so you're saying if agency is found.
If agency is found.
We believe they're inappropriate, Your Honor. First of all, we have not been able to locate case law, but
We found one from 1860?
That might have been-
1887.
and I know I had seen one a
We said it
while
was a
back.
reversible error if you didn't give the self-defense one, so.
I know I'd taken a look at one a while back. I think but I don't have a case site for you. I think it's a question of law as to whether it applies. So at a minimum, I think we should figure that out, I guess. But the reason we don't think it should apply is these were statements that were made by Mr. Waldman in 2020. I guess it was before Ms. Heard's counterclaim. So if he's saying that
It goes to the op-ed, I think.
Understood. So if he's saying that this lawsuit was a statement in response to the op-ed, statements that were made a year and a half later by Mr. Waldman, and it doesn't, I mean, again, Your Honor, the key words are fairly and reasonably. So obviously both sides are going to argue defamatory implication and what did the op-ed really mean, and did it say these things? But saying, even under their theory, 2 years ago I became a public figure representing domestic abuse, to say that then it's fair for Mr. Waldman a year and a half later to make public statements that Amber and her friends roughed up the place and spilled a little wine, all the things that he said in those statements, that's not fairly and reasonably. Ms. Heard responded fairly and reasonably to Mr. Depp's case through her counterclaim. The parties can speak to each other in the courtroom here, but saying that if someone makes a statement in an op-ed, that then you can go and do whatever you want for 2 years, say whatever you want. And obviously there's only 3 statements that comprise the counterclaim. But as the evidence has shown, it was part of a pattern by Mr. Waldman. It's the opposite of proportionate. It's the opposite of fair and reasonable response.
Okay.
Mr. Depp's opportunity for a fair and reasonable response, well, we don't believe it was either, but he had the opportunity to file a lawsuit in this court.
Right.
To have Mr. Waldman be his attack dog and to say anything Mr. Waldman then says as his attack dog is somehow fair and reasonable and entitled to the privilege is inappropriate. And I do think that before Your Honor gives it, we need to confirm whether it's a question of law.
Okay.
Your Honor, Mr. Rodmore noted that this lawsuit was a response to the op-ed, but I think there could be multiple statements in response to the op-ed. So I think that's not dispositive of anything. And the statements were clearly a direct response to Ms. Heard's allegations on their face. And whether that response was fair and reasonable is a jury question.
I don't, what do you say is the matter of law? The privilege of self-defense is a matter of law?
I think it could be whether it applies.
Okay, I don't think it's a matter of law. I think it's whether or not if there is any evidence that a jury could find it being protected speech, not the weight of the evidence, but if there is any evidence. And I don't think it's my role to weigh that evidence as far as how long it was made afterwards.
I think it is, Your Honor. I mean, it can't be the case that anytime there's an alleged this is why this doesn't come up often, because this just isn't given. If it were appropriate here, every time there's a defamation case, this would be an instruction. Even the person who's the defendant in the case who said, "Well, all I said, I was responding to something that was said before."
So all your evidence that you say goes to the jury are just the statements? That's why this should be given? That he made the statements, that's the only evidence?
Well, I think
You gave me evidence of agency, but that's just agency. Do you have any evidence of self-defense, that he actually said these statements because of what she said?
Well, I think there's circumstantial evidence, at least, that so it's agency. He's an attorney who was retained in connection with this litigation and the UK litigation.
That doesn't automatically give you self-defense, though, a privilege of self-defense.
And that's
You have to make them, I have to have some evidence that the statements were made in response to the direct accusations of Ms. Heard. I just some evidence.
On their face, they appear to be a direct response.
Not the statements themselves, but is there any other evidence? But the statements fairly arose in response to Ms. Heard's accusation. Did anybody testify that he made these statements in response to her op-ed?
No.
Not that I'm aware of, Your Honor.
All right.
Your Honor, just one small point there. There's no requirement that it be in response to the op-ed in particular. The question for self-defense to apply is simply whether it's made in response to an allegation against Mr. Depp. And Mr. Waldman's evidence is clear, I think, that he was responding to allegations against Mr. Depp, and he believed those allegations to be false. There was extensive evidence in the record on that, in fact, I think.
That he was responding to, so if it's not the op-ed, then we're really in murky ground. If he says, well, I was responding to what she said in 2016, that's.
What
That's very
what Mr. Munez is saying is that you take it as a separate case. You take it as a separate case, their claim and then your counterclaim. So your counterclaim is a separate standalone case, right?
Okay.
So the standalone case your claim doesn't deal with the op-ed. So they're saying in defense of your case, that's why this comes in.
But he couldn't have made the statements in defense of our case because these are the basis for our case. So what he had to have been, what was he responding to if it wasn't the op-ed? And if it's not the op-ed, then we're really in murky ground because there's no, plus Your Honor, couple points. To your point, there's been no testimony that he made these in self-defense to anything. Two, the defense doesn't apply. And this is, it doesn't, this is under the Haycox case, 1958. It doesn't apply if we prove malice. So it has to be made in good faith and without malice. So it's coextensive. I can bring the case up if you want, Your Honor. So if the malice inquiry incorporates this, this is the, let's see, 200 Virginia 212, Haycox versus Wilcox Dunn. And it looks like on page 231, they're discussing a Massachusetts case, and that says statements made in an honest endeavor to vindicate one's character or to protect one's interests are usually regarded as qualifiedly privileged, even though they're false, if they are made in good faith and without malice. So the malice inquiry takes care of this.
But did you prove malice?
In addition, I don't think I need to remind the court, but for the record, Mr. Waldman was not allowed to answer any questions about this. So to say, well, he could have been making it in defense of something, they could have let him answer questions and get that evidence on the record. They can't say, well, he could have been making it in defense of something now.
And when I say, just looking at your case, you're claiming these alleged defamation. The three we have allegations, well, they're saying in response that they made them because of something she said that maybe it's not the op-ed.
But then there's no evidence of what that is. She was sued. She said 2016 when she made her and 2018 she has the op-ed that have a couple words that they're trying to turn into what we've just seen for the last 6 weeks, and then she responded to the lawsuit. Okay. So it can't be the case that by trying to defend yourself in a lawsuit that was brought against you, if it's not the op-ed, then it's got to be her statements in the lawsuit, that somehow trying to defend yourself through judicially immune statements in a lawsuit entitles someone else to go out and say whatever they want and then try to veil themselves in the privilege.
Counsel for Ms. Heard made a point of making clear that there was extensive allegations about Mr. Depp circulating. They repeatedly brought up the UK action, which was in fact the context in which I believe these statements were made based on the date. It was very close in time to the UK action. They brought up the Dan Wooten article. These allegations date back to 2016. These allegations are out there, and there's there's evidence, from which the jury could find that Mr. Waldman was acting in defense of Mr. Depp.
We're not acting in defense against Ms. Heard's accusations. So what are Ms. Heard's accusations that would be defense, that are in evidence?
Your Honor, there has been extensive evidence of the accusations against Mr. Depp going back to 2016. For example, the Dan Wooten article that they raised in evidence prior to the op-ed, which included the word wife beater, and it was essentially,
But it has to be.
That's not Ms. Heard's statements.
Ms. Heard's statements.
I don't believe that's correct, Your Honor. It doesn't have to be.
Against Ms. Heard's accusations, it is correct.
That would be crazy, Your Honor, if they get a jury instruction because he was responding.
I understand that.
The number of allegations made by Ms. Heard, it's been very well documented in this case. You have the op-ed, and it doesn't have to be it doesn't have to be any one particular allegation, but you have the op-ed, you have the People magazine article, you have the republication of her statements through the wife beater and the Dan Wooten article, you have the fact that she was giving testimony in the UK action about these issues.
Well, then would you agree that actual malice, you don't get the self-defense if there's actual malice in his statements? If the jury finds actual malice, then you don't get,
If the jury finds actual malice,
then it's not
that
protected
may
speech.
obviate the privilege, but that doesn't mean that the privilege is not applicable or a valid.
But the only way they can find in this case is if there is actual malice. This goes back to their defense, slap defense as well. The only way they find defamatory statements in this case is if there's actual malice. And it's unique to this case, I understand that. But so if they find actual malice and defamatory statements, you don't have protected speech privilege.
And if there's no actual malice, they win.
Yes,
So-
correct. The same with this, that's why we're not giving a jury instruction on the slap defense, because there's no basis for it.
Ooh.
I mean, if the instruction is not being given on the understanding that it's essentially moot,
Which I agree. I think what's what happened with the slap defense as well. We found out after we went down that legal road, we found out that was moot as well.
Ooh.
Okay, so you want me to deny it or withdraw it? I'll do either one.
if you don't mind denying, Your Honor.
Okay, that's fine. I'll deny. That's instruction 28 and 29. Okay, put that in the deny stack. All right, next one I have is the republication one. Okay. So I see both of them dueling paragraphs for the republication. Yes, sir. And I understand last time we spoke that you must determine whether any content that was added constitutes a republication. And you just would rather have just the 3 sentences as yours for republication. Is that correct?
Correct, Your Honor.
That didn't,
No, I
you
think
must
it's
find
the
that she read, or you want to add that into it? I'm not sure. I'm just not sure how I'm reading it.
I think, I don't mean to put words in their mouth. I think we want the whole thing at the top.
Right.
And they just want the 1 sentence at the bottom.
Okay, that's correct.
And Your Honor, we talked about not going backwards. We went
No,
over
I
this on
understand.
Friday. Your Honor said that on page 92 of the transcript, I don't have a problem with the republished jury instruction. I just think it has to be accurate with adding the language. And
Right.
that language was on page 89. You said, but you also have to say, but adding content to it may establish republication. So that's what we did in the sentence that starts with merely linking.
Right.
It did say merely linking to an article does not amount to republication, period. And then we added directly from the transcript, but adding content to it may establish republication. So now they're going backwards. They just want you to strike the whole thing except in the first sentence. And that's different from Your Honor's ruling on Friday and also doesn't fully capture.
Yeah, it
the
doesn't
republication
capture the whole
doctrine.
legal argument.
If I may just make our argument for the record here,
I
Your
agree
Honor.
what you did on Friday, but if you want to do it again, that's fine.
Okay, just very quickly. So I think the issue with republication is whether it reaches a new audience, which is what we
And that's there.
what we propose. Well, it's included in their instruction, and that is basically the full extent of our proposed instruction, and we believe it should be limited to that. Lacova is a case that they've repeatedly cited in support of this republication issue, and that's a case where there was a defamatory New York Times article that was hyperlinked in a more recent New York Times article, and the court said that that's not directed at a new audience. It's the same party tweeting to the same audience, so there's no republication. And that's not the case here, where Ms. Hurd has retweeted a Washington Post article. So that, Ms. Hurd's article, Ms. Hurd's audience on Twitter is different than the Washington Post. And so
But if she just retweeted a hyperlink,
That'd be one thing, but
that's
she.
different. But in this context, and that's why I took the motion strike under advisement, once I got it, there was more content to it. And that's
Yes.
why I'm putting it in the jury instruction, because it is accurate that a hyperlink alone is not enough to reach a new audience. But I'm willing to,
But she
what I think
added the
would
additional.
also add to it though
verbiage
is
at the
after
top.
you must determine whether any content that was added constitutes republication. And let's see, I would say then you must determine whether any added content republished the op-ed to a new audience. I could say it that way. Or I could say, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a republication. I could say it in that term. Add that to the end of that paragraph.
I think that's fine. If if that's the court's inclination.
Do you have any objection to that?
I'm thinking, sorry, I'm
Okay.
slow on the.
One more time.
Yeah, that,
Sure, okay. Let's see.
She didn't just retweet it. She
All right,
added
let's see if
verbiage
I
at
can
the top.
Incorporate into it. Okay, so merely linking to an article does not amount to republication,
Right.
but adding content to a linked article may constitute republication.
And she
You
added
must
verbiage to the tweet.
determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a republication.
So it's to reach her audience versus the Washington Post
I think we would
audience.
prefer just to say, just that first sentence, merely linking to an article does not amount to republication, but adding content to a linked article may establish republication, period.
Well, that's what you already had. This is.
No, because we had you must determine whether any added content that was added constitutes a republication. I think it'd be better to just delete the last two sentences
Yeah.
than to add the sentence at the end.
Your Honor, I just want to note, I don't think that adding content is a requirement for republication. I mean, we found a number of cases when somebody repeats a defamatory statement, that they're as liable as the original defamer.
Right, but she added it
We're not
anyway.
going
So, I
back,
mean,
we're not going backwards. So
Right.
either it's his language or my language. What do you want?
I prefer the court's language.
All right, I'm gonna put my court's line.
I don't know why we were. Okay.
Do you want us to do the revisions? Because if you do it, we may have to just get one more time from you.
Okay,
We're happy to, or
Sammy, can you do it? You gave him to
We did.
in Word format?
we did.
All right, can you do that? Here.
The only other thing I would note is I think the word retransmitted in the second line is misspelled. So
In the second line? Okay, all right, we'll take care of that. But adding content, just do it. Adding content, yeah, it's like this one right here.
Okay.
Do and then just get rid of all of this and add this instead. Okay, all right, and we'll clean it up, we just took out the box. Okay, we'll get that done. All right, takes care of that one. Next one, it's, I think, instruction FF. Defamatory meaning, consider the publication as a whole. And we have dueling answers here. And the defendant just has op-ed in it. The plaintiff just has it as plain, which, I mean, it does say that it means you may not seize any word, phrase, or image. So it would appear that, so it could apply to both of them in that context.
the problem, Your Honor, is that we believe that because the counterclaim statements that the jury will be presented with are redacted, so the statements are in isolation, that there's a risk that as they're phrasing it, the jury may read the phrase, you must read the statements in context as a whole, to say, well, we can't do that, so therefore there's no liability. We think because it's impossible to read those statements in the context of the whole piece. And so that's number one. Number two, the op-ed was all Amber statements. So the whole thing is her words. The counterclaim statements were Mr. Waldman's quotes in another article that we don't believe, well, that's not in evidence. So there's no point arguing about that other than you just have these one or two sentences from Mr. Waldman. So we believe that the jury's going to be confused if we give their instruction and say, we cannot read it as a whole. So therefore we can't, follow the jury instruction.
Okay, I can see your point with that. Yes, sir.
I don't think there's anything there's a lot of instructions here. I don't think there's anything that would indicate they can't find the liability if they're not able to take statements in their proper context, in the context of the entire article. Just thought it would be more appropriately phrased to be mutual, as opposed to obviously applying only to one party.
Well, because yours says you must read the statements, which is true, but you also can take the content in the context as a whole, but you can take the context of the op-ed as a whole, which is accurate. What I could do, if you want, I could keep the op-ed up top for their claim, and then for your claim, we can, in determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read the statements. I could keep that in there as the second paragraph. That way they can't just pull out, because it's accurate law also, that they just can't pull out the word hoax and say, okay, this whole statement.
Agreed.
Okay?
That's fine. Thanks.
Is that okay?
That's fine in concept. I guess I would ask if Norm does that to add a clause saying disregarding any redactions on
Well, it says the statements themselves, statements, and there you must read the statements in context as a whole.
Right. So I think, I mean, could we say in determining whether any of Mr. Waldman's statements or whatever are false and defamatory, you must read the text of those statements as a whole? Text of those statements in context as a whole or something.
But it's kind of, you must read the statement in context as a whole.
You must read, can we say you must read those statements in context as
You
a whole?
must read those.
Because I just don't want them
statements
to
in
think that it's impossible for them to.
Any problem with just putting those instead of the?
I don't think we have a problem with that.
Okay, in determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read those statements in context as a whole. This means you may not seize on any one word, phrase, or image, or consider only one particular statement, phrase, or passage in isolation. Does that sound correct?
Yes.
All right, we'll add that as a second paragraph. Keep Sammy busy. All right. Takes care of that. All right, the next one I have is the objections and assertions of privilege.
Which? 32.
Oh, I'm sorry, it's Depp 32. It's a new instruction.
Yeah, right.
Yeah,
This is the one at the end. This is the new one.
Do you have the objection?
We do. Yeah.
Okay.
The objection, Your Honor, is that the objections made by counsel during the course of trial, we have no problem with something on that. But instructions, what they're trying to do is to direct the jury what inference to draw from Mr. Waldman's instructions not to answer.
Well, the only legal inference they can draw, they can't draw any inferences from that.
Exactly, and that's my point.
That's what this says. You may not draw any inferences from the fact that objection was made.
Yeah, but saying sometimes attorneys stated objections during the course of this trial and instructed a witness and instructed a witness not to answer a question. Objections and instructions to witnesses are not evidence, and you may not consider them in reaching a verdict, nor are you to draw any. So, why do they need to be told this? I mean, I think this risks confusing the jury.
Because to be fair, in the depositions you wanted to keep in all those objections when we usually take them out, but you wanted to keep them in. So I want to make sure the jury doesn't have any improper inferences from leaving those objections in. You wanted to leave them in to show that, hey, I asked the questions, they weren't answered, fine. But you can't infer from that, oh, well, they're hiding something then, or it's attorney-client.
Understood. I mean, just like you can't infer when someone takes the fifth in a criminal case. I get that.
Right, which I would give an instruction for.
Of course, I know, I understand that, but I think that the jury is entitled to draw their own conclusions and not inferences, and not entitled to infer anything from that. But I just think that this risks confusing the jury and getting the jury to think, if they stand up in closing and say they haven't presented any evidence that Mr. Waldman was doing this, then that's using this instruction as a sword. If they get up there and say they haven't, do you understand what I'm saying? They haven't proven that Mr. Waldman was acting as his attorney. They haven't proven that Mr. Waldman was authorized to make the statements. Then they rely on this to hide behind that. And we're not allowed, and I'm not saying that we will, but I'm not going to say you heard him instruct him not to answer, and you should infer that he was acting as his agent. I know I'm not going to say that, but if they're going to argue in closing the converse of that, then that's prejudicial, and that's
All right, yes, sir, Mr.
Your
Rose.
Honor, this is just an accurate statement of law. They chose to play about 30 minutes of Mr. Waldman being instructed not to answer. Without this instruction, that's prejudicial.
All right.
And it would also be prejudicial if they're allowed in closing to say that we haven't presented evidence of anything about the parameters of Mr. Waldman and Depp's relationship.
That doesn't follow from this instruction. This instruction is simply saying that the jury is not to draw any inferences from the objections and instructions inserted by counsel. They can consider the evidence. They can consider whether evidence was presented or not. The instructions and objections are irrelevant to that question.
That's
No.
like saying
All right, I understand
when someone
your-
pleads the fifth in a
your
criminal
objections,
case,
but it
you
is an
can't say
accurate,
they're guilty just because they plead.
phrasing
pled
of the
fifth.
law.
They have the right to plead.
And I want to make sure that the inferences aren't taken against an attorney-client privilege.
Okay. Can you deny it over our objection?
You got it. I mean,
and-
no, I can grant it over your objection.
Sorry.
Okay, Freudian
I
slip.
meant grants. Yes, sorry. Can we get some direction for the arguments that they're allowed to make on closing on that, Your Honor? Because I don't think that's appropriate for them to point to a lack of evidence when they didn't allow Mr. Waldman to testify.
Pointing out that instructions are not evidence is not to say, there's no connection here between these issues, Your Honor.
No, I'm not going to do that. So we're going to do depth 32. I just need to clean up the top part of it. Okay. All right. Over objection. Be offered. All right, then I have instruction JJ, which is the model.
Right.
So why would I not give the model?
We believe you should. I think the only looks like the only substantial difference is that they, rather than saying as it's written, it says clear and convincing evidence that Mr. Waldman's statements. It's confusing and misleading to say that if you have found by clear and convincing evidence that Mr. Waldman's statements were made by Mr. Depp, we already have a principal agent instruction.
Right, if they find principal or agent, I mean, that would be the only basis for it.
Well, first of all, Your Honor, if liability is entirely vicarious, which I think is the position of the counterclaim plaintiff in this case, I don't think there's any evidence of direct liability. If liability is entirely vicarious, then I don't think there's a basis for a punitive damages instruction at all against Mr. Depp, because vicarious liability generally doesn't result in punitive damages as to the principal. Punitive damages are only applied where the person against which punitive damages are being assessed actually engaged in conduct that was wrongful, and that's not the way they've pled and sought to prove their case. I think that's the first.
So they're correct, okay? They're saying you're not entitled to a punitive damages instruction.
Well, I disagree with that, and there's no case law that they've cited in here on that, and I think that's going backwards. That's an argument that we got, and I just think that Mr. Waldman's statements were made by Mr. Depp. I mean, I'd be okay with something that said that Mr. Waldman, while acting as an agent for Mr. Depp, made statements with knowledge. I'd be okay with that.
Is that okay?
I think we would maintain our objection on that. On the basis previously asserted, Your Honor, and then what's the other? I'm sorry, could I have counsel's language again one more time?
Sure.
Yeah, if you have found by clear and convincing evidence that Mr. Waldman, while acting as an agent for Mr. Depp, made the statements with knowledge that they were false or so recklessly, I think it's so reckless. There's a typo there, sorry. We'd be okay with that.
Yeah, I mean, we do maintain the same objection, Your Honor, that principal liability, and we do have case law for that proposition.
I'll overrule that objection. We'll go ahead and, can you type that up real quick for me?
Sure.
And get that to me. If you email it to Sammy, we can print it out.
Yep.
Okay, you're in charge of that one. Okay. All right. That's fine. I think that was it, correct, as far as?
I think it was, other than the verdict form.
Perfect. Let's go to the verdict form. Do you have the other ones for you, Sammy? We can print those out.
Yeah.
All right, let me get the verdict. All right, I think with the verdict form, it was just the first page. Am I correct with that?
And the punitive damages.
And the punitive damage, you didn't have a response, right? You had.
I think there was a comment in what we got from them that we changed.
Okay. All right, well, in the Here. Oh, thank you. All right, I think it was in 1A, the statement was about Mr. Depp. I think the plaintiff wanted that out because we already have, the statement has a defamatory implication about Mr. Depp, and the defamatory implication was designed and intended by Ms. Hurd, which I think is.
If you look at the, I think you should track the finding instruction, which is jury instruction C on
I would
page
have
4
to
of the jury
agree that
instructions,
Waldman
and that's what
was-
the verdict form does.
Okay.
His attorney.
Take a look.
An attorney's job is to speak for their
And that
client, so,
was C, okay,
I mean,
okay.
So the way it's been written tracks the
All right,
finding
tracks the
instruction.
finding instruction.
Yeah,
agree
we
on
don't
that.
have a strong objection here, Your Honor. I
Okay.
thought it was maybe cumulative, but,
It does match the finding instruction, which would be clear to the jury, so we'll keep that in.
that's fine.
And then the punitive,
And so
So
that
on
would
the
carry
last-
through to all of that.
oh, you went through all those?
We'll withdraw that, Your Honor. Their proposed language is
All
fine.
right, so the verdict forms as written are the verdict forms good to go, correct?
No, well, were you, I'm sorry, did they withdraw the punitive damages? Okay.
So we're good with the verdict forms. What I have is the verdict forms, correct?
Your Honor, I think yes, but I do just want to make sure, and I understand we don't go back, but I just want to make sure that for the record, we do maintain that the verdict form should state that the defamatory implication was false and not that the statement was false, because under the Pendleton case, that can, a facially true statement can still have a false defamatory implication.
And I think we had that on the record on Friday, but thanks for putting it again, it's fine. All right, so verdict forms are good. So we'll keep the verdict forms. Did you print out the other? No, you can print it out, that's how, yeah. So which ones are we missing then? We're missing which jury instructions? You're working on 2 of them, right?
32, I have 32 in that.
32 and FF, and you have 1 jury instruction for me, right?
Yes,
All
they're
right.
editing it right now. It's JJ.
Okay, JJ is coming in, and did you do the other one yet, or no? Here, I have that one here, could you guys do? Michelle, or could you, on Depp 32, could you take off disputed and send that to us too?
Yes.
Thank you. And that would just leave us, we'll get those 2 printed out, and then I'll tell you the order that I'm gonna do them. While I'm doing that, I do have the laptop, if both sides would like to look at the jury evidence on these. We'll stay up here at the bench, but all we did was we put 2 files on here. There's no password for it. As soon as you open up, it doesn't have any internet, and there's just 2 files. One's plaintiff, one's defendant. They just click on those 2, and then they can watch all the audio and the video, okay? So if you want to take a look and make sure it's been downloaded to everything that we put on our website, which is all the evidence. We didn't receive any new evidence today for audio or video files, so that it's everything on there. But if you want to take a look and make sure that everything is there, you can do that. Also, all the tangible exhibits Jamie will have, except we need to get those other ones. So you have them? Perfect.
Yes, if I may approach, I have
Okay, sure.
1301.
Okay.
And then, Your Honor, I just would like
Thank you,
some
Lisa.
clarification.
Sure.
I understand that defendants exhibit 712 and defendants exhibit 713 were initially moved into evidence in redacted format.
Correct.
Today, we offered them and put them in an unredacted form, so that's the
712A and 7.
and then
713A.
713A.
Yeah.
I believe Your Honor should already have those in unredacted form. I believe that's how they were provided to you all.
Oh, they're not binders down here?
I believe so. I will. Yes, so I believe you should actually have those in unredacted form
All right.
from defendants.
All right. We have a few binders down here. Hold on.
Yes, I think they would be in the binders. That's correct.
712 and 713. Those, yes.
So I can give you copies.
It could be 2 hours, it could be 2 weeks, you just really never know.
Do you want to go ahead and make a proffer now?
Yeah, but it included 712 and 713, so I can give you copies of that.
Oh, you can? Well, that would make Jamie happy since she's down here digging through binders.
Right, so I can give you copies of that.
Okay, perfect. All right, now we have those in evidence. Okay, so are we missing any more from over here? Or did you find out about the one that you thought was in evidence?
So, Your Honor, defendant, I believe, it's Plaintiff's Exhibit 120D. I believe actually Sammy and I had a number of back and forths about this exhibit. I believe that defendant's counsel provided a redacted version of that exhibit to the court, but based off of our reading of the transcript, that exhibit was not actually offered into evidence.
Okay, so it's not in evidence then?
It's not in evidence, Your Honor. I thought, and I believe I emailed it to Cindy last week.
You're gonna take this video off.
You don't have it, I'm happy to bring it tomorrow, but it's not in evidence, so we can go back and do
Okay, all right, so I just want to make sure, because it was checked off on somebody's list that it was in evidence, and I just want to make sure. I don't know, but it's not. We're good.
And then I heard the exhibits 711, A and B. I'm not sure.
Well, I think
Is that
711 was wrong. It was 712 and 713. So we're good.
All right.
So Jamie, are we missing anything else? Sammy, did you put out the ones that they sent you?
Shit, I gotta take this, I'm sorry.
The email, did you email Sammy the?
I'm currently on a live,
Oh,
but I'm
okay,
getting
okay.
off, but
We'll get that in a
just wait a
second.
second so I can.
Let me just put these in the order.
Here it is.
All right. Get that one without dispute on it. Okay, sure. Republication.
This last paragraph. It doesn't cross out what you get.
It was in the one that I gave you. Let me see. Yeah, that stays in. Yeah, that stays in. You want to go print that out? Yeah. Just print out 2 copies so we can share them. The one that Sammy printed off on republication, I'm just going to give you a copy so make sure they're right, okay?
Yes, and you should receive in your email soon, FF, JJ, and 32.
Okay. So if you print those out too, Sammy. Let's print those out. So you're sending FF also?
Mhm.
Okay. Did you take the disputed off the top? Thank you. All right, let me just get this printed. Could you print me out another one of AA? There's a mark on this one. Or at least email that one to Sammy. Something in the paper and it just doesn't look right. Printing?
I'm not.
Huh? I'm sorry.
I'm not gonna. This one's.
Can you send it to Jamie so she can print them out?
Your Honor, will we be getting just a paper printout or an electronic copy from the court?
All I have is a paper print.
Okay, so we can
So
scan it.
You can scan
okay,
it and
that's fine.
if you want to do it electronic, that's fine.
And will these be posted on the,
Not until after I get
not till
them.
after, okay, wasn't sure. And then they're read before closing.
They're read
is that
before closing. All right. So we have
Thank you.
that.
Okay, so I guess we just replace.
Thank you.
Oh, okay.
If you want to take a look at that instruction and make sure it looks okay before I add it to the stack. Do you have the actual malice one? Was that sent to you? Michelle, you sent the actual malice one?
Yes.
Okay. Oh, never mind. Jamie already gave it. Sorry, Jamie.
And Your Honor, was it,
Is there?
no, I think it's fine. Does the court want, to leave the, herd C, Depp 7
No.
sort of things in there? Cause otherwise we could,
Oh, no, well, yeah, the numbers at top can stay. I just
Okay.
don't want to say disputed.
No, I don't think any of them say dispute.
Okay. No, the numbers, I tell the jurors to disregard the numbers in the heading. That's better for the record if we keep it that way. Okay, so are you still reading the publication? Okay.
Your Honor, can we get, sorry to bother Sammy, could we get one more printout of the actual malice instruction?
Sure.
Thank you.
Jamie, can we get another actual malice?
AA. So these are only copies.
All right, any objection to the republication then? As typed?
No, Your Honor.
Okay. Put that in there as well.
Hold on.
Is there a typo?
Nope, it's okay.
It's okay?
Yep.
All right.
Your Honor, I just have a very quick question regarding closing arguments, if we may. Does the court have any objection to us playing very small clips of?
As long as they're in evidence, you can play anything, show any picture.
Well, that's my question. So obviously depositions were by video, many witnesses, especially from Ms. Heard. Do you have any objection to us playing video depositions, portions of?
If it's not in evidence, it doesn't get.
No, of course, just what's in evidence.
There's no video depositions in evidence.
Oh, I see what you mean. Okay, so.
The only thing that can be played to them is what is in evidence.
But their testimony, it's witness testimony.
Well, yeah, but depositions are witness testimony that you have during trial. That doesn't go back to the jury as evidence. And video depositions are the same. That would give more weight to video depositions than witness
Well,
testimony.
so my question is a follow-up question to that. Obviously, this trial was televised, so there are videos of witnesses testifying.
No,
So-
none of that comes in.
Okay.
The four walls of this courtroom is what the jury decides this case in.
Okay.
Period.
And just so we don't have a problem tomorrow, also, we can't put in front of the jury written deposition or
That's
trial
correct.
testimony.
That's correct.
Understood.
Only things that are in evidence.
Understood,
But you
Your
can
Honor.
show pictures in evidence, you can show video that's in evidence.
Or audio that's in
Or
evidence?
audio that's in evidence, all of that's fair game.
And
You just-
no display of written transcripts either.
No written transcripts, just only items in evidence. And,
No, I'm on the same page.
okay, all right, just want to make sure.
Thank you, Your
And-
Honor,
and
for
you
that
have-
clarification.
And you have 2 hours, right?
Right,
2 hours each, and two people over here and 2 people over there, is that what's going to happen?
Yes, Your Honor, we're going to split our closing, and then only one of us will do the rebuttal.
Okay, and that has to just be on the rebuttal case, correct?
Right. Right,
We have that down, right? We've gone
Understood.
through that a few times.
Understood.
Mr. Chu, do you have something on that?
Yes, I just wanted to make sure we were all on the same page. So plaintiff goes first,
Correct.
then the defendant,
Does-
counterclaim plaintiff.
Right, they do
Then-
their defense to your claim, and also they do their offense to their claim.
And then plaintiff.
Plaintiff gets to do their defense to their
And they
claim and
respond
rebuttal.
only with respect to the.
Rebuttal.
To the
To their
rebuttal.
rebuttal to their counterclaim
counterclaim.
only.
And so it goes 1-2, 1-2, and plaintiff gets 2 hours, they get 2 hours.
Total.
Is it fine if it's not exactly 1 hour
Oh,
for each?
that doesn't matter
That's
to
up to
me.
us.
No,
Okay,
as
thank
long
you,
as your
Ron.
time is just 2 hours, it doesn't matter how much anybody does.
Thank you, Ron.
Okay?
If you wanted to shorten that to about 15 minutes apiece.
I would want to shorten it to 2 minutes, but that's not my take. I gave you 2 hours. I thought
We
that was
got
good.
pretty efficient at the end of this.
Well, it's amazing how that happens. It's kind of like the physics of, you make a circle and the people will fill that circle. That's what happens. I made a circle. Okay, so let's go ahead. Let me just go ahead and read into the record the order that I'm going to give the jury instructions. I'll also read in the record the instructions that were denied. And I will read the instructions that were withdrawn, just so we have a complete record, okay? All right, here we go. All right, so for the jury instructions, I'll read them in the following order. Number heard I, number 3, number 10, 1, B as in boy, C as in Charlie, D as in Delta, E as in Echo, F, G, H, 12, 13, Y, FF, AA, BB, DD, that's David, DD, TT, CCC, 20, Z as in zebra, T, U, V as in Victor, K, L, 5, 6, 7, 32, 8, 9, 16, I, 30, KK, and JJ. All right, those are the ones that will be read to the jury in that order. Okay. The ones that were denied was instruction 22, 23, 24, CC, NN, both as in Nancy, OO, PP, RR, SS, S as in Sam, SS, 28 and 29 were the ones that were denied. The ones that were withdrawn for the record was instruction A, 2, 4, 11, 14, 15, 17, 19, 21, 25, 26, 27, X as an X-ray, 31, W, EE, GG, QQ, DDD, Q, 18, J, M, N, O, P, R, S, HH, LL, UU, VV, WW, XX, YY, ZZ, AAA, and BBB. All right. So I will get you copies now. I'll get you hand copies of the jury instructions I'm going to read in that order, so you'll have copies when you leave here, okay? And I'll give you copies of the verdict form as well. And you can have those while you prepare for your closing arguments. Other than that, if you could come up to see Jamie after I leave the bench, just to make sure you go through the exhibits and everybody okays the exhibits, so we don't have to do that tomorrow. And also if you can have a look at the laptop with Sammy, just to make sure all your exhibits are there that are going to go back to the jury, okay?
Your Honor, one quick question
Okay.
about closing to make sure
Sure.
we don't have any issues tomorrow. Understand the jury only sees evidence
Yes.
that they've seen in the trial. If that evidence is displayed through like a PowerPoint or whatever, are headings allowed, or do you not want the jury to see any written text or anything other than just evidence?
I mean, I've seen PowerPoints in cases before in med-mals where they have their other items up there, but I think in this particular case, I'd rather just have no writing and just have your arguments orally.
That's fine. I just wanted to, make
Okay.
sure that there wasn't
Just try to keep it clean.
or paraphrasing of witnesses or anything like that.
Okay,
It's just,
that sounds fine with everybody. Does anybody?
that's fine with me.
That's a good question, though. Are you going to have a PowerPoint?
Probably with evidence.
Okay.
You know.
Did you want me to have the big screen up as well? For the
I think
PowerPoint?
so. Yeah, I think that would be great.
Thank you,
Okay.
Your Honor. Yes.
Okay,
Thank
good.
you.
We'll do that as well.
And starts at 9.
Starts at 9. Closings start at 9.
So, Your Honor, Mr. Nadelhaft has a proffer still on some
Oh,
things.
yes,
Do
okay.
you want to do that now before we?
Sure.
As does
Yeah,
Ms.
everybody
Myers.
wants to hear your
I have
preference.
a-
As does Ms. Myers at the end of Mr. Nadelhaft's.
Yeah, okay. All right, they have one too. So that's all right. Go ahead.
Yeah. This will
If
be
you can just get to
shorter.
the microphone
Yeah.
so I can hear you better. Or the court reporter can hear you better.
This will be shorter than the other day.
Oh, good.
Okay, this is for metadata. On May 16th and May 17th, 2022, the defendant attempted to introduce into evidence photographs from May 21st, 2016 that included metadata on the photographs. Ms. Hurd testified that the metadata was included on the photos by pressing a button on her phone. The metadata demonstrated the pictures were taken on May 21st, 2016, along with the times they were taken. The exhibits were defendant's exhibits 700 through 726 and are exhibits A through AA of the proffer. Tabs N and O of the proffer are now blank as defendants 712 and 713 were admitted with the metadata on May 26, 2022. Mr. Depp objected to the metadata on the document, stating that the metadata was hearsay and there was no foundation for the hearsay. The court sustained the objection on the ground that the metadata was hearsay and that there was no foundation, and admitted the exhibits, but redacted the metadata. And then separately, we have a proffer for Stephen Duders. On May 20th, 2022, Ms. Hurd moved to designate certain portions of the deposition testimony for trial of Stephen Duders, who was Mr. Depp's personal assistant. Mr. Duders testified that he was on the Boston flight and sat in a seat facing Ms. Hurd and Mr. Depp. He further testified that the day after the flight, Mr. Depp told him he wanted to, quote, smooth whatever issue, end quote, existed with Ms. Hurd. Mr. Depp asked Mr. Duders to, quote, write a text, end quote, to Ms. Hurd and to say, quote, whatever she needs to hear, end quote. Mr. Duders then sent a text message to Ms. Hurd about Mr. Depp stating, quote, when I told him he kicked you, he cried, end quote. The testimony is contained in Exhibit A, Mr. Duders' deposition. Ms. Hurd moved to admit the text message into evidence, arguing it was not hearsay under Rule 2:803, which provides for the admission of statements of a party opponent and his agents. Ms. Hurd argued Mr. Duders was acting as Mr. Depp's agent when he sent the text, and the text message was therefore not hearsay. The text message is Exhibit B to the proffer. Mr. Depp objected to the text message as hearsay, arguing that although Mr. Duders was Mr. Depp's employee, sending text messages to Ms. Hurd was not within the scope of the employment. The court denied the motion to admit the text message in testimony, finding that Mr. Duders was not acting as Mr. Depp's agent when he sent the text message. And I have copies to provide.
All right, fine. We can add it to
The list, yeah.
We have a box for you. All right,
Oh,
we
here's-
will
here's this.
add that.
Oh, sorry, Eric.
I think he has more.
And this is the other one.
All right, we'll make them part of the record. Thank you, sir.
Thank
All
you.
right, yes, Ms. Myers?
Thank you, Your Honor. On May 25th, 2022, plaintiff intended to call Dr. Kim Collins as an expert witness in forensics pathology. Defendants objected on the basis that Dr. Collins had not been designated as a defensive witness and was designated only to rebut Dr. Jordan, which was defendant's forensic pathologist who had not been put up at this trial. Dr. Collins intended to testify as to whether Ms. Hurd's descriptions of violence and injuries allegedly sustained by Mr. Depp were consistent with the photographic evidence at issue in this trial. She also, for incidents where there was no photographic evidence, she would have testified as to what injuries she would have expected to see based off of the violence that Ms. Hurd testified to. And finally, she would have testified as to her opinion as to the cause, or as to Mr. Depp's finger injury and what she observed, consistent of which was similar to what Dr. Gilbert testified to today.
All right, thank you. Any other proffers? Okay. All right, so just don't leave here until you check the laptop and you check all your evidence and make sure we get your checkbox on that and everybody's happy with it, okay? Anything else for the court?
Thank you.
Really?
No, thank you.
Thank you very much.
Thank you. Okay.
Thank you, Your Honor.
We'll see you in the morning.
All right.
Hi, everyone. I'm Michelle Yu, and welcome to the third hour of For the Record here on Law and Crime. Thanks so much for joining us. Earlier, Judge Ascarati dismissed the jury for the rest of the day in the Johnny Depp versus Amber Heard defamation trial. The jury will return tomorrow at 9 a.m. Eastern Time for closing arguments. Before we break down that star-studded case, I want to remind you of the other case we are covering down in Florida. Today marks day 7 in the retrial of defendant Catherine Magbanua. The state rested yesterday, so today the defense began to present evidence to the jury to prove she is not guilty of a first-degree murder, conspiracy, and solicitation to commit murder of FSU law professor Dan Markel back in 2014. If you want to check this trial out, you can also watch it on our YouTube channel. And now, though, circling back to Fairfax, Virginia, both sides have rested in day 23 of the civil defamation trial of Johnny Depp versus Amber Heard. All the evidence has now been presented to the jury, and the parties will return to address the jury one last time in their closing arguments tomorrow. Judge Ascarati has allowed 2 hours for each side, and after she reads the jury their final instructions, the case will then be handed over to them to deliberate. Now, Law and Crime is all over this case, as you know, in Fairfax, Virginia. So tune in tomorrow and we'll keep you up to speed with any movement in that courtroom while we are near the end of this star-studded trial and begin verdict watch. Now, since court is in recess, let's recap some of the rebuttal testimony of the forensic psychologists called in this trial, each presenting very different perspectives about Heard and PTSD. Let's take a look at Dr. Shannon Curry's testimony first. She was hired by Depp's team.
Dr. Hughes says that Ms. Heard has PTSD. Do you agree?
I do not.
Why not?
The results of my multi-method comprehensive evaluation based on carefully selected, researched, relevant test instruments, based on comparing those instruments to Ms. Heard's self-report, observing Ms. Heard's behavior over 12 direct hours of assessment, reviewing copious notes from prior therapists who indicated symptoms in their notes, reviewing the notes of Nurse Filati, previously Nurse Borum, who spent, I believe at one point, almost 2 months with Ms. Heard daily, reviewing the notes of her treating providers, all of the legal documents and discovery. There was no evidence of PTSD.
How is evidence of PTSD generally exhibited?
So really the bottom line in a forensic psychological evaluation is a change in functioning. That's what we're looking for. Again, I said, we don't have a crystal ball. We're not wizards. We can't get into somebody's head. What we're looking for were there identifiable changes in the way the person engaged in their world. Were they able to keep a job? PTSD is an extremely disabling diagnosis. When a person has true PTSD, it is difficult for them to work. You'll see unemployment, job loss. It causes extreme levels of distress and impairment. There's divorce. There's isolation and estrangement from children, from family members, extreme alcohol abuse, often a string of sudden DUIs when the person never had any before. They become homebound. They can't go to the store. They're certainly not going to events. They're not having success in their film career, usually. They're not exercising every day, pursuing their hobbies, being avid readers, obtaining level 3 sommelier training, having dinner parties with friends, speaking to public groups. Those are just indications of very high functioning. And when you're looking for a decrease in functioning over time, that is inconsistent with that decrease.
All right, with that in mind now, let's compare Dr. Curry's testimony against what Dr. Dawn Hughes said when she returned to the stand to testify in Amber Heard's rebuttal case earlier this morning.
Dr. Hughes, Dr. Curry also testified that a victim of PTSD has to effectively be prone and unable to function at all. Would you agree with that?
Objection, misstates the evidence.
She said they couldn't hike, they couldn't move, they couldn't function in any shape, way, shape, or
Overruled
form.
objection.
Thank you.
No, that is not correct. That is often actually a myth and misconception about individuals who are struggling with PTSD or trauma-based disorders. And I'm often called to answer that and speak to that. People who are struggling with trauma and PTSD are very strong, courageous, resilient people, even though that they're struggling. They get up, they have to go to work and drop their kid off at school and go to the market, even though they're struggling with these symptoms. So I often talk about it as this sort of walking around with a 50-pound bag of flour on their backs, just sort of trying to get through the day, where sometimes that button's going to press play and the trauma is going to start activating in their head, and then they're going to be having to think about it and have startle and have physiological reactions until they can find a way to hit that pause and shut it off again. So they still have, impairments in other ways, but they go about their lives. They're not, totally debilitated. If you have someone in that high range, the highest score is an 80 on the CAPS. Ms. Heard had a 28. If you have someone in the higher range, we have seen people who are, severely disabled because of it, but that's not the norm of people who have this moderate PTSD.
And did you find functional impairment with Amber?
Yes, I did.
Now, Dr. Curry also said that it is not within the scope of a psychologist to evaluate domestic violence. Do you agree with that?
Of course, I don't agree with that. This is what I do for a living, day in, day out, for 25 years. We are specifically trained to understand the profound impact that trauma has on people's lives. That's what we do in the trauma division of the American Psychological Association. We disseminate that knowledge. And domestic violence is one of those profound traumas. Domestic violence is part of state licensing boards, that you can't get licensed in some states unless you take training on domestic violence. You can't renew your license unless you get training on domestic violence. So people who have, specialized training in this area, it is, beholden upon them to accurately assess for intimate partner violence and sexual violence. And it's more important to assess for the sort of scientific understanding of what domestic violence is. So you have to assess for the physical violence, the psychological violence, the surveillance, the economic, the emotional abuse, and the sexual violence. That is not gratuitous. That is
Objection.
understanding.
Narrative.
All right. Next question.
And I want to bring in my guest this hour to discuss that testimony. Sticking with us here is crime analyst Lisa Lockwood, and we also have psychiatrist for Women's Health, Dr. Yalda Safai, joining us too. Yalda, let's start with you. Do you think Dr. Hughes did well here? She pointed out that in contrast to what Dr. Curry said, those with PTSD can function in society.
Of course. In fact, they function for years before they even recognize they have PTSD, before they even recognize it and seek treatment for it. So it's very much possible for someone to have something called high functioning PTSD. So yes, it's possible.
Lisa, both doctors did not evaluate Amber Heard in the same way. So are different approaches fine? Do you have to nitpick rules and regulations about psychological tests?
Well, I think the guest you have right now would be better equipped to answer that question because she's probably done that. So there are an array of ways of coming up with a diagnosis, and both of them talked about their methods and what they use. Some of them were similar, and then some went beyond the other person's method. But what I do find interesting about PTSD and what we're discovering right now is it's on a scale. Can it be completely debilitating? Are you depressed? Do you have a complete change in your function? Or do you show up courageous, resilient, as Amber Heard's doctor had said? So knowing that there's a scale, I thought that there was a scale with depression, and knowing people in the military and police and people who have incidents in their life and veterans that suffer through PTSD, a lot of them, I guess, are higher on the scale because they do turn to drugs. They do end up changing their complete function. They're not able to work. And these are the only PTSD victims that I have had to deal with, and knowing that they fit that criteria. So this is new information for me.
And Yalda, so I want to get your take on that because obviously you're the professional here.
Right. So I agree with what she said about being there is spectrum for PTSD. You can have mild symptoms and you can have severe debilitating symptoms. And sometimes it's a progressive thing. You might start out with mild symptoms that just become more and more debilitating. And it's only when you have those debilitating symptoms that you seek out help and treatment. Now, in terms of approaches to treating PTSD or diagnosing PTSD, yes, there's a general guideline, but not every single person meets the criteria for PTSD. And it's really, every psychologist and psychiatrist has different ways of exploring this to determine whether someone really has PTSD or not. There's no blood test to say you definitely have PTSD or not. It's very subjective. So people have different methods and different ways to come to the conclusion that a person has PTSD. There is a diagnostic criteria we follow, but every psychologist or psychiatrist has their own way of coming up with an answer.
Now, we can't forget to discuss testimony of psychiatrist Dr. David Spiegel. During cross-examination on the stand, he made reference to the Goldwater rule when asked if he examined Johnny Depp. Let's listen and discuss on the other side.
You were asked about whether you were able to examine Mr. Depp. Do you recall those questions back and forth?
Yes.
And so if I understand your testimony, you asked twice for Mr. Depp to be interviewed by you, correct?
Yes.
Objection leading.
And overruled. And then in addition to that, Ms. Heard requested twice of the court for Mr. Depp to be submitting to an examination of you, correct?
Yes.
And those were denied, correct?
Yes.
And now Mr. Depp is contending that it's unethical for you to provide an opinion in this case because you didn't get an opportunity to interview him. Do you think that makes sense?
Objection, Your Honor.
I'll sustain the objection.
All right. Is that your understanding?
That is my understanding of it.
Okay. Now, when counsel for Mr. Depp was reading to you the Goldwater rule, there were two words that he kind of went over pretty quickly, and I'm going to go over them again with you a little bit slower. And that was that the Goldwater rule was that you cannot make an armchair diagnosis, right?
Objection.
Based on, quote,
Okay.
publicly available records. Do you recall that?
Yes.
Okay. Now, the records that you reviewed in this case were private, were they not?
Yes.
And in fact, Dr. Blaustein's records were marked confidential, correct?
Yes.
And his deposition was marked confidential?
Yes.
Okay. And Dr. Kipper's records were all marked confidential?
Yes.
Objection leading.
And
I'll sustain.
okay, what if any labeling was there on Dr. Kipper's deposition?
All the documents I reviewed were confidential, and I also signed the confidentiality agreement, so everything I looked at was confidential.
Okay, so that in fact does not even comport, that doesn't meet the restrictions that were put.
Objection leading.
I mean, so would it be fair to say that you have not, or have you rendered any opinions in this case as an expert witness based on publicly available records?
I have not rendered any opinion based on any publicly available records.
Dr. Yelda Safai, what could you tell us about the Goldwater rule here? How much weight should the jury take in Dr. Spiegel's testimony?
Very much. It's very unethical and it's very unethical and forbidden for a psychiatrist to pass comments or make a diagnosis without evaluating a patient, specifically if that is a public figure. So I am completely in agreement with the psychiatrist that he avoided answering this because, like he said, the Goldwater rule states that we are not allowed to pass a diagnosis or comment on the mental state of anybody, especially a celebrity, without evaluating them ourselves.
Let's not forget Dr. David Spiegel had quite the circus testimony as well when he took the stand. All right, we're going to take a quick break here on Law and Crime. When we come back, so much more to cover on day 23 of Johnny Depp versus Amber Heard. Stay with us. We'll be right back.
Are we going back in? What I miss? Took that phone call and I don't know what's going on.
Welcome back to For the Record. I'm Michelle Yu, and thanks again for joining us. We are now in day 23 of the Johnny Depp versus Amber Heard defamation trial out in Fairfax.
Okay, so that's done. Okay, so what do y'all want to do? What do y'all want me to see? I missed everything today. Jeez. And yesterday. Okay, so is there a particular thing y'all are wanting me to rewatch to the TMZ guy? Okay, let me see here. Let's find it. TMZ testified. Was it very long or was it like 12 minutes? Actually, let's just do this. Depp, day 22.
Unlike platforms that we cannot name, Riverside automatically records audio and video locally on you and your guest computers and simultaneously uploads it to the cloud. So you get crystal.
So let's see here.
Where are you?
Outside. Oop, hold up. Oh, see.
1990.
Okay, let's start here. Hold on.
Are we ready for the jury?
Yes, Your Honor.
Okay.
For anyone confused, we're rewatching what I missed yesterday. It's definitely a rewind show right now.
Good morning, ladies and gentlemen. All right, please be seated. Next witness.
Good morning, Your Honor. Mr. Depp calls Kate Moss to the stand.
Let's go.
She will be appearing on your screen.
All right, ma'am, can you hear me? Yes, can you count to 5 for me?
1, 2, 3, 4, 5.
Thank you, ma'am. If you'd raise your right hand. Do you swear affirm to tell the truth under penalty of law?
I do.
Thank you.
Good morning, Ms. Moss, or I should say, good afternoon, your time. My name is Ben Chu from the firm of Brown Rudnick. Would you please state your full name for the record?
Kate Moss.
Looking like a
Ms.
snack.
Moss, where do you reside?
London, England.
From where are you testifying today, Ms. Moss?
Gloucestershire, England.
Ms. Moss, do you know Johnny Depp?
Yes, I do.
How do you know Mr. Depp?
I had a relationship with him.
Did there come a time when you and Mr. Depp had a romantic relationship?
Yes.
For how long, Ms. Moss, were you and Mr. Depp a romantic couple?
From 1993 to 1994 to 1998.
Ms. Moss, did there come a time when you, while you and Mr. Depp were a couple, that the two of you took a vacation together to the Golden Eye Resort in Jamaica?
Yes.
What, if anything, happened when you were in Jamaica with Mr. Depp?
We were leaving the room and Johnny left the room before I did, and there had been a rainstorm, and as I left the room I slid down the stairs and I hurt my back.
How did you...
And
I apologize, Ms. Moss, please continue.
And I screamed because I was because I didn't know what had happened to me and I was in pain, and he came running back to help me and carried me to my room and got me medical attention.
Did Mr. Depp push you in any way down the stairs?
No.
During the course of your relationship, did he ever push you down any stairs?
No, he never pushed me, kicked me, or threw me down any stairs.
Ms. Moss, have you ever before today testified in any kind of court proceeding?
No, I have never.
Why did you decide to testify today?
Objection, Your Honor.
All right.
That's beyond the scope of what we just talked about.
All right, I'll sustain the objection.
Thank you, Ms. Moss. We have nothing further at this time. We greatly appreciate your taking the time to testify.
All right, any cross-examination?
No, Your Honor.
All right, you're free to go. Thank you, Ms. Moss.
Thank you very much.
Thank you very much. Thank you.
Okay. Love to see that. Let's fast forward here.
All right,
One main skill that you notice is elevated, then you look for additional subscale life events check.
I mean, I know she did fantastic, so I'm not even worried about that. Oh, now come on.
$1,200, $5,000, and this one is
Responses as verbatim.
Damn, am I gonna get a commercial every time I try to skip?
I discovered the 8 immortal kings of Samaria lived a total of 241.
Very well. So then I go down to control, self-control, loss of control, coping abilities, and I put in the scores that are associated with that and the research
an understanding as to where they appeared.
As to where they had appeared, these statements.
In what publication?
No, off the bat, I didn't know exactly. It just seemed like a lot of word salad to me. I didn't know where they'd come from, or I mean, where they ended up. Or...
Mr. Depp, do you recall Ms. Heard testifying that you did not assist her in getting her role in Aquaman?
Yes, I do. Yes.
And what is your response to that?
It's not exactly true.
Okay, here we go. TMZ guy. I'll watch Johnny Depp by myself later, so y'all don't have to rewatch all that again.
Do you solemnly swear or affirm to testify truthfully in this case in penalty of law?
Yes, ma'am.
Good afternoon, Mr. Tremaine.
Hello,
Would you please state your full name for the record?
Morgan Cliff Tremaine.
And what do you do for a living?
I produce esports events and design video games.
And in 2016, what did you do for a living?
I worked as the field assignment manager at TMZ.
What is TMZ?
TMZ is an entertainment news website and television show.
And what were your responsibilities as a field assignment manager for TMZ?
I was the go-between the news desk in the office and the reporters in the field, which you might know as paparazzi.
Approximately how many paparazzis were you in charge of?
At the time, it was about 20 in LA, a handful, maybe 3 in New York, and then 1 in DC.
And what were your responsibilities specifically as to the paparazzi?
It would be to dispatch paparazzi to various locations based on tips or just direction dictated by having a list of sort of hotspots where celebrities would be.
And how were those tips received?
They were received either through tips that we received through our tip line or directly through news producers in the office.
And were tips frequently received directly from sources?
Very often the case, yeah.
And who were the type of sources that TMZ received tips from?
They would receive tips from, oftentimes it would be publicists, managers, agents, or B-list celebrities.
Lawyers?
And lawyers, definitely.
How are tips verified?
Tips are verified by an extensive process. If they come in through our tip line, we have to verify who sent it, that
It's
they
legit.
that the source is truthful, and so they have to add their contact information, which is a field in that on that website for like name, phone number, things like that.
And how long did that process typically take?
If we receive a tip through the tip line, it could take a while because that would need to be, if it was a tip, we would need to verify it. If it was media, such as photos or videos, that would need to be extensively verified to ensure that the person sending it is the copyright holder and that we would have the legal ability to air it and distribute it.
And while working
You
for
have to make money
TMZ,
off
were
of
you
it by
involved in any
copyrighting
assignments related to Ms. Heard?
I was.
What was the first time you recall working on an assignment related to Ms. Heard?
I believe it was May 27th, 2016.
And what was your role in
week
that
after
assignment?
the event.
For that, Ms. Heard was filing a restraining order at a courthouse in downtown Los Angeles. So I dispatched camera people to that location.
So they were alerted that she was at the courthouse.
Under what circumstances
Which we
would you
knew.
normally send paparazzi
Because that's
to
obvious.
a courthouse?
Only if we had been informed prior. It's not
I
by
told
any means
y'all.
a celebrity hotspot.
I told
We would
y'all.
only ever send people there if we had been tipped off that something was
I
occurring and
told
there
y'all
was
they don't
somebody
just
present
stake out
there.
the damn courthouse all day.
And what footage was TMZ trying to capture at the LA courthouse on May 27th, 2016?
We were trying to capture Amber leaving the courthouse and an alleged bruise on the right side of her face.
So they were alerted not only that she was there and what she was doing.
What
but
was
that
your
she had
team
an
of
injury.
paparazzi supposed to do while they were at the LA courthouse on May 27th, 2016?
Objection, Your Honor, hearsay and foundation.
What were they supposed to do?
Right. She's asking for, I don't think there's a.
How is that
I'll
hearsay?
overrule the objection at this point. We'll see.
Yeah.
Go ahead, Mr. Tremaine.
Can you state the question again?
What was your team of paparazzi supposed to do while they were at the Los Angeles courthouse on May 27th, 2016?
Their objective was to capture her leaving the courthouse, and then she was going to sort of stop and turn towards the camera to display the bruise on the right side of her face, the alleged bruise.
Did your team of videographers get the shot of Amber Heard?
We did.
What is the difference between receiving a tip from a news producer and any other source?
So she said she posed for you.
If it's any other source, it would have to be verified by copyright. If it was anything that was received directly through a news producer, then they go through that process to verify the source.
Did you do anything to verify the tip on May 27th, 2016 related to Amber Heard?
I did not,
Why not?
because it had come directly from a news producer.
Does that mean it had been verified?
It means that they had verified that tip and deemed that it was credible, and therefore a camera person needed to be dispatched.
After May 27th, 2016, were you involved in any other assignments related to Amber Heard?
Yes.
Can you tell me about those assignments?
The next one would have been August 6th, 2016, where she was giving a deposition.
So what did you do in relation to that tip?
I dispatched camera people to a parking lot adjacent to a law office in which she would be arriving to, so we could get the footage of her arriving for the deposition.
Do you typically send paparazzis to parking lots?
Y'all have already seen this, so I can pause when I talk. So basically, as I said, I don't know, a week or two ago, they don't just hang out at the damn courthouse all day. So the only way they would have known that she was there, as we've already discussed, was if someone just happened to be there for another case or something and saw her there, or if someone had called to say. And clearly he just said, yeah, we were tipped off she was going, why she was going, and that she had this alleged mark on her face and she's going to pose for the fucking camera. So that was, I mean, I felt like that was obvious, but I mean, I guess some people think paparazzi hangs out at the courthouse all day. They most certainly do not. But let's get back to it.
Lots of law offices?
No, not at all.
Did you get the shot of Miss Heard on August 6, 2016?
We did.
After August 6, 2016, were you involved in any other stories involving Miss Heard?
Yes, I was.
And what story was that?
On the 12th, we received a video depicting Johnny Depp slamming some cabinets that was captured by Ms. Heard.
And what day was that?
Okay.
I believe that was the August 12th
Of 2016?
of 2016, yes.
Can you describe to the jury how you received the video on August 12, 2016?
Yes, the video was sent in through our email tip line, which is an email distribution that goes to all the producers and to myself as the field.
So they have proof of who sent the fucking email.
Assignment manager, because it often included celebrity locations. It came in as I recall,
Objection, hearsay.
He's just describing how it came in.
I think he's about to reveal hearsay, Your Honor.
I'll overrule for now.
You can't object before you. No.
Please continue.
No.
So I received that email
He
and
might say
included a
hearsay
link
object.
from some unknown Dropbox type public website in which it contained that
Objection, Your
video.
Honor, hearsay. He's about to describe what comes from the Dropbox website, and that's.
So far, he's just said he's, what's the link from the Dropbox? We'll see the next question. Go ahead, next question.
So you received a link. What was in that link?
In that link was the video of Johnny Depp smashing the cabinets.
And you received this video in your inbox, correct?
I did.
What did you do once you received that video?
We downloaded it. We alerted the web editor who was sitting next to me at the time. We downloaded it, and then were instructed by the news producer to do what we call slap bumpers and a bug on it, which is putting the dun 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 at the beginning end, and then putting a translucent watermark over it, which indicates copyright ownership.
Okay. So you bought it.
After you did that, was it posted?
It was posted, yes.
Where was it posted?
It was posted to tmz.com.
Did you do anything else related to Amber Heard on August 12, 2016?
Yes, I received a tip that Amber Heard would be arriving at LAX, and so I dispatched camera people to film that exit, or her.
Well, now time out. He receives the email, which would verify who sent it. Not that we don't even need him to write on a source, because the fact that he had a copyright on it tells us the source, as I said a week or two ago. So he gets the email, whatever, don't need to know who sent it, and begins to put the copyright on it. So did the email send in this video and give him the rights or forfeit the rights of the video up to TMZ, or did they pay for it? Like, that wasn't specified. So does the email say you have the rights to this video? Come on.
Her arrival to LAX, rather.
And why did you do that?
I was instructed to.
How long does it take to post a story after media's been received by TMZ?
After media's been received, it could take any length of time depending on
Verification.
who owns the copyright.
Right.
How does TMZ obtain copyright over images and videos?
The only way to obtain
I was jumping
copyright
to the
over
point
media
earlier.
would be if we shot it ourselves,
Right.
if it was sent to the tip line, source verified that it was from the original copyright owner, and then either purchased from that person
I was
or
ahead of
given to
myself.
us.
There you go.
If you record podcasts
Oh,
and
come
videos
on.
remotely with Riverside, your content will look and sound so good no one will.
And then
So I was ahead of myself on there, clearly. Sorry, guys. I was jumping ahead unknowingly.
the third option would be if it was directly given to us by the copyright holder, like a direct source.
And how long does it take to copyright something TMZ has received through the tip line?
It can take a while because you have to extensively verify that that person owns the copyright.
Right? You don't get sued.
And then possibly, it depends also if you can even get in contact with the person because they might not be super responsive immediately via phone or email that they provided. And then potentially you'd have to enter a negotiation with our clips and clearances department to figure out the cost of that media.
How long does it take for TMZ to obtain a
Cost of
copyright
media.
over something received directly from a source?
Something in the realm of 15 minutes just to do what I described before, which is putting bumpers and a bug on something and write the article and post it. It's pretty fast.
How much time had
Because they
passed
give
from
you
the
rights.
time you received the kitchen cabinet video to the time it was posted on TMZ?
About 15 minutes.
Did any other tabloids other than TMZ post this video?
Objection
No, they-
leading and calls for hearsay.
Did any other tabloids?
Overruled.
Mr. Tremaine, go ahead.
No, they did not.
And why not?
Because it was a TMZ exclusive.
And what does that mean?
It means
Only
the TMZ owns the copyright to it. So it can't be distributed by any other media source without backlinking to TMZ. And they wouldn't be able to upload that media without getting a copyright strike.
Time out.
Have you seen the kitchen cabinet?
You also cannot credit a source that you don't know is the source. And what I mean by that is if you see a video, let's say I filmed something and I put it up and it's not of me, but I like the Duggar thing yesterday, the sentencing statements they made. I filmed that, I put that up, someone sees it and shares it. They don't know to credit me because they don't know that I was the one that recorded it, which is why all these people put up these videos and then got a copyright pull for it, because how were they to know that TMZ had the copyright? They didn't even know it until they got the pull.
Video that was played in this trial?
I have, yes.
How does that video that was played in this trial compare to the one you received on August 12, 2016?
When I had clicked the direct link that we received and watched the video in its entirety, it was much shorter than the video we had received, than the video that's been played in this trial. There was a bit at the beginning that was played here in which Ms. Heard is seemingly sort of setting up the camera and getting into position. And then there's a bit at the end where she's seemingly snickering and looks at the camera. That part was not present in what we received.
Did TMZ edit the video?
No, not even a little. When we receive something and it's edited, there's a clear indicator because there's sort of a journalistic practice that uses when there's an edit, you do what's called like a white flash transition, which covers the entire screen with white to very clearly indicate to everybody there was an edit here for time or whatever, just to make it a little more compelling. But in this case, it was not edited as I was staring at the machine that edited it and present for the entirety of receipt to publishing.
When was the next time you worked on an assignment related to Amber Heard?
Okay, I see what you did there.
Well, there was the
I see what you did
time
there.
where we went to the airport. And then the day after that, because she had flown in for the deposition, because I think the first time didn't work out. So she was arriving again for the deposition in that same parking lot adjacent to a law office.
So he knew when she was
Was
gonna
that
get there.
August 13th, 2016?
That was August 13th.
AKA communicating.
And what was your assignment on August 13th, 2016?
To dispatch camera people to that parking lot at a specific time in order to film Amber Heard arriving for the deposition.
How did you know that tip was legitimate?
It came from a news producer.
While you worked at TMZ, did you ever receive any communications from Mr. Depp or his camp?
I did not.
Nothing further, Your Honor.
Cross-examination?
Yes. So how do you know what video was shown at this trial?
I was alerted by a friend that that TMZ was being kind of talked about in this trial, and so I had seen a clip of that.
Rational.
So you watched some of this trial?
Correct.
Okay. When did you first reach out to counsel for Mr. Depp?
I believe that was 6 days ago, whatever that date would be. I'd have to do that.
All right. And then you received a subpoena, I think, yesterday.
So timeout. This guy took one for the team because he's putting a target on his back by saying, look, you never rat on your sources, okay? And I will not rat out on my sources. I take that shit to my grave. Unless, like, source secrecy and protecting your sources is very important. But here, it's so obvious due to the copyright who the source is. And I love that this guy went out on a limb. And he's not risking his sources, okay? It's obvious who the source was based on the copyright. So there's that. But he put a target on his back by saying, hey, look, no. Like, I'm going to reach out and say something. So I can respect that.
In care of your attorney, Cindy Hickox, right?
Correct.
Okay. And Cindy Hickox represents Christy Dombrowski, Kate James, Robin Baum.
Objection, Your Honor.
Were you aware
Calls
of
for
that?
speculation.
Overruled.
Were you aware of that?
No.
Okay. Now, if you don't have information that's helpful to this case, then you wouldn't be a witness, correct?
Objection. Calls for
can't.
speculation.
Sustained. Next question.
I'm not aware.
Okay, you know this case is being televised, right?
No shit.
I am aware that there are cameras.
And so this gets you your 15 minutes of fame.
Bitch.
Objection, Your Honor. Argumentative.
I can ask that question.
Overruled.
So I stand to gain nothing from this. I'm
No.
actually putting myself kind of
Yes.
in a target of TMZ, a very
Absolutely.
litigious organization.
Yes.
And I'm not seeking any 15 minutes here. Though you're welcome to speculate. I could say the same thing by taking Amber Heard as a client for you.
A little argumentative, don't you think?
Oh, hardly. I find that to be purely logical. Thank you.
Now, are you aware that Mr. Depp's attorneys were
Oh,
well aware
shit.
of the TRO that was going to be presented on May
Touche, my
27th?
friend.
Objection.
Touche.
Calls for speculation.
Were you aware of that?
Lack of foundation.
Overruled if you can answer it.
Can you just restate the
Holy
question?
shit.
Were you aware that Mr. Depp's divorce attorneys were aware that
Holy
Amber Heard was
shit.
going in to seek a TRO on May 27th?
I don't think I understand the question. I don't think so, no.
Okay.
It's kind of a
Do you
complicated question.
know whether Blair Burke, one of Mr. Depp's
Amazing.
divorce attorneys, had a very close relationship with TMZ at that time?
Objection. Calls for speculation.
Amazing.
Overruled. If he knows.
I was not aware of that.
Okay, and when you said that you were dispatched twice, once to film Amber in the parking lot for the
It is
deposition,
logical thinking.
and then it
He's
didn't
very
work out, and so you had to do it another time. How did you know it didn't work out?
Because TMZ.com posted an article saying as much.
Okay.
And
do you
I was
know-
not dispatched.
Do you
I
know
worked in the office.
why the deposition did not work out?
I'd have to reference the article, I forget.
So do you know?
I didn't write that story. I wasn't involved in the
Do
actual
you know
journalism of that.
which side? Do you know which
Great
side
response.
would have known or not known whether that deposition was going to work out? In other words, the people representing Mr. Depp and the people representing Ms. Heard.
I wouldn't know.
Okay. And then the video clip.
He's looking like
You
a snack
don't
too in that
know
all black. I'm
who
here for it.
provided that, correct?
Correct. Not testifying to that.
I've never.
All right, redirect.
Get it. Oh, okay, Cam Man.
Mr. Tremaine, why did you contact me in relation to this case?
I saw that there was discrepancy with like the video that was shown here and the video that I know I'd received. So I had no interest in testifying. I had reached out simply to maybe try to help with the timeline of things.
You see this app right here?
No, come
it's called
on.
Audible. Using just this little app on my phone, I would
Or help with the case in any way, just by virtue of understanding the timeline of the stories that were published and kind of how that can be unclear. But I had no idea I'd be on the stand.
Obviously, you're just trying to
All right, sir,
testify.
you're free to go.
Thank
Thank you. All right.
Well, that was
You have
badass.
another witness. Okay.
Sorry, I was not trying to predict what he was going to say beforehand, but common sense is not that common anymore. And the fact that he even had to be called proves that, because if TMZ has the copyright to the video, that immediately tells you how he obtained the video. I mean, it's purely logical thinking, as he would say, and he is absolutely correct. Of course, if they've got a copyright, they've been given the rights to that video, whether directly given or paid, and he answered that purely logically, as well as without throwing anyone under the bus. I mean, he did the damn thing. What else do y'all want me to watch from yesterday? That was good. That was good. That was hella good. And I agree. He did put a huge target on his back by doing it, but also telling the truth is not fun. It's not always, certainly not always easy to tell the truth, and it's not fun, and it oftentimes does put a target on your back. I respect the fuck out of that guy. Okay, so who are y'all wanting me to watch? Is the Hicksville guy on this from yesterday? Is the Hicksville guy from yesterday's testimony while I was at Duggar? Okay, let's find him. Don't think it's this guy. Who's the? He's still up there. Okay, so when would the Hicksville guy have been? Yesterday morning. Okay. I see Kate Moss. I see Dr. Curry. I see Johnny. Johnny again after lunch. TMZ that we just watched. This guy in a suit, which they're showing exif data to. And then this woman right here. So I don't think Hicksville is from yesterday. Do y'all want me to go back and find Hicksville, I take it? So day 21.
Have you heard about this education stimulus program? This can deposit up to...
Okay, that's... Did catch part of that. EXIF data.
Which we'll find out. The prejudice attached to it. Also, if the excluded witness learned about substantive aspects of the case from an earlier testifying witness, and whether that knowledge had any effect on his or her testimony. So those are the three factors I'm going to look at in weighing this decision. So keep that in mind when you do your voir dire. And it's my understanding that the evidence that Mr. Knight will testify only relates to Hicksville. Is that correct? Okay. All right. Now we can have Mr. Knight. Go ahead. All right, sir. Mr. Knight, if you could come forward to be sworn.
Do you solemnly swear or affirm to testify truthfully in this case and penalty of law?
I do. All right. Sir, if you could just have a seat, please. Sir, what we're doing is I'm just going to ask you a few questions outside the presence of the jury, and then the attorneys are going to ask you a few questions, okay?
Sure.
And then I'm going to have you step back outside after that, okay?
No problem.
All right, what's your full name, sir?
Morgan Higby Knight,
Okay, you don't have to be that close. All right. All right, how do you spell your last name?
N-I-G-H-T.
Okay. All right, and sir, before I can allow you to testify, I just want to ask you a few questions. Have you seen any of the trial that's been going on for the past 6 weeks?
Approximately 5 weeks ago, a friend of mine texted me that Hicksville was mentioned, and I watched a little clip where
Okay.
it was mentioned.
Which clip did you watch?
I believe it was somebody testifying about, I think it was a security guard testifying maybe about Hicksville, or I forget exactly who was testifying, but it was something where Hicksville was mentioned, and it was about something about a wrist or something like that.
All right, and what did you do after that? At some point, did you get in contact with attorneys?
So I didn't reach out to them. I didn't really care. The innkeepers that worked at Hicksville before reached out to them and said, we saw some stuff that wasn't true. And then they asked, is it okay if I give the attorneys your phone number? So the attorneys reached out to me.
Okay, and when did the attorneys reach out to you?
May 3rd.
May 3rd. And you talked to the attorneys at that time?
Yeah.
Okay.
Not Camille, but Geraldine.
Okay, and then have you seen any other parts of the trial?
No, she instructed me not to watch anything about it, regardless of if it was about Hicksville or not. So I've been
since
keeping off the internet and turning off anything that seems to be like it's on social media. So I just don't watch any of that.
Okay.
Good for you.
All right. And
What you
questions,
supposed to
Ms.
do?
Farah?
So, Mr. Knight, you were contacted by an attorney for Mr. Depp on May 3rd?
Yes.
Okay, and you said it was Carolyn?
Geraldine.
Oh, Yerlin, I got it. Okay, and what?
I think it's pronounced Geraldine.
Okay, can you tell us the conversation you had with her at that time?
Yeah, she just asked me my recollection of the evening, and I told her, and she said, okay, would you mind testifying? And I said, sure. And she said, okay, well then, we're not sure if we're gonna call you or not, but just in case, please don't watch anything having to do with the case. And I said, I will do.
Now, how is it that, to your best knowledge, how is it that Geraldine was able to get hold of you? How did she know that you knew something?
So, like I said, two of my innkeepers, my innkeeper and my manager, had reached out to her team, I think through email. And one of them texted me and said, hey, do you mind if we give Geraldine your phone number?
Now, you also communicated on Twitter, did you not, about this case?
Yeah, 2 weeks prior to Geraldine reaching out to me, someone had made a comment about something that happened by the fire pit, and I said, that's not my recollection. I didn't see, that's not what I saw.
And obviously this guy did not know that he was going to be a witness at the time. So, I mean, he didn't have a reason not to be watching it until he contacted legal and they were like, yo, dude, don't watch.
So who was it that made a comment about something that happened at the fire pit?
So once I was told about the fact that Hicksville was mentioned, I went and did a Twitter search of Hicksville trailer. So it was, I don't know who it was, but I was just like, what are they saying about Hicksville? And so that was why I did a search, just to see, because it was weird and fascinating, because the night to me wasn't that remarkable in the context of all the different experiences I've had at the Trailer Palace.
So explain to me, please, what you mean by you did a trailer search.
So if you go to Twitter and you put in keywords and do a search, all the tweets regarding that subject come up, or anything with those keywords in it. So that.
Do you want to know the secret to making a great podcast?
No, I already have a great podcast.
Is
Thank
how
you.
I found the tweet that I replied to.
Okay. And how many tweets did you find that mentioned Hicksville when you did that trailer search?
Probably like 5 or 6. I only replied to one of them.
Okay. And what do you recall those tweets saying about Hicksville?
The one that I replied to said that there was some incident by the fire pit, and Johnny was yelling at Amber, and I replied that I didn't see that. I was there all night, and I was working that night, so I didn't see anything like that.
So your best recollection on that one was that somebody said somebody was testifying that Johnny was yelling at Amber?
Yeah, and I believe grabbed her or something along those lines.
Do you recall
I'm not the only one.
said Johnny was yelling at Amber and grabbed her?
I have no idea. It was a stranger, so I didn't really pay attention to who was writing it.
All right. And you said that you responded to it. How did you respond to it?
I said that's not what happened. I was there all night. Yeah, basically. I'm paraphrasing. It was.
Did you say anything about what you thought happened?
I just said that didn't happen. I didn't say what. I believe I said maybe something along the lines of, from what I saw, Amber was the one acting jealous, not Johnny.
And you said this to one of the tweets.
Yes.
Do you recall whether that was the Umbrella Man?
I don't recall. That's a ridiculous name, though.
Okay.
Do
So
that
tell me
plug-in.
about the other 5
Help him out.
tweets that you recall seeing when you ran your trailer search.
I think they were similar in nature, but I don't specifically remember the details of them. That was pretty much the only one I remembered, and that's the only one I replied to.
Okay, I can see some of y'all's comments. Now, originally when Amber told the story, she kind of made it seem like it was like a double wide rundown piece of shit. So it piqued my interest. It got pulled up. A ton of you shitheads looked it up too and sent it to me. And we've showed it on our live discussions before. It's an incredibly nice place. Matter of fact, since y'all have already watched this and we're just reviewing it, let's just take a little look-see here. I think it's like $3,000 a night to get the whole place or something like that. Let's pull it up. Actually, I want this one. Yeah. Since y'all already seen this and it's paused, let's just take a little side tour. Because again, they made it seem like it was not, well, to me it seemed like it was not a very nice place. And I Googled it and was like, what? Let's just look. Stay a while. Super cute. It's a whole ass vibe. Okay, so let's come on down here. They got different personality ones. The skipper is honestly doing it for me. Loving the skipper. All of these, this tent, love it. A Western vibe there. Oh, I love me a little fat horse statue. Would dead ass put that in my front yard. We got mood lighting. I mean, clearly it's a whole ass vibe, right? I mean, I don't know what looks like one Johnny would stay in. We'll just click this one, the Lux. Okay. Okay, so here's the Lux. Oh, we can do a little video tour here. Great videography. Let's go. Wood carving. I love it. I love it. This is definitely the one they probably saved. Cute. Cute. Look at that. That looks like a porn star movie in the making with the zebra sheets, but I digress. Got a jukebox. I'm totally into it. I'm into it. Oh, is that Maryland? Hey, I think that I made a pretty good vote on which one they probably stayed in because, you know, it's creepy. I dig it. I'm pretty sure that was Maryland inside. But yeah, as you can see, it's clearly a nice ass place to stay. One more thing. Let's see. Matter of fact, JK, let's book a trailer. Let's book a trailer here. Do we have prices? We do. 100, 115, 200, 315. So the entire property is just shy of $2,000 a night. Just to rent out the entire property for the night, you're looking at $1,880 plus tax. Let's round up, say $2,000. Okay, so now that we have definitely established it's a very nice facility, very cool. It's a whole ass vibe. I'm here for it. Let's get back to this.
Do you remember anything about the other 5 and what was said?
No.
Okay. When you said that somebody told you about a security guard, what was your understanding of what the security guard said?
Thank you, Yarmer.
I got a text that somebody in the trial had said that they were talking about Trailer Palace during the trial. And so that's what led me to go on Twitter and do a search.
And did you have any communications with the 2 innkeepers about what you knew or what you thought?
No, I hadn't talked to them in years and still haven't regarding the case.
Can you imagine if all this went to Hicksville?
How is it that the innkeepers
we'd have a shithead
then
showdown?
contacted you and said, do you mind if we give you the telephone number to the attorneys?
Because they still have me in their phone, and Christy, who was the manager at the time, was the one that texted me and said, hey, do you mind if we pass this along? Mr. Depp's attorneys want to talk to you.
Also, notice how all of these extra people are watching this thinking, oh, hell no. This is not right. Let's send into Johnny Depp's team and help this dude out. Have y'all caught on to that? All these additional people talk about how other people are watching the trial and talking to them about how this isn't right. This is crazy. Can you reach out and set the record straight? Hey, can we give them your number so that they can talk to you and get this worked out? Have y'all caught on to that? Because I'm hearing this trend here, and I think it's important.
Do you mind if we pass
The
what
people
along?
want to help
Your
Johnny.
phone number.
Right, but how is it that, what is the communication you had with the innkeepers that even led them to understand that you believed you had knowledge about the Hicksville incident?
There was no conversation. They knew because they were both working that same night. Jenna was the innkeeper and she was there along with me that night. Christy was the one who texted me and she had come in the following morning for her shift. And I slept over. I was live-in innkeeper that night.
So I'm trying to understand. So just based on the
We know
fact
you are,
that
Elaine. We know
7
that.
years ago,
We know.
they happened to know that you were working that night.
9 years ago, and it's because I was there
Okay.
with them.
My math, well.
I'm sure he told
2022
people, hey,
right
y'all
now,
won't
and
believe
that
who
was
rented this place
what year?
out.
Oh, that
Johnny
was
Depp was there
2013.
tonight.
You're right, okay. So
That's
how
normal.
is it
The
that
fuck?
out of the blue, they remembered 9 years ago?
I think you would remember
that-
if you got to
that
hang
you
out with
worked there
Johnny
that
Depp
night
for
and
no
that you
reason
might
all
have
of a
some
sudden.
knowledge.
Come on.
I mean, to be honest, like we do get celebrities sometimes, but was, it's not that unmemorable. It's not like it's any other night of the week. So I'm sure they remembered the specifics of that night.
Had Mr. Depp's attorneys ever attempted to contact you before?
No,
Had you ever attempted to contact Mr. Depp's attorneys before?
no, I had no interest.
All right. Have you had any conversations with Mr. Depp's attorneys other than the
Am I
one
jumping
you
ahead
described
again like
with
last
zero?
time?
Since?
Yes.
Well, I met with Camille last night.
All right. And what was that conversation? Please describe.
I just went through, the story again that I had told Geraldine.
Sure aren't.
And let's hear what that story was.
You want me to go through?
Yes.
The whole story?
Your Honor, we would object to attorney work product.
There's no attorney work product.
No, I'll overrule that.
All right.
That's okay. Go ahead. Go ahead, sir.
Yeah, sure. That
I don't mean to
I
jump ahead, but it's
described,
just
like, them
obvious
getting to
sometimes,
the
like where this is
trailer
going.
palace, me showing them around, the interactions I had when I was on duty with Mr. Depp and Miss Heard, how the evening progressed throughout the night, the levels of drinking and drug use that I witnessed, what the state of the damaged trailer the next morning, and basically just, the details that I had only, spent total 45 minutes to an hour with Mr. Depp and Miss Heard throughout the entire course of the night. So it was my recollection of those events during that time.
And what did Ms. Vasquez say to you?
Your Honor, this is beyond, we object on the grounds that it's beyond the scope of the voir dire,
No,
which is limited to the
whatever
three
she said to
criteria.
him is
May I
very
please finish
clear.
stating my objection, Your Honor?
Go ahead, yes, sir.
The objection is that it's beyond the scope of the voir dire. Your Honor enumerated the three criteria which are relevant here. And this is a rebuttal witness, so.
Your Honor, whatever Ms. Vasquez shared with him is going to be very important here because they knew by this time he was going to be a witness. So.
Well, that was last night, so how does that fit into one of the three factors in deciding whether or not he's going to testify?
Well, one of the three factors, Your Honor, may I approach so that the witness doesn't hear?
Okay, that's fine.
I mean, where's she going with that? I'd be laughing too if I was on the witness stand. I was fighting for my life yesterday in Duggar. They said so much stuff. I was like, do not do it, do not do it, do not do it. It's hard. Yeah, y'all already know it's going to happen and I haven't seen it. So I'm just thinking out loud and then y'all are like, shit's coming, it's coming.
Mr. Knight, did
Yes.
Ms. Vasquez provide?
Your shipping manager left
Oh,
to find
come on.
himself, leaving you lost. You need to hire.
I need indeed.
You with any information that anyone had testified to or said at any point?
No, she didn't talk about anything except for asking me my experience and just getting a clear understanding of what my experience was. She didn't mention anything outside of the scope of what I saw and just asked me for the facts and told me just tell the truth and let me know,
Do you know what any of the witnesses said in this trial?
about, outside of what I described earlier with the, a friend of mine texting that someone was talking about trailer palace, I do not.
Do you know whether any of the witnesses testified about any jealousy?
Other than the tweet that I replied to, no.
I'm glad to know that's at least working for me.
All right. Thank you. Your Honor, may we approach?
All right, well, do you have any questions? All right, sir, if you could have a seat back outside the courtroom.
Sure.
Thank you.
Can I leave my water?
Yes, you can leave your water.
His whole outfit is a vibe. I'm here for it. He is so cute. Yes, I love his outfit. Okay, yeah, that's true too. Oh, I forget I can fast forward. Let's see. Oh, we're still in the sidebar. Okay. Well, what's going on here? The hell?
Some matters we have to take up outside your presence, okay? All right, thank you. All right, your next witness. All right, Mr. Knight, if you could come forward to be sworn.
Do you solemnly swear or affirm to testify truthfully in this case or penalty of law?
Sir, if you can have a seat.
Wait, what? What? What's going on here?
Over the course of the build out of all the trailers, themed trailers, which I'm a huge fan of this hotel called Madonna Inn. And so I wanted to do really detailed themed trailers. It became too expensive to just make a living off of an artist retreat. So I decided before I was done to make it a hotel as well.
And what were your job responsibilities, generally speaking, when you owned
Y'all
the
see me
Hicksville
on
Trailer
camera. I
Palace?
swear I'm not the
So
coffer
I
in
would
Depp.
be
I
live-in
swear.
manager some nights, a couple nights a week. I would also drive out from Los Angeles twice a week and bring supplies that you can't get out in the Yucca Valley area and Joshua Tree. There's just a lot of things like, you know, Smart Finals, Costco's and stuff. So I would drive that stuff out. There's also no USPS. So sometimes I'd have to get things shipped to my house and drive them out as well. I would also just do constantly building and creating new stuff at Trailer Palace, whether it's new trailers or amenities. So I would be working on that stuff as well. I'm a big fan of the fact that Disneyland is always making it better and better.
And when you were the live-in manager, does that mean that you spent the night at the Hicksville Trailer Palace?
Yeah, we have a house on site where the recording studio was, and there's a bedroom in there. So whoever is live-in manager those nights stays in the house and basically lives there. There's a kitchen and everything.
Have you ever met the plaintiff in this case, Mr. Depp?
I had met him really briefly at the Viper Room in the late 90s. I had worked with some of the people that performed there and was good friends with this girl Robin from the Pussycat Dolls and some other
Of course
friends,
he
Miss
owns
Andy
it. Look how
Foster.
cute
So
he is.
I was
His whole
there and I
outfit
met him
and
once.
everything. Like,
how about Miss Heard?
He
Have you met
vibes
her?
perfectly.
I had
with
never
it.
met her before.
I love that.
They were guests at the hotel.
When was the first time that you met Mr. Depp and Miss Heard together?
In late May 2013, when they were guests, Mr. Depp's assistant Nathan had rent out the entire place so they could have a night there in privacy.
What do you recall, if anything, about Mr. Depp and Miss Heard's arrival to the Hicksville Trailer Palace?
Mr. Depp got lost, so his security guard who arrived early asked me if I could go fetch them because he had an old car that didn't really fare on the dirt roads out there, which are pretty horrible. So I went out and made sure that they got themselves and the car back to Hicksville safely.
Do you remember approximately at what time that was?
It was 3 to 4 in the afternoon.
What was Mr. Depp's demeanor when they first arrived?
At Trailer Palace, he was super excited about the place, really complimentary, just had a lot of questions and seemed like he was in a really great mood.
And how about Miss Heard's demeanor? Anything stick out?
She was pretty quiet. She just kind of didn't say that much when I was giving them the tour of the ground.
I leave for one day to go to Duggar, and I get accused of being the coffer in Depp, which I'm on camera, so y'all know I'm not, I swear. And 2, get accused of watching what I had FOMO over, even though I've got witnesses and an alibi, and I'm on security camera to prove it. I'm not trying to pull Amber Heard over here, but I am on camera to prove my alibi. Hilarious. I'm not the cougher. I swear to God. But I did cough once yesterday and dug her. But Judge Brooks coughed and everybody else was like, now's our chance. And then I got tickled because I kept thinking about the cougher and Depp. Oh, I love you guys.
In the trailer.
And was anyone else with Mr. Depp and Ms. Heard when they first arrived?
There was people that were arriving throughout the afternoon. So there was, I think 10 to 12 people total ended up staying. The security guard had gotten there earlier and just to check out the place. But yeah.
And did I understand your testimony previously that the entire trailer park was rented out by Mr. Depp and Ms. Heard?
Yeah, the whole place slept, I believe at the time, about 25 people, but there was only 10 to 12 in this party.
And who was part of that party besides Mr. Depp and Ms. Heard?
I'm really horrible with names, but I remember one of them was Ms. Heard's sister and the security guard I mentioned before, but I honestly forgot his name too.
What happened when Mr. Depp and Ms. Heard first came onto the property?
So I gave them a tour we give all guests a tour of their specific trailer and the grounds and show them around when someone rents the whole place, they get another trailer called the bar trailer, which is basically a place to set up their alcohol and stuff. And some people in the group were just putting their beverages in that area.
And where were you when Mr. Depp and Ms. Heard, did there come a time when Mr. Depp and Ms. Heard went to the bar trailer?
No, snitches get stitches, y'all.
Didn't
Snitches
notice most
get
of the time that
stitches.
my interactions with them, everything's kind of centrally located. So there's a fire pit, bar trailer, and picnic tables all right in the same area. So they were generally around that area the entire evening that I saw them.
And what did you observe of Mr. Depp and Ms. Heard as the evening progressed?
So Mr. Depp was just super curious and really nice. He was also really interested in my innkeeper because she was a musician, so they would talk about music a lot. At one point, the innkeeper who lived at the next door property went home and grabbed her guitar, and they had sung a song or two around the campfire in the early evening. There's another instance where Mr. Depp, the innkeeper, her name is Jenna, and myself were talking about books and music, and Miss Heard came over and kind of interjected. She seemed a little annoyed that Mr. Depp wasn't spending time with her.
What about Ms. Heard's demeanor made you think that she was annoyed?
I think just generally she, it's hard. Like I think, I don't know. It was just like a gut reaction. Like I can't describe it, but
How long were you with Mr. Depp and Ms. Heard that evening, generally?
So throughout the course of the evening, I was probably mostly with Mr. Depp, but 45 minutes to an hour total. So it was, that's over the whole course until the end of the night after the check-in.
And did you have an opportunity to observe Mr. Depp interact with other people, guests on the property that evening?
Yes, I saw him hanging out with his security guard at one point, and outside of the time that him and Jenna were sitting around the campfire,
I do buy that.
He was off by himself a lot of the time, and Miss Heard was over at the campfire with her friends and seemed to have a good time.
And if you haven't already, can you generally describe for the jury your observations of Ms. Heard that evening?
She seemed to be having a really nice time with her friends around the campfire.
Riverside FM is the easiest way to produce a high quality podcast, interviewing a guest.
I love that y'all know that I got a podcast, but don't need the help.
Did there come a time in the evening that you observed Mr. Depp and Ms. Heard have a disagreement or an argument?
Yes. I was speaking with Mr. Depp, just one-on-one, talking about Hicksville, and Ms. Heard came over and she said that, I want to talk to you, and seemed really upset about something. So I went and back in the house because it was really, they went off on their own, and she started yelling at him, and I didn't want to hear it. It honestly was really triggering because I've been in an emotionally abusive relationship before.
Objections.
Oh.
Move to strike.
What's the objection?
You're up. Maybe you're
Yeah, you have to have an objection. Move to strike. Why? You have to say, he's saying he did not want to hear it because it was triggering, because he's been there. Snaps for our homie. Looking fly as fuck in his 70 pants.
Mr. Knight, will you please just explain for us what you observed when you saw Mr. Depp and Ms. Heard having an argument?
Yes. So Ms. Heard asked him to go talk off to the side, and she was upset at him, and she was yelling at him.
Do I need to stay on this guy? Is there something in particular y'all are wanting me to see from this testimony, or do I need to go on to somebody else?
Objection.
Y'all tell me, because y'all saw it. I missed it.
Okay.
If you could just explain to the jury what you observed when you saw Mr. Depp and Ms. Heard having an argument.
Okay. He was kind of cowering and seemed almost afraid, and it was really like odd to see because he was older than her, obviously. So, but I just went back in the house because I didn't
Objection to what he did.
All right, I'll sustain this too.
Understood. So after you observed the argument, fair to say you went back to the trip to your house on site?
Yes, I did. Yeah.
What happened after that?
So when I saw Mr. Depp on my next rounds, he apologized profusely and said, "I'm really sorry about that." She was upset.
Objection, Your Honor, hearsay.
Sustain.
At least she knew the objection this time.
What, if any, type of reaction did Mr. Depp have?
He was just really...
Objection, Your Honor, hearsay. He's going to say it again.
It's the reaction. It's not the statement.
All right, if you could make that clear. That's
Yeah.
fine.
Just what type of physical reaction did Mr. Depp have after the argument between Mr. Depp and Ms. Heard?
He honestly, throughout the rest of the night, became a lot more quiet and was
Good bias check, for sure.
just very more petulant. In the beginning of the night, he was a lot more outgoing and extroverted, and throughout, as the course of the night went on, he was less and less so and more quiet.
Did you observe any of the guests consuming alcohol while on the property?
I assume they were. I mean, people had cups and there was alcohol set up in the bar trailer, but I didn't physically see them pour alcohol into the cup and cup go into the mouth per se.
Did you witness Mr. Depp drink any alcohol that evening?
I couldn't say.
Anything about Mr. Depp's demeanor that made you think he was perhaps intoxicated?
Yes, as the night went on, I am a former bar owner, so even though I wasn't drinking that night, I'm very familiar with the signs. So just as the night went on, like I said, he became more and more quiet, but he also, as we would have conversations, his head would kind of sway a little bit back and forth, which was a little, he was much less sharp than he was earlier in the night.
Did Ms. Heard appear intoxicated to you?
She did. She seemed, I think when she was angry at him, it seemed like she was intoxicated, but that's just based on my experience and my own personal trauma dealing with abuse.
Objection, Your Honor, move to strike.
All right, I'll sustain the objection. We'll strike it from the record. Please disregard that testimony.
But the jury still heard it, baby.
Did you
Damage
observe
is
anyone
done.
do or take drugs?
I did not.
Did you witness Mr. Depp and Ms. Hurd interact other than the argument that you previously described for the jury?
At the end of the night, I heard a commotion. I was inside the house and came out. I couldn't tell what was going on. And Mr. Depp and Ms. Hurd were having a discussion about I'm not sure what, but then they went to their trailer. At that point, a lot of people had already gone to bed. So it just kind of petered out. Everyone went to bed, including myself, and I didn't hear anything else the rest of the night.
What time did the evening come to an end?
I'd say it was almost around 3 a.m.
So nobody
Did you ever
knows
see
shit
Mr.
about
Depp
Buck.
grab
Nobody
anyone?
heard no shit about
Objection,
Buck.
leading.
Sustained.
Nobody heard
Did you ever see
anything?
Mr. Depp become physical with anyone?
Alright.
Objection, leading.
Sustained. Next question.
Did you ever witness Mr. Depp get angry that evening?
Objection, leading.
Sustained.
What, if anything, happened the next morning?
The next morning, we have checkout at noon at the time, before COVID. And
Well,
so
damn, that's what everybody
around
wants to
11
know.
o'clock, one of my innkeepers let me know that there was some damage.
Objection,
Okay.
hearsay.
Hold up. I gotta focus.
Did something happen that caused you to go to Mr. Depp and Ms. Hurd's trailer?
Yes, I was informed that.
Objection, hearsay.
It's not being offered
He's
for the
not
truth, Your Honor.
saying-
I mean, may we approach on this one
Okay,
topic?
sure.
Thank you.
He's so cute. His whole outfit vibe matches the I love it. I dig it.
The new best way
I
to
like
make
that
money
guy.
online that nobody's talking about is something you've never heard of before. Is
Yeah, because it's hard to make money online. Thank you, though. Did it not scare anyone else how well the ads know us all? Like,
What, if anything, happened the next morning, Mr. Knight?
let's go.
The innkeepers let me know that there was some damage in one of the trailers, and it happened to be Mr. Depp and Ms. Hurd's trailer. So I wanted to inspect the trailer because I was extremely worried. All those trailers that Steve and I worked on were like my babies.
Custom,
And
yeah.
the one they were staying in was the only one that was mostly original and restored 1950s style. And so I was very concerned.
Right, it's your property.
So
it's
what
your
did you
business,
observe
of
when you
course.
went to the trailer?
I observed that there was a light sconce by the bathroom in the bedroom that had been broken off the wall, and a couple people.
Time out. The sconce was the only other thing. What witness said that? The female. Somebody said all they saw was the broken sconce. So we just verified that. Let's continue.
Pieces were on the floor, and they were, and yeah, it was basically just broken. The light fixture was hanging on the wall still, and except for the pieces that were on the floor.
Did you come to understand how that happened?
Objection.
Is that it?
Foundation and
All right,
light.
foundation. I'll sustain as to foundation. How you knew?
Did you ask how the sconce was broken?
Objection, hearsay.
Sustained.
Yeah. Wait, is it just the sconce?
How often do light fixtures in the trailers break?
Is it just the sconce?
They break pretty often. I mean, it's not like a usual thing, but things in the trailers generally get broken
Shut the
because it's
fuck
all
up.
vintage
It's
trailers.
just the
And
sconce.
I would say as much as every couple weeks, there's some incident of damage in one of the trailers. In this case, Mr. Depp had told me that.
Objection,
Sustained the
hearsay.
objection.
Yes, shut the fuck
anyway,
up, y'all.
yes.
Beyond the light fixture, was anything else in the trailer damaged?
No, everything else looks fine. In fact, we have something we call a piggy fee that we address to guests, that if there's anything, what we call inconsiderate or unusually large messes, we charge them extra for it
As
for a
you should.
$25 an hour cleaning fee.
You should.
But they did not receive one of those because everything outside of light fixture looks fine.
And what was your reaction to seeing the damaged light fixture?
Why are
To be
you
honest, I
laughing,
was
bitch?
relieved because
That's
it was
helping you.
not a big deal. I just there was already another light in the room, so I just tucked the wires in the wall until I had a few months later time to
Why are you laughing,
it was
Herb?
matching sconce with another one in the room. So I had to on eBay find a matching pair that would fit there, and when I finally got around to it, I was able to get that and charge it to Nathan, whose credit card I had.
And what was your understanding of who Nathan was?
Mr. Depp's
asked
assistant.
y'all and everything.
And what did you
fun.
charge Nathan or Mr. Depp for replacing that pair of light fixtures?
The pair came out to $62.
Excuse me, what? What?
While you were on site, Mr. Knight, did you ever wear
Okay.
a mesh shirt?
Okay. So, wait, I want to hear the mesh shirt thing. Hold on.
No, I would absolutely never wear that.
At any time during Mr. Depp and Ms. Heard's stay on the property, did you see Mr. Depp become physical with anyone?
Why are
I
you
did not.
smirking?
Overruled. That's
I'm sorry, that answer was,
I never saw Mr. Depp get physical with anyone when I saw him.
thank you,
All
Your
right,
Honor.
cross-examination. Thank you, Your Honor.
Okay, do I want to see Cross or do I just want to go to Amber this morning? So we're just going to Amber this morning. Okay. 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 Let's do that. Good God. Again, I don't know why she's smirking because someone I think that worked for her knew her. I think that's who it was, the female witness that was there. Her acting coach, she said all she saw was a broken sconce. So him saying just a broken sconce, that's not good for her. Where we go. Trash the place, the damn $60 sconce. Good God. The audacity. Here we go. Freaking yard. Like, come on. I thought I fast forwarded enough, but I guess not.
Speculation.
overruled.
I am harassed, humiliated,
Should be.
threatened every single day. Even just walking into this courtroom, sitting here
That's
in
true.
front of the world, having the worst parts of my life, things I've lived through, used to humiliate me. People want to kill me, and they tell me so every day. People want to put my baby in the microwave.
Who
They tell
said
me
that?
Johnny,
The person that said that's more
Threatened.
sick than you are, but so
Promise.
they don't put them in the boat.
promise
with us.
me that if I ever left him, he'd make me think of him every single day that I lived.
Objection, Your Honor, non-responsive.
I'll sustain the objection as to that, if you want to ask the question.
Amber, how did Mr. Depp's statements and threats to you that you were discussing, how do
That's what
those
I was
continue to
thinking.
manifest themselves today?
In the harassment, in the humiliation, the campaign against me that's echoed every single day on social media and now in front of cameras in this room. Every single day I have to relive the trauma. My hands shake. I wake up screaming.
I have to live with the trauma and the damage done to me. My friends have to live with a set of unspoken rules about how to not scare me.
Objection, hearsay.
And not relevant, but all right.
Unspoken rules.
Not hearsay.
Good.
About how to not touch me, not to surprise me. My intimate partners have rules about how they can deal with me, how they can touch me.
Come on,
I
we don't
have
want to know
rules
about all your
for
intimate
doctors,
partners
and medical
friends and
professionals I
shit.
see, gynecologists I see.
Keep that shit private.
I live my life with these sets of rules that I have to follow, my friends have to follow for me not to have a panic attack or a triggering event where I relive the trauma. Even if I'm training to do my movie, for instance, if I'm training for Aquaman, a combat scene and a trigger happens, I have a meltdown and have to deal with that. The crew I work with have to deal with that because of the damage I walk around with every single day from what I've lived through, from what I've survived.
I'm just saying, there's certain things that are triggering that you avoid. So for me personally, I don't like to watch like someone get beat to death in a movie or something. Like if it looks like someone's gonna get beat to death in a movie, I don't watch that. So if something's gonna be triggering for you, I don't know why you would take the role because you do get the script, but I digress.
I'm not sitting in this courtroom snickering. I'm not sitting in this courtroom laughing,
Bitch,
smiling,
yes, you
making
are.
snide jokes. I'm not.
Girl, come
This
on.
is horrible.
Girl, come on.
This is painful. And this is humiliating for any human being
Sure is.
to go through.
We embarrassed for y'all. Every last one
Perhaps
of
it's
us.
easy to forget that, but I'm a human being. And even though Johnny promised that I deserve this and promised he'd do this, I don't deserve this. I want to move on. The statements, the attacks on me, the campaign, that Johnny has elicited millions of people
Objection, hearsay.
to do on his behalf when he himself
Objection, Your
couldn't
Honor,
do
lack
it.
of foundation.
Torture me.
Speculation.
I'll sustain the objection. Next question.
You're saying he started it?
Amber,
Nah, girl, we
How
got
have the Depp
two
Waldman
brain cells
statements
to rub
impacted
together.
your ability
We just teamed up.
to do charitable work?
We're not getting paid for it.
You know, the only reason that people like Dr. Curry can sit up here on the stand and say I'm high functioning and I do things like have hobbies and have interests is
Objection,
because I'm not.
non-responsive.
Your Honor, Mr. Depp gave long-winded responses yesterday.
Good. It's because I found a solution to that pain. I woke up every morning with panic attacks and trauma until I realized I could do something with it. So to answer your question, Ben, I was able to turn the things that I've lived through, my pain, my life experiences, into work, into action, into providing a voice for other people. I'm not a saint. I'm not trying to present myself as one, as you all know, but I selfishly found relief in being able to use what I've lived through to advocate for others, to bring light to these issues, to give a voice to people who don't have the voice and the platform that I have. And while I would not wish this situation on my worst enemy, if it gives a voice to someone who doesn't have it, but I now, as I stand here today, can't have a career. I can't even have people associate with me because of the threats and the attacks that they have to endure.
Objection,
when they are.
non-responsive.
And I can't do my charity work.
Sustain the objection.
Amber, other than the threats that you've described, what other threats have you endured since the Depp Waldman statements were made?
I receive hundreds of death threats regularly, if not daily.
To be fair, you played the Me
Thousands
Too movement, and
since
everybody
this
was on
trial
your
has
side at first
started,
for the
people
most
mocking.
part. Not everybody.
Mocking
But you used Me Too to get
my testimony about being assaulted.
Well, how do you know that?
Making fun of my
Objection, relevance.
And how do you know?
Non-responsive.
Thanks to damages. You can continue.
It's been agonizing.
Yes, it has. We've been here for 6 weeks. We know.
Painful, and the most humiliating thing I've ever had to go through. I hope no one ever has to go through something like this.
She literally stood on the back of the Me Too movement. She used the Me Too movement platform and stood on the back of survivors. Hey, y'all already know where I'm going with this, so I'll digress. But if you know, you know. And I think we all fucking know.
I just want Johnny to leave me alone. I just want him to leave me alone. I've said that for years now, and I thought he would after 2020.
Objection, non-responsive.
All right, I'll sustain objection. Next question.
What do you hope to reclaim after this is over?
Protecting the secret that I did for as long as I did has taken enough of my voice.
No, you've been pretty
Johnny has taken enough of my voice.
No.
I have the right to tell my story. I have the right to say what happened to me. I have the right to my voice and my name.
We know, girl. We know.
You took it long enough.
We know.
I have a right as an American to talk about what happened to me, to own my story and my truth. I have that right.
But you wrote the article.
I
we
hope
know.
to get my voice back. It's all I want. And I've said that from day one.
Thank you, Amber. I don't have anything else.
All right, cross-examination.
Get that tissue, girl. But use your finger instead. The fuck? Get some Germ-X. What did we just watch?
May we approach?
Yes.
What in the hell? Damn, if I knew today was only going to be a half day, I wouldn't have taken a nap this morning. I would have said, I'll take that 3-hour nap later in the afternoon. I didn't know it was a half day. So then I wake up to find out it's a half day. And now y'all have to watch it again, so I apologize, because I definitely would not have taken my nap this morning if I knew that it was only a half day. I missed you guys. Yeah, I told y'all Duggar was coming to an end, so wrapping that up is a full-time job in itself on top of covering this. I missed you guys so much yesterday, and the day before I took a half day, and I'll have to go edit some more. I'll have to edit some Duggar interviews and film the podcast, so I'll have to go do that later, but I definitely missed you guys. I'm blaming the Duggars for making me miss the party yesterday. But like, what in the hell did I miss? I mean, I knew that's how my life works. And I told you guys, I'm going to get off here and then I'll go to Duggar and all the good shit will happen. That's exactly what happened. But I mean, I didn't know it was going to be a throwdown showdown while I was gone the whole day. I mean, we couldn't get one boring witness while I was gone. It had to be an entire party the day I was gone. I heard y'all did hold down the fort. I hope y'all were good to Sierra, because she definitely had a lot on her plate managing y'all alone yesterday. And if you haven't caught on, the reason why Clint could not do it for us, because of course he would have, was because he met me at the courthouse at 5 a.m. So Clint was with me yesterday at Duggar sentencing, which is why he could not do it for us. So Sierra took one for the team yesterday, hardcore. Yeah, honestly, this group is great. I can't believe, I'm sad I missed it. I had serious FOMO, but I heard it Everything was fine. No, there was no issues, and I love that. Look, she's texting, what the fuck have I got myself into? This shit's fucking wild. Oh shit, yeah, I can fast forward. What am I doing? I do this, y'all, with pre-recorded TV shows too. My husband's like, babe, you know you can record, you know you can fast forward. This is recorded. I was like, oh, oops. I'm the worst with that kind of stuff. Damn, how long were the sidebars?
You who was yelling at Mr. Depp.
Again, I've heard a lot of people say a lot of things to be involved in the Johnny Depp show, but
Girl,
he
no.
wasn't there. He doesn't know. And he certainly doesn't know what happened behind closed doors, like most people.
So you're calling Mr. Knight a liar?
What?
I am saying he wasn't there, and what he testified to doesn't match what I know happened.
Girl.
But I don't fault him. He wasn't there, so how would he know?
He testified he was there, Ms. Heard. Did you hear that?
That's
No,
his
she
testimony,
didn't.
yes.
So you're calling him a liar?
No, she didn't.
I'm just saying he wasn't there.
You heard Mr. Knight testify that the trailer wasn't trashed.
No,
Why?
she did not. No, she did not. I rewound.
Ms. Heard, you just testified that this case has been very hard for you.
The man
So let's
fucking
talk
owns the
about that
place.
and why.
All right.
Your lies have been exposed to the world multiple times, right?
So have.
I haven't lied about anything I've been here to say.
You sat here and told this jury that the events in Hicksville started with Mr. Depp getting really upset about a woman leaning on you. Is that correct?
Yes, that's effectively what happened, yeah.
You testified that he actually grabbed that woman's wrist and twisted it, right?
I'm sorry. They evacuate the courtroom? They kick people out of the courtroom for laughing? What? Damn, I missed everything.
And told her that he could effectively break her wrist by saying he knew how many pounds of pressure, or asking her how many pounds of pressure it took to break a human wrist.
But your own witness, your former best friend, Rocky
Really was a
Pennington,
party. Holy
she didn't
shit.
corroborate that, did she?
I'm not quite sure what part of that night she saw. There were a lot of people there.
Huh?
She didn't testify that Mr. Depp grabbed anyone's wrist in Hicksville.
Again, I don't know what Rocky saw. There were a lot of people there that night.
You testified that once you brought Mr. Depp back to your trailer, he trashed it, correct?
That is correct.
And the manager of the Hicksville trailer park was furious that Johnny had wrecked the whole thing. Do you remember that testimony?
That's correct.
Well, we heard from that manager of the Hicksville trailer park, Morgan Knight, on Monday, didn't we?
I'm not quite sure who that guy was or if he had any involvement in this. I know a lot of people have come out of the woodwork to be involved.
So you're accusing Mr. Knight of testifying and committing perjury?
I'm not accusing anyone. I just don't recognize that man.
You heard Mr. Knight testify that it was actually you who was upset with Mr. Depp spending time away from him.
Does she not recognize him because he was not worthy of her recognition? I mean, he owned the place and worked there, but maybe she just thought he was a worker. Like, he was the one on staff staying there. The one.
Isn't that correct?
How would he know? He wasn't there.
Girl.
You heard Mr. Knight testify that it was actually
Look at
you who was
Ben.
yelling at Mr. Depp.
Look at my boo over here on the
Again,
right.
I've heard a lot of people
He's
say
like,
a lot of
"Come
things to
again?"
be involved in the Johnny Depp show, but he wasn't there. He doesn't know. And he certainly doesn't know what happened behind closed doors, like most people.
So you're calling Mr. Knight a liar?
I am saying he wasn't there, and what he testified to doesn't match what I know happened. But I don't fault him. He wasn't there, so how would he know?
He testified he was there, Ms. Heard. Did you hear that?
That's his testimony, yes.
So you're calling him a liar?
I'm just saying he wasn't there.
You heard Mr. Knight testify that the trailer wasn't trashed, and that's why you're calling him a liar.
He testified that a light fixture was broken, similar to the way that
Yes,
Johnny's
other than a light
employees
fixture, that was
testified
the
to
only
my
thing that was
closet
broken,
being
right?
rearranged
Ms. Heard,
and things
Ms.
like
Heard,
that.
the only thing that was broken in the trailer, according to Mr. Knight, was a light fixture? Yes or no?
And
I realized that he summed it up by saying a light fixture was broken, just the way his security guard summed up him trashing my closet as being rearranged.
Your Honor, I'm going to move to
Girl.
strike everything after he summed it up, that it was a light fixture as non-responsive.
She answered the question, Your Honor.
Overruled.
In the security guard testimony, Your Honor?
Go ahead.
Mr. Knight also testified that he charged Mr. Depp only $62 for the damaged light fixture. You heard that, correct?
I did.
In Hicksville, you were the only one that was jealous that Mr. Depp was spending time from other people. Isn't that correct, Ms. Heard?
That is incorrect.
Time out.
In Hicksville, you were the one who was upset that Mr. Depp.
This bitch has an ice cold heart, and I need a motherfucking space heater. So everybody, just hold on, because I'm freezing. Just hold still. Okay, got my space heater so I don't freeze. Space heater, check. Blanket, check. Dr. Pepper, check. A snack, check. Let's go.
That wasn't giving you enough attention.
Incorrect again.
Ms. Heard, you told this jury that you had no idea the press was going to be at the courthouse when you got your TRO on May 27th, 2016. Do you remember that testimony?
Okay.
I said I did not have anything to do with it. Yes.
No. My question again. You told this jury that you had no idea that the press was going to be outside after you got the ex-parte TRO on May 27th, 2016. Do you remember that testimony?
I apologize. I must have misunderstood Ms. Vasquez. I actually had no idea whether they were going to be there or not. When I walked into the courtroom that day, it was completely quiet, still, empty. Even though I had given Johnny's team notice that I was filing the
Objection.
TRO,
Your Honor, this is not
we had no
responsive.
reason to
Move to
believe the
strike.
press knew.
And Your Honor, I would also ask that you instruct the witness to please stop talking once I lodge an
Yes,
objection.
no.
Your Honor, she's trying to answer the question as best she can, and Ms. Vasquez is misrepresenting to her what she testified.
That, no.
I'll strike the last part as non-responsive. Just if you could just answer the questions asked. Okay, thank you, Ms. Heard.
In fact, you testified that you were, quote, shocked when you saw press when you were leaving the courthouse. Yes?
Yes.
You weren't shocked at all, though, were you?
Incorrect. It was.
You knew the press
horrifying.
would be at the courthouse, right, Ms. Heard?
No.
Well, you did bring your publicist to the courthouse with you on May 27th, 2016, didn't you?
I sure did. I'm a public figure. I brought my publicist in case it blew up.
A girl
in
quit.
case.
Girl
You actually
quit.
had
I did.
alerted TMZ
Girl,
that you would be
nobody-
filing a TRO against Mr. Depp
Girl,
that
nobody
very
went
day,
to the
didn't you?
courthouse. Everybody knows
I
that.
did
The
not.
one day you didn't bother to wear makeup to cover up the mark on your face.
Girl.
I did not call TMZ or any other news source or paparazzi source. No one.
Well,
I
we
never
heard
did that.
testimony from former TMZ employee Morgan Tremaine yesterday, correct?
Did I hear his testimony?
Yes.
Yes, I was here.
Yes. And you heard Mr. Tremaine's testimony that he knew to dispatch the paparazzi to the courthouse on May 27th, right?
I heard him say that he knew that, yes.
Yeah, and that he dispatched paparazzi to the courthouse to capture a picture of an alleged bruise on the right side of your face. Do you remember him saying that?
I remember him saying that.
That information must have come from your team, right, Ms. Heard?
Absolutely not. Why would I want that? What actual survivor of domestic violence wants that?
Now, the video of Mr. Depp beating up some kitchen cabinets, you admit that you took that video, correct?
Yes, I did.
And you acknowledge that the video was released online the day before you were deposed in connection with your divorce from Mr. Depp in August of 2016, right?
I believe it was, yes.
But you testified that you had absolutely nothing to do with the video's release, right?
Absolutely not.
And you testified that you learned about it when you landed after flying into LA. Do you remember that testimony?
Upon touchdown is when I was alerted to the video's
You
existence
heard Mr.
online.
Tremaine testify that about this video as well yesterday. didn't you?
Yes, I did.
And you heard Mr. Tremaine testify that TMZ received the cabinet video the same day you landed at LAX, yes?
I don't know if I don't know if that's what his testimony was. I'm sorry.
You heard Mr. Tremaine testify that the cabinet video was posted 15 minutes after TMZ received it, yes?
That's what I heard him say.
And that this could only have been possible if the video was received directly from the source, yes?
I heard him say that. I don't know if that's true or if that's possible because
And
it
you
didn't come
heard
from me. I was
Mr.
flying.
Tremaine
So
testify.
I know that's incorrect is what I mean to say.
Another liar on the stand.
Yeah,
I just know
everybody
that
but you,
that's incorrect.
Right.
Get her, Camille.
And you heard Mr. Tremaine
Tell her.
testify that TMZ owns the copyright to the cabinet video,
I love
right?
that Camille said that shit.
That's
Tell
news
her.
to me.
The cabinet video you filmed of your then husband, yes?
The copyright ownership of that is news to me. I learned that yesterday.
Girl.
It's the cabinet video that you captured of your then husband, yes?
That is correct. I did capture that video, and
The
yes,
cabinet
that was
video-
my husband.
The same cabinet video that was released the night before you were deposed in your divorce, yes?
That's correct.
You must have also heard Mr. Tremaine testify that the version of the cabinet video that TMZ received was incomplete compared to the video the jury saw in this trial. Did you hear that?
The video that that you have seen is complete.
Right. But the one TMZ got the day before your deposition in the divorce was incomplete.
I don't know. I haven't seen it.
He testified that at the beginning portion of the video where you set up the camera, that wasn't included in the video that TMZ received.
I don't know what video TMZ
I'm talking
received.
about Mr. Tremaine's testimony, Ms. Heard. Let's just
So you're
focus on
asking me to
Mr.
repeat
Tremaine.
his testimony?
No, I'm asking you if you recall hearing him say those words to this jury.
Yes,
Under oath.
I heard his testimony. We all did.
And he testified that at the end of the video, where you can be seen smirking. I know you testified earlier that you haven't been smirking in this trial, but you sure were caught on camera smirking in that video.
I disagree with that.
Was also not included in the TMZ video.
Everyone can watch that video and you can determine whether you think it's funny to me or not.
That's because the video came from you, right, Ms. Heard?
No, it did not.
You
That
edited
video
out
did
the
not come to
portions.
me.
Ms.
That didn't
Heard,
come from me.
Ms. Heard, you edited out the portions that made you look bad before sending it to TMZ.
You're very wrong about that.
So
If
that
I
only
wanted to
Mr.
leak
Depp
information, I
looked
could have
bad.
done it in a more effective way, a lot sooner and a lot more.
Because you
I
knew
was
exactly
living
how
with
to
a
do that,
mountain
right?
of this evidence. If I wanted to leak it, I could have done a lot more with it.
That you testified earlier in this trial that you didn't know how to leak things.
I don't.
Oh my God, Camille, get her!
You edited that video before you gave it to TMZ so that only Mr. Depp would look bad.
Holy
Yes?
shit.
That's absurd.
Right in the middle of your divorce proceedings.
Again, you're very wrong.
Holy shit. Get her, Cam Bam.
I'd like to show you a picture from that's already admitted into evidence. It's Defendant's Exhibit 799.
Damn. Damn.
This is you at the courthouse on May 27th, 2016, when you got your domestic violence restraining order against Mr. Depp, right?
Damn.
It is.
And next to you is a woman named Jody Gottlieb, right?
Yes, yes.
Jody Gottlieb is your publicist.
And dear friend.
Now I'd like to show you what's been marked as Plaintiff's Exhibit 1316.
Is all your friends on your payroll? They're living for free.
This is a picture of you and your friend Rocky Pennington, right?
Camille
That is
fucking
correct.
killed that shit.
Your Honor, I'd like to move to admit this photograph.
Any objection to 1316?
Cam Bam.
No, Your Honor.
All right, 1316 in
Get
evidence.
her,
We'll
girl.
publish the jury.
This is a picture of you on May 28th, 2016, right, Ms. Heard?
I don't know when this was taken.
This is the day after you obtained the domestic violence restraining order against Mr. Depp, right?
I have no idea when this image was taken. I did not take it.
There's no bruise on your face in this picture, is there?
Again, I don't know when this was taken. And also, I'm outside. I was obviously wearing makeup. I have no idea when this was taken. So I have no
Girl,
idea if I can
let's
speak to
refresh your
what
recollection.
bruise you can
Let's
see or
refresh
not.
your recollection about
Obviously wearing makeup. Obviously wearing makeup. Okay.
when this picture was taken. Can we please pull up Plaintiff's Exhibit 1315, just for the witness? This is an article dated May 30th, 2016, right, Ms. Heard?
That's what it says, yes.
And this article contains the same photograph of you and Miss Pennington we were just looking at. Yes?
Yes, I see that.
And the article is entitled Amber Heard Smiles as She Puts Arm Around Friend One Day After Getting Restraining Order Against Johnny Depp. Is that what the title says?
I know that's what the title says, yes.
Your Honor, I'm going to move to admit and publish the article with everything but the headline and date and the photo redacted.
Objection, Your Honor. That's inconsistent from the way you treated all of these.
I'll sustain the objection. All right, next question.
What in the fuck?
Let's take a look at picture Plaintiff's Exhibit 1317. This is also a picture of you and Miss Pennington on May 28th, 2016, isn't it?
I don't know when this photo was taken, but it looks like the same outing as the picture prior.
Your Honor, I'm going to move to admit and publish Plaintiff's Exhibit 1317.
Any objection?
No, Your
All
Honor.
right, 1317 in evidence, you can publish.
There's no bruise on your face in this picture either, right?
I disagree. If it is taken when you represent it was taken, then obviously there's a bruise on my face. It's covered by makeup as per usual.
Girl, you're not wearing any makeup there. Come on.
Let's zoom out of that picture for a moment, please.
Come on.
Thanks. That's Josh Drew in this picture, right?
Yes, that's correct.
And Miss Pennington
That is correct.
in there too?
That
Ms.
is
Pennington submitted a sworn statement on your behalf in support of your domestic violence restraining order, didn't she?
I believe she did, yes.
Mr. Drew also submitted a statement in support of your domestic violence restraining order.
I believe they both did, yes. Mhm.
Mr. Drew, I'd like to show you Defendant's Exhibit 512, which is already in evidence.
I prefer when it's like this because I can think.
You've seen this photograph before, right?
I have.
On the second day of your direct testimony, you testified that this was taken in the downstairs of the main apartment on December 15th, 2015. Do you recall that testimony?
Yes, I believe so.
So it's your testimony that Defendant's Exhibit 512 reflects damage to Penthouse 5 that occurred during the December 15th, 2015 incident. Yes?
I'm not quite sure from what incident this is when I see this photo in a vacuum without context.
Let's give you that context.
Wait, what?
Can we please, thanks. I could have day 16 trial testimony.
What? Hold on, I gotta focus.
All right.
Let me eat my chip.
Could you please turn first to page 4585?
Okay, I'm getting ready. And I told y'all those spill marks don't look like spill marks weeks ago. Anyways, let's go. I'm not looking at the comments.
Specifically on,
Just raw
starting on
Washington.
line 16, where it says, let's talk about December 15th, 2015.
You said 458. Oh, four. I'm on 4485.
Hold on,
Sorry,
I need
you
a
said
pen.
4584.
4585.
Pardon.
Line 16. Line 16, where it says, let's talk about December 15th, 2015. You see that?
Yes.
And then do you see that your testimony about December 15th, 2015 follows?
Let's see. It's just the first line or two. Yes.
Okay. Now I'd like you to turn to page 4603. Starting at line 12. 4603. starting at line 12 and going on to page 4604, line 4.
Okay.
And do you see that you testify that defendant's exhibit 512, which is on the screen,
Yes,
is a picture of the downstairs of the main apartment?
that's correct.
And the main apartment is penthouse 5 in the Eastern Columbia building, right?
No, well, depends on what, the main apartment's penthouse 3 generally when we say main apartment.
Penthouse 5 was where you had your closet?
The downstairs was kind of like had some of my painting studio set up and a reception area. Upstairs was the closet.
Got it.
Mezzanine office was in between.
All right, so it's your testimony that defendant's exhibit 512 reflects damage to the penthouse 5, that occurred during the December 15th, 2015 incident, right?
I'm just not sure from which incident this is a picture of, since I'm only looking at
Even
a
though your
partial
counsel
floor.
was asking you questions about December 15th, 2015, and then admitted this picture into evidence
Again,
in relation to that incident.
Sorry, go ahead.
In relation to that incident on December 15th, 2015. This exhibit, defendant's exhibit, you are the defendant, number 512, was admitted into evidence in this court. You testified that this was a result of damage that occurred on December 15th, 2015. Yes or no?
I just need to orient myself because I'm just looking at a picture of
Girl, it's
partial
defense
No,
picture of
Ms. Heard, you didn't just
So
look
I
at a
can't.
picture.
It's
You
defense
looked at your
exhibit.
testimony.
You
I-
submitted
you
it, babe.
Pointed me towards the page and then asked me a question. I haven't actually reviewed it. I don't know if this was submitted
babe, she
in
said
relation to that incident.
Okay,
Let's pull up,
that's what she was
let's actually
showing
leave
you,
out defendant's
stupid.
512 and please pull up defendant's exhibit 725, which is already in evidence
Thank you.
in redacted form, Your Honor.
All right, thank you. You can publish.
Just side by side.
Passing my first illegal.
You've seen this
thing.
photograph as well, right?
JK
I
is
have.
totally legal. I'm being a dick.
On the third day of your direct testimony, you testified that this photograph reflected spilled wine in Penthouse 5 on May 21st, 2016, didn't you?
Again, I don't know because I'm looking at a partial picture of a floor. So unless you remove the metadata you've covered up, we could then tell. If you
I didn't
remove-
cover it up, Your Honor.
Could we
Your
unredact
Honor,
them so we could get context?
That's how it's in evidence.
That's how it's in
All right.
evidence.
Next
Well,
question.
metadata next to it is so that.
Ms. Heard,
Girl.
Ms. Heard, there is no question pending.
Girl.
And I would appreciate it if you wouldn't be making argument to the jury.
Sorry, I thought you had asked me about it.
Girl.
No, I didn't ask you about anything. Let's look at your direct testimony from the third day.
Oh, shit. She literally is giving her the daily transcript. Page 4,603, line 12. Like, girl, you said it on there. And it's defense exhibit.
Thank you.
So you submitted the picture as defense exhibit for a
Thank you.
reason. And the metadata is missing because you fucked it up. You didn't submit stuff. And when you did, it was corrupt.
Let's
as
turn
well.
to page
Come on now.
4750 in day 17 transcript.
Sorry, can you repeat that?
4750.
Okay. Let's go. Mhm.
Specifically line 16.
Lines, okay. In the transcript, I got it.
Do you see where Ms. Bredehoff asked you to describe for the jury what took place on May 21st, 2016?
I see that.
Damn, she's about to
And do you
mark
see
her.
that your testimony is reflected about May 21, 2015?
Oh, God. She's
Yes.
about
That
to mark her
follows?
ass.
Yes.
Now let's turn to page 4804
4804. Damn, she's about to mark her
at
ass.
line 14. 4804. Starting at line 14
Yes.
through 4805, line 4.
Damn. Damn.
Going to what line?
Nobody
Line
else
4
caught this.
at
Elaine, come on.
4805.
Nobody
Do you see that you're
caught this.
testifying that defendant's exhibit 725, which is reflected on the right side, reflects spilled wine on the floor in penthouse 5?
Oh,
That's correct.
Okay. And defendant's exhibit 512 and 725 seem to be different versions of the same picture, don't they?
That's correct.
Oh, my God.
So which is it? Which one was taken on December 15th, 2015?
Oh my God.
Or May 21st, 2016?
If you remove the redacted metadata, you can find out.
Bitch, girl, no you didn't.
It's right there.
Or if you're telling the truth, you would know.
Recognize a portion of of spilled wine on a floor, and I'm supposed to know off the top of my head when you've lived through 5 years of this stuff? I don't think so. That's not how that works.
No. You're not supposed to know off the top of your head. It's a defense exhibit. You submitted the exhibit. Your team submitted the exhibit. It's a defense exhibit, which means that you submitted that exhibit so that you could show it at trial and discuss what it is. And your dumbass fucking submitted the same photo twice and then tried to sell it in a courtroom as 2 different days. And the metadata is not there because you fucked it up. What in the literal fuckery fuck shit is this?
Thank you, Todd. Ms. Heard, at the beginning of your cross-examination last
Your Honor, may
week.
we approach?
Yes.
No. That's everybody's fault. That's the whole defense team. That's on y'all. Let her give 2 separate testimonies about the same picture that looks clearly identical. And this is why I say that if I was on the jury, exit data matters. I'm going to make somebody prove their case. Okay, I'll tell you right now, I'm going to make somebody prove or disprove their case. And the fact that we have exit data redacted on every single picture, to me alone, no matter how compelling something is, there's no excuse for there to be no exif data on any of the photos. And that alone, I would just say, would be enough doubt for me to be like, I don't know that I can't verify these pictures. They fit the story and the narrative you're telling, but you don't even have exif data for any of them. No. That's it.
Ladies and gentlemen in the gallery, I would ask that there be no words or no phrases, no words, no sounds at all coming from you. If I hear one more sound, I will clear the gallery and we will continue this testimony without anybody in the courtroom. Understood?
Oh,
good.
Shit.
All right, your next question.
Everybody's in trouble.
Ms. Heard, at the beginning of your cross-examination last week, I showed you an audio where you told Mr. Depp to tell the jury, tell the judge, tell the world that he is a victim of domestic abuse. Do you remember that?
That's correct.
And you testified you found it hard to believe that Mr. Depp would tell the world that he's a victim of domestic abuse, didn't you?
Don't lie.
I said I find it hard to believe that he would do that knowing that he himself had beat me up for 5
Girl,
years.
you say
But he has told the world
that
he's your
audio.
victim of domestic
We
abuse,
have
hasn't he?
audio.
Well, he started to say that only recently. He didn't make that claim up until very recently. So when we signed our divorce agreement and we signed a statement saying that neither party had ever said false claims for financial gain, it was relevant and important to me because I was the only one making the accusations. I was the only one making those claims. He wasn't doing that at the time. And he signed his name to it.
You didn't expect as many
That's a
people to show up and
settlement, girl.
testify
Don't
on
play
his
me on the
behalf.
settlement.
That did you?
Do not play me on
Incorrect.
the fucking settlement, bitch.
When you told this jury under oath that you never assaulted,
Don't do it.
actually, strike that.
Let's not.
When you told this jury under oath that you punched Mr. Depp because you thought of Mr. Depp pushing Kate Moss down the stairs, you didn't expect Miss Moss to agree to testify that never happened, did you?
Incorrect. I know how many people will come out of the woodwork to be in support of Johnny.
So you think
Clear
Miss
by this
Moss
courtroom
needs
how
to
many
come
people
out
will
of the
do that.
woodwork to testify for Mr. Depp?
Everybody who was around in the 90s and the early aughts knew that rumor. I had heard that rumor from multiple people.
Nobody
of course,
had
that's what
ever
flashed
heard
through my
that
head
rumor
when my
until
violent
you said
husband
it.
not only swung for me, but all of a sudden swung for my sister. Of course I thought of that. I did not expect her to show up or not expect her to show up. It didn't matter.
I
It
bet
doesn't
you
change
fucking
what I
didn't.
believed at the time when we were on the stairs and I thought he was going to kill my sister by pushing her down the stairs.
Now, hold on.
You
Now,
told
this
this
is-
jury
we're gonna-
under oath that Mr. Depp was aggressive.
Now, we're going to have to clarify something. It is about what is perceived to be true. There's a bias check for you. It is about what she perceived to be true. But now, that being said, why would you have perceived that to be true when no one else fucking heard that shit before? Like, nobody's heard that story. If that rumor was going around in the 90s, it would have been slapped all over every fucking 17, People Magazine, you name it. If that rumor was really going around, come on. In the 90s, listen, we grew up on Eminem, honey. We talked about shit in the 90s. Like, no. So, though it is about what she perceives to be true, that is fair. That's true. I give her that. Why would you have ever perceived it to be true? You're the only ones telling that fucking story.
And trashed a trailer in Hicksville. You didn't expect the manager of the Hicksville property, Morgan Knight, to come forward and testify that that was untrue, did you?
Incorrect. I've already been through trials with this man. I know how many people will come out in support of him.
When you told this jury under oath that you had no idea that the paparazzi would be at the courthouse on May 27th, 2016, you didn't expect a TMZ employee to show up to testify that TMZ had been alerted that you would be at the courthouse and knew exactly which side of your face to take a picture of, did you?
I know how many people will come out and say whatever for him. That's his power. That's why I wrote the op-ed. I was speaking to that phenomenon. How many people will come out in support of him and will fall to his power? He is a
Hold up. Now, well, we got a critical thinking issue here. We got a situation. We got a critical thinking situation here. Did you write the article for Me Too movement, speaking out against sexual violence and domestic violence and all that stuff? Or did you write the article? What did she say again? Let's just rewind this view. What are we at here? 4:18:11. Let's do. Why is it backwards numbers? Okay, we're at 4:19. So let's just go back. Let's hear that one more time.
What about that?
Yeah. But you didn't expect Mr. Baruch to weep.
What the hell happened there?
For Mr. Depp.
Of course, that's what flashed through my head when my violent husband not only swung for me, but all of a sudden swung for my sister.
In this trial, fake.
What the hell?
I have seen people do this time and time again. That's why I wrote the op-ed.
You didn't expect Ben King, the house manager in Australia, to show up from England. He flew from England.
The only one making those claims. He wasn't doing that at the time. And he signed his name to it.
You didn't expect him for committing perjury.
Excuse me.
Ms. Moss needs to come out of the woodwork to testify for Mr. Depp.
Everybody who was around in the 90s and the early aughts knew that rumor. I had heard that rumor from multiple people. Of course, that's what flashed through my head when my violent husband not only swung for me, but all of a sudden swung for my sister. Of course I thought of that. I did not expect her to show up or not expect her to show up. It didn't matter. It doesn't change what I believed at the time when we were on the stairs and I thought he was going to kill my sister by pushing her down the stairs.
You told this jury under oath that Mr. Depp was aggressive and trashed a trailer in Hicksville. You didn't expect the manager of the Hicksville property, Morgan Knight, to come forward and testify that that was untrue, did you?
Incorrect. I've already been through trials with this man. I know how many people will come out in support of him.
When you told this jury under oath that you had no idea that the paparazzi would be at the courthouse on May 27th, 2016, you didn't expect a TMZ employee to show up to testify that TMZ had been alerted that you would be at the courthouse and knew exactly which side of your face to take a picture of.
Did you posed for it?
I know how many people will come out and say whatever for him. That's his power. That's why I wrote the op-ed. I was speaking to that phenomenon. How many people will come out in support of him and will fall to his power? He is a very powerful man, and people love currying favor with powerful men.
Currying
I know
favor
that
and
firsthand. I've
risking
lived
jail
it.
time for committing perjury.
Girl,
Excuse
come
me?
on.
I didn't hear your question.
You didn't hear
Excuse
my
me.
question?
Ms. Vasquez, if you do mind,
Curry-
please just repeat the question. I didn't hear you.
Curry favor and commit perjury in this courtroom
I have
for a
seen people
powerful
do this.
man?
I have seen people do this time and time again.
Girl,
That's
come
why
on.
I wrote the op-ed.
You didn't expect Ben King, the house manager in Australia, to show up from England.
Okay.
He flew from England to testify that Mr. Depp's fingertip was found exactly where he said it would be. Did you?
I have never heard Johnny testify to knowing where his finger was, or really, frankly, making a claim that he knew where it was when it was found. I've never heard Johnny claim that.
You didn't expect
Johnny
King
doesn't-
and Wyatt.
Johnny has never
Ms.
actually
Heard.
said that.
Ms. Heard.
And
I think the
Ben
jury
King,
can,
yes.
Ms. Heard, there's no question pending. You didn't expect Keenan Wyatt, Mr. Depp's longtime sound technician, to show up and testify that Mr. Depp is not being fed lines through his earpieces, but instead music, did you?
You know what the problem is? The problem is she stood on the back of survivors and the Me Too movement and the sociology of that time period and how things were going on. And she knew not only the damage that it would cause, but the damage it would cause if you were to back him in the midst of all that, which that's sad in itself because, you know, the truth is the truth. I don't care about the rest of it, but is she not expecting them to come forward because she thought they'd get crucified in the middle of the Me Too movement? I got questions.
Not that it matters much, but of course I did. I know how his employees treat him.
So you
I know how
probably-
his team treats him. Of course I expected that.
Okay, so you probably expected Isaac Baruch to come and testify for Mr. Depp, right?
I'm not sure I thought about that.
Yeah, but you didn't expect Mr. Baruch to weep for Mr. Depp after what you've put him through and so many others with your lies.
I
did you?
relate to Isaac because he and I are
There's
the
no
only
further
ones who
questions, Your
cried
Honor.
on this stand.
Nothing further.
All right.
Girl, no, you
Redirect.
didn't. Girl, no, you didn't. No, you didn't. No, you did not.
Thank you, Your Honor.
I relate
Ms.
to him
Hurd,
with
if
the only
if
ones that
Mr.
have cried on
Baruch
this
felt
stand.
misled, who misled him?
Johnny, and I don't blame him. I don't blame him from crying. This is horrible.
Ms. Vasquez has suggested that you faked bruises on your
Come on.
face. Is that true?
Absolutely not. I didn't need to.
Did you ever fake an injury caused by Mr. Depp?
That's true.
No.
Is any of the evidence of your injuries that has been put to the jury in this trial fake?
No, absolutely not.
And to the extent that there may be some confusion over when a picture of spilled wine was taken, why might that be?
Objection.
Because there's so-
Objection. You submitted them as two different defense exhibits with two different narratives, so that's your own fucking problem. Y'all should have talked
The
about it.
foundation.
Overruled.
Because there's so many incidents of violence. There's so many pictures. There's so much evidence. Most people don't have this kind of evidence for years, 5 years. And when I was saying that to Johnny on the phone in that recording, I was saying for years, this has been going on. And I have pictures, we have texts, we have everything. Normally you don't get this amount of evidence. That's what I was pointing out to Johnny. It would be crazy to
Y'all.
try to challenge this in this way. It's crazy. It's easy
It is crazy
to
you're
not know the
challenging
context of
everything in this way,
a picture
girl.
of
It
spilled
is.
wine because there are so many more important details, pictures, and also so much I didn't photograph, so much I didn't have the presence. of
Objection,
mind to document.
non-responsive.
All right, I'll sustain the objection. Next question.
Did Mr. Depp abuse you physically,
Yes,
verbally,
yes,
emotionally,
yes,
psychologically?
yes.
How did the threats that Mr. Depp made against you individually years ago resemble what you've endured as a result of the Depp-Waldman statements?
Beyond the scope of cross, Your Honor.
Overruled.
Johnny promised me he would ruin me, that he'd ruin my career, he'd take my life from me. Death was the only way out. And if I got out, this is what he'd do to me. He'd make me think of him every single day. He promised me global humiliation. You saw those texts. What he couldn't do, the work of one individual, meaning Johnny, when he was inviting a disgruntled employee over for a spot of purple to fix my flabby ass up, that revenge that he sought back then was just what he could do as an individual, calling the studio to get me fired, trying to block him.
Objection, Your Honor. Lack of foundation, speculation,
It's
hearsay,
all in
non-responsive.
I'll sustain it as a non-response.
Ms. Hurd, how did those things that you just testified to that Mr. Depp did, how did those resemble what happened to you after the Depp-Waldman counterclaim statements were made?
Oh, come on.
Those are
Objection, Your
just-
Honor. Lack of foundation.
She's
Overruled.
Thank you.
Come on.
Thank you, Your Honor.
Those are just an echo of what I'm living through today. It's like what I'm living in right now. What you see in this courtroom is an echo. This courtroom and the other courtroom he dragged me into to do the same thing again.
Girl.
That's just an echo of the violence and the abuse that I suffered within our relationship. The campaigns to have me fired, the blocking me to try to ruin my career, the threats he's made to humiliate me globally are being lived out in real time in front of you, ladies and gentlemen, for the past 6 weeks. And for the whole
We're here,
world
we know.
since our camera's here.
We know.
No further questions. Thank you so much, Amber.
All right, Ms. Hurd, you can have a seat next to your attorneys. If I could have the attorneys approach.
Come on. Like, she does know that we all are watching, right? Like, we heard it. Like, I'm choking on a Pringle, y'all. I swear I'm not the cougher. I'm on camera, y'all would know. Okay, so are we done? I guess we're done because she's done. I mean, what a mess. What a mess. Y'all know I'm not the cougher. I'm on camera. It can't be me. Okay, pull up Heard's data guy from across this morning. Never gonna live this down. I'm choking on a Pringle. I'm never gonna live this down. Okay, let's see here. Right here.
Richard Stephen Gilbert. And what is your occupation? I am an orthopedic surgeon and I have a subspecialty training in surgery of the hand and upper extremity.
I don't know if I need that.
Dr. Gilbert.
And published on data preservation.
Fingers.
Oh, here
No
we
further
go.
questions. Plaintiff rests, Your Honor.
All right, plaintiff rests the rebuttal case. All right. Defendant counter plaintiff rebuttal case. Sure.
Computer forensics investigator.
Where are you employed?
I work for a company called iDiscovery Solutions, or IDS.
And what is your title?
I'm a managing director at that company.
What services does IDS perform?
IDS provides consulting, expert testimony, forensic analysis, data analysis, electronic data review and production services, all to the business and legal community.
What, if any, of those services performed by IDS have you performed?
I perform all of those
I
services.
mean, y'all know I got Clint for all this.
How many years of experience do you have in computer forensics investigation?
I've worked in the industry for 20 years. Particular evidence ID. So for example, A00 hypothetical in my opinion.
Mr. Acker, did you form any pictures?
Visually, they look
To evidence in this court,
I hear him.
I misheard.
Hold on.
the first one, for example, the rails of the evidence for which I found Mr. Neumeister's original photos that he had concerns about, specifically the ones that had iOS in the software metadata
Yes,
field.
and Clint, we trust.
I validated that those came from devices that
We've already
had
talked about this. Me and Clint had one here.
had log files that were validated by me. In other words, they came from original evidence files, and in most instances, they came from more than one file.
Mr. Acker, the opinions you have testified to today made to a reasonable degree of forensic
Damn, I missed one day
Yes,
and y'all
ma'am.
are blaming me for everything.
No further questions, Your Honor.
All right. Cross-examination, sir.
Thank you, Your Honor. Good morning, sir.
Good morning.
I missed one day and y'all are seeking out your vengeance
You've
on me.
worked with opposing counsel's law firm approximately 20 times before?
Give or take, yes.
For more than a dozen years?
Those 20 probably would have been spread out over more than a dozen years.
Okay. As you sit here today, You cannot testify that all of the photographs produced by Ms. Heard are authentic originals, correct?
No, I can testify to the ones that Mr. Neumeister identified with specificity.
Right.
Okay, I can tell from that we need to switch. I'm not watching the NAS clown. Listen, if y'all didn't pick on me, then I wouldn't think that y'all loved me. So the fact that y'all are picking on me tells me that you do, in fact, love me. The love is mutual. We do need Clint for this. Anything else we should watch? Because I've already gone over the EXIF data, so has Clint. So I already know all that. JD on the stand's gonna be long, and y'all have already all watched that, so I can watch that and not make y'all all sit through that again. Johnny's cross from yesterday. The demonstratives. Ooh, Peyton. I love somebody that can remember the terms. Woo! Okay, you won me over by knowing the term demonstrative. I will go back to tomorrow. Remembering the word demonstrative aid will win me over. Let's go. Day 22.
I worked there. What happened when you met Miss Heard in 2009?
My life went to shambles
Ready to
like
start
everybody
eating
else's.
healthier? Meat?
No, I
Pachava.
don't want to eat healthy. I'm literally
Pachava
eating
is
fucking
the-
Pringles and Dr. Peppers right now. Like,
I
no.
was in the bag.
Save that commercial for somebody that actually does want to be healthy.
In a manner.
Good morning, Your Honor. Mr. Depp calls Kate Moss to the stand.
Candy curry.
She will be appearing on your screen.
All right, ma'am, can you hear me? Yes, can you count to 5 for me?
1, 2, 3, 4, 5.
Thank you, ma'am. If you could raise your right hand. Do you swear or affirm to tell the truth under penalty of law? He has not been sworn.
You solemnly swear or affirm to testify truthfully in this case on penalty of law.
Yes, ma'am. Good afternoon, Mr. Neumeister.
Good afternoon.
Could you please state your full name for the record?
It's Norbert, Norbert, Brian, I go by Brian, Bryan, Neumeister, Neumeister.
Okay, somebody mentioned that they removed the black marks over the EXIF data and proved they were taken. Here's my thing. Again, off the bat, the fact that they felt the need to cover the EXIF data to me, immediately no. Immediately no. No. When the EXIF data is covered, that tells me that they can't verify this shit, and there's disagreements about it, so they're covering it up. They don't want it in evidence. Full stop. No. There's no reason. If it was a few pictures that didn't have EXIF data like that, maybe that'd be one thing. But everything, no. And if you tell me that they're about to take off the black marks on the EXIF data and it's going to show proof that they were taken the same day, I'm going to lose my motherfucking shit.
DER.
Could you start by describing your educational background, please?
My educational background, well, I graduated from Cal State University Northridge 42 years ago with a degree in political science. From then on, I've been working professionally in photography, totally unrelated, for the past 42 years. And that would also include videography, audio, and a few other different binary related tests.
Where do you currently work?
I own USA Forensic.
What is USA Forensic?
USA Forensic is a digital forensics company. We are boutique. We're very small. We work. We have offices in Grosse Pointe Farms, Michigan, and in Phoenix, Arizona. We work with varying types of clients because to us, data is data. It takes no side. So we could be ending up working for a prosecution or the Axon company used by police officers. We clarify their cameras to better see work on the West Coast. So I grew up around television cameras. My first camera.
I've already known.
There's a few others, but again,
I already saw this guy's entire resume, and if you are a media member on the website, you can go through the documents, and there's a motion about handing over the data and all that stuff. And at the very bottom of it is his entire resume plus a picture of his office for anyone that cares.
they're just
So that's why I'm fast forwarding. I don't.
mainly to have a XF viewer.
Anything else that you looked at?
Yes, when we're dealing with RGB cameras, which are red, green, and blue channel cameras, which would be a cell phone or a basic home camera, they're based on RGB channels. We would do four types of scopes. We would do a vector scope, we do a luminance scope, we do a waveform scope, and then what's called an RGB parade. And those scopes analyze different things. The vector scope analyzes where the different types of colors are headed in. For example, it's broken up into reds, magenta, different areas on a scope. We would take a look at that to see if there's anything out of the normal for the type of camera being used. In other words, would there be above a certain percentage of chroma? And chroma means color saturation.
Objection, Your Honor. Outside the scope, we can approach.
All right.
Like,
So somebody just asked about that in the comment section. So there's with like the raw eye colors, whatever you want to say, like a camera can only, how's the best way to explain this? There are some colors that would not naturally be caught in a camera. And so the saturation would have to be turned up or down in order to have those colors present in a photo because they wouldn't be there naturally. And if certain colors and things are there, then the saturation, the hue, the temperature of those pictures, it's a giveaway that they've been doctored. Oh, I forgot I can fast forward, so hold on.
As quite a number of the photos had been through a photoing, at least one, possibly
objection, Your Honor.
You need help.
Oh, come on.
Let God help you through this.
No
Foundation,
thanks.
which photos is he referring to? We have to go through this one by one.
One's in evidence. Mr. Neumeister, in terms of the photos that you looked at and that you formed opinions about, do you understand if they've been submitted as evidence in this case?
Yes.
Okay. And what conclusions have you formed about those?
Same objection, Your Honor. That doesn't cure the issue of the objection. We have to go through this. Which photos is she talking about? Which one's in evidence? What exhibit numbers? That's the basis of the
We're
objection.
talking generally about opinions right now, Your Honor, and we're going to get into some specifics. I think we have to go straight to specifics. Okay. Mr. Neumeister, have you prepared a demonstrative that aids in your testimony with respect to any of the photos that you looked at in this case?
Yes.
I'd like to pull up plaintiff's 1303, Your Honor, if I might approach.
Your Honor, I would again object. We can approach to discuss
Okay,
it.
I'll approach.
Yeah, I was laughing at that commercial too. I guess it's because they heard me say, "Dear Lord, 10-ounce baby Jesus, Buddha, Egyptian gods, Mother Nature."
Been through photos one or
Tom Cruise.
Tom, can we pull up Defendant's Exhibit 170A, which has been admitted into evidence? Mr. Neumeister, does this photo appear to be one that you have analyzed as part of your analysis in this case?
There were many versions of this photo. I would say there were dozens of different versions with different chromatic values, different file sizes, different physical sizes. Some had been through Photos 1 or Photos 3, which are photo editing software programs.
Your Honor, at this time, I'd like to show Mr. Neumeister's demonstrative Plaintiff's Exhibit 1303. All right, any other objection?
I would object again, Your Honor, because the photograph in 170A is not in evidence.
All right.
Or, yeah, I mean, the photograph is in evidence. None of the photographs he wishes to show the jury are in evidence.
1303 is in evidence over objection. I'm not in evidence, I'm sorry, as a demonstrative.
Just as a demonstrative.
I'm sorry.
Could we publish this very please?
Of course it is.
And
Of
Mr.
course it
Neumeister, what does this demonstrative show about the photos that you analyzed?
Amazing.
Well, they appear to be similar. However, if you look below at the file sizes, one on the left is 712 kilobytes. The one in the middle is 489 kilobytes. And the one on the right is 524 kilobytes.
So this, let's see here, how would this work? This would be the original. It's got the most storage, and once it's screenshotted or changed and edited, it's going to take it down. So 1, 2, 3, if I'm guessing. 1, 2, 3.
Now, what's unusual about that is
Actually, hold on. Let me just screenshot this for the media members. Okay.
these photos will not digitally fingerprint with each other. They won't hash. In other words, forensically, they don't match. But the thing is, you could say, well, it was sent through email, maybe it's a different size. The file sizes, for example, would be possibly, you can select the file size you send a photo,
Right.
but there's no way to authenticate any photo that was presented in the way the evidence was collected.
Correct. Clint
And
talked
so
about
what
that.
conclusions do you draw from that?
Well, this is just three of many of the same type of photos that are all different sizes and have different chromatic, which means color.
Objection, Your Honor. We just had a ruling on this.
All right, sustain objection.
Mr. Neumeister, stick to your opinions that relate specifically to what you analyzed about the EXIF data, please.
All three of these photos had to go through some type of transformation to change sizes.
We can take that one down. You mentioned Photos 1.5 and Photos 3.0 earlier, I believe.
Photos.
What is that?
Photos 3 and Photos 1.5 are editing programs that Macintosh or Apple put out with their product. It's for editing photos. In other words, you would put a photo in and you would change the colors, or you would crop it, or you would clarify it by enhancing, for example, the sharpening, or you could darken it. But when you save a photo through an editing program, you leave a mark on the EXIF data.
And what is the EXIF data?
The EXIF data is the data that is embedded in a photograph that tells you a lot about the photograph. And
Again, Clint and I already went over all of this on a different YouTube video.
And in the early days, when we were using film cameras, you would write down the f-stop, which is the light setting. You would write the type of lens you use, the time of day, the type of film stock, the type.
Yes, look this. Y'all are commenting about the hair. Look, it goes without saying that, like, shit, shit. Why? Just why? I don't know.
The filters you're using. Now with digital cameras, that's done electronically, and there's about 1,000 lines of code, of which 50 are probably important, that tell you what the camera was doing.
So what's the significance of EXIF data in your photo analysis?
Well, in this situation, I can see that normally where the operating system of the camera would be, which means the version that of operating system the phone is running on, it would normally say something like I'll just throw out an arbitrary number, 9.1.3 operating system for iOS, which is Apple's iPhone operating system. Instead of saying that, it says software Photos 3.0
I bet
or
they
Photos
did.
1.0. That means that the photo had to be rendered, which means composited together in an editing program.
Did you prepare a demonstrative that shows some of your analysis of some of the exit data of the photos in this case?
Yes, I did.
Okay, can we pull up 1304, please? Your Honor, may I approach?
Let me get another sticky note.
Can Americans with no degree really get $6,495 from this education program?
Probably not.
Permission to publish as a demonstrative, Your Honor.
Any objection?
Okay, here we
Any
go.
objection, Mr.
I'm sorry,
Murphy?
Your Honor. My
She was just to
co-counsel's talking,
publish
I'm
it
so sorry.
as a demonstrative.
His name is Norbert. Like
no
the
objections
dragon
launched.
from
All
Harry
right,
Potter.
thank you. We'll publish it as 1304,
I love it.
just as a demonstrative.
And Mr. Neumeister, are these the images in this demonstrative excerpts from the report you prepared in this case?
Yes, they are.
And what do they show?
On this particular photo and on all of them, it shows the first few lines of EXIF data, the ones that would be most important for this photograph. So, for example, things you would see, the very top line would be the make of phone. It's an Apple iPhone 6. And then the resolution is 72 pixels per inch, 72:1. And instead, where it says software on a normal iPhone photo, it would, instead of saying Photos 3, it would say the software version, for example, 9.3.1. And then you've got the date and the time of the photo below that, which is really easy to change in an EXIF editor. And below that, you have things like the like the flash. You've got the exposure type, how long the exposure was.
We talked about this on the video
So
Clint and I
what
did.
you just highlighted there again was the date and time. So that's universal time code minus whatever area you're in the world.
Clint talked about that as well.
Anything else you want to show us?
Beyond my math abilities.
Yeah, just below that, if you look, there's some things that would say, for example, a directly photographed image. That is not going to be necessarily accurate once it's been through an editor. It will always pretty much say that.
Yeah.
So when you're looking at scene type or auto exposure, these are things that really don't matter all that much. What would matter is, for example, if you're taking notes, the focal length would be important. The pattern of metering, things like that to a photographer would be important.
That's true.
And again,
That's
this is
true.
just a few lines, and the reason I put these in there was
Oh,
just to
that's true.
explain a bit what EXIF data is. The actual thing I'm trying to point out is the fact that instead of an operating system, it shows the editing program that was used on this photo.
Are there additional photos that you did this analysis for?
Yes, many.
Can we scroll to the next page, please, Tom? Is there anything about this photo that you noted as part of your analysis, Mr. Neumeister?
Yes, again, it's right there, you've got Photos 3.0 on that particular photo.
Nobody
And I
can see
think,
that.
we
Pull it up.
pretty much covered what the
Here we
stuff
go.
is, but again, you see the Photos 3.0.
Why'd you gotta mark over it?
And again, this could not come out of an iPhone this way. This would go into a computer, be edited and rendered through the photo editor. And this would then be embedded in the EXIF data.
Do you have
Yeah.
other photos in this demonstrative?
Yes.
All right, can we scroll to the next page?
Same thing. You've got up here in the top, you've got the Photos 3.0, and this is throughout a lot of the photos that are in evidence or versions of the photos in evidence were gone through Photos 3.0 or Photos 1.5, an earlier version.
Let me scroll to the next page, please. And what about this one?
Same thing, Photos 3.0. And again, in a photo editing app, you can do an awful lot of things. So when you see Photos 3.0, first of all, you know it's not anywhere near an original. There's going to be compression artifacts because it's a JPEG file.
I'll sustain the objection. Next question.
Can we move on to the next page of this demonstrative, please?
And again, same thing. You've got the Photos app.
Okay. And I believe there's one final photo in this demonstrative. What about this one?
Again, if you look up there, it says Photos 3.0 on that particular photo.
All right, we can take that one down. Your Honor, I have a little bit left. I don't know if you wanted to.
All right, you want to take our afternoon? Let's go ahead and take our afternoon recess. Just do not discuss the case and don't do any else research.
Okay. So we've done our little review, but it's 4 o'clock here. Well, it's 3:53, and I have to record the Duggar episode for the podcast from sentencing. So I've got to muster up the energy to do that. So I'm going to have to get off of here, but I cannot believe how much I missed yesterday. Cannot believe how, I mean, I can because that's my luck, but I hate that I missed so much stuff yesterday. And then if I'd known today was going to be a half day, I would have taken my nap after the half day. I didn't know. So, but no, thank you guys for rewatching it with me and keeping me up to date on all the things that I miss. Sounds like everything that was predicted or said was spot on, especially with the TMZ guy. I was spot on with that, but to be fair, it was, I feel like, very obvious how that played out. Some people, somebody in the comments said, no, they do hang outside the courthouse. I'm like, no, they really do not, unless they have a reason to. Anyways, I think that was very obvious. He proved what should have been obvious, but in case it wasn't, he's done that for us, so that's good. I will watch some of it. It's me. I'm the cougher, y'all. It's me. Oh, I miss a day, and I'm never going to hear the end of it. I would be hard on me too. Oh, thank you. I totally dressed like a dude yesterday. I had my regular black suit, but I ordered like a boy's white button-up, borrowed my husband's tie, and then my husband was like, take this tie clip with you. So I had a golf club tie clip on and just challenging gender norms while at the Duggar sentencing, because that seems like the most appropriate thing to do. Yes. If y'all did not tease me, I would not. That's how I am. If I'm hard on you, if I keep it real with you, that's how you know I love you. If I don't do those things with you, then you're not a real one. So absolutely. Y'all should be making fun of me. Y'all should be giving me a hard time. The one day I'm gone and there's not a cougher, I'd be like, bitch, you're the cougher. But like, where was the cougher yesterday? Very, very unfortunate. This is not helping my defense that the one day I'm gone, the cougher's not there. It's really not looking good for me. It was very Men in Black vibes at Duggar. I'll tell you that for sure. The chips I'm eating have defamed me because I choke on one and I'm now the cougher. But I love you guys. I missed you guys yesterday. And and yeah, I was unfortunately at Duggar, so oh, what a mess. What a mess. What prison is he going to? Yeah, I can answer a few Duggar questions before I get off of here. We don't know yet. Gelfand asked for 3 possible prisons, and my notebook is not in here with me, but one of them was a medical facility, so he for sure is not going there. I don't even know why they bothered to ask that he would go to the medical facility, because that's not happening. The other one was in Texarkana and Seagullville. So they asked for Texas prisons, which mind-blowing, but okay. They asked for Texas prisons. So Judge Brooks did take that into consideration. He made notes that that's what they wanted, so we'll see. But what they asked was all 3 Texas prisons. Any other Duggar questions? One of y'all, it was Tiff. Tiff recorded me and Carrie talking on TikTok Live a few weeks ago, and we did this thing where we said, on the count of 3, say how long you think he'll get. And on the count of 3, I yelled 12, and it was kind of a joke yesterday because he got 151 months, so 12 years and 6 or 7 months, 12 years and 7 months. And he has 6 months time served from being in Washington County, so he got basically exactly 12 years. So that was a joke yesterday for sure. But I'm glad you saved that, Tiff. I'm glad we had that. He sat directly in front of me, and he kept to his motherfucking self. I can do the West Memphis 3 live if y'all want me to. I can, but if I do it live, okay, here's the thing. I'm happy to do the West Memphis 3 case live, but if I do it live, we're going to have to understand that we're doing it in chapters. So, like, we're going to talk about this evidence or this section, and we can't be blowing up questions with like, well, what about this, because we have 30 years to explain. So if I don't do them, I was going to do them in little video chunks about certain topics. Now I'm more than happy to do them as a live coverage in chunks, but I just want to make sure that if we do live coverage chunks that we don't jump ahead in the questions, because we'll have to like build up all the information. So you guys can tell me what format you think's best, but we can definitely do it however y'all see fit. I do not discuss, I see this. Let me just put it here. I don't discuss those aspects of trial. The way I see it, that is a private citizen who is also a victim showing up to court. And so I don't like that when someone shows up as a private citizen and a victim, that they get made out to be like a public spectacle. I don't like that. So whatever I saw or did not see involving her will stay between me and my Sojo brain cells. Yeah, it'll be a multi-linear timeline, but the math will math with the West Memphis 3 for sure. We could do that. We could cover like certain segments and then do a live to discuss certain segments. I just can already tell now that if I do a live and I say like XYZ, that people are going to start jumping in the comments, jumping ahead, asking questions that I'm for sure going to get to, but we have 30 years to cover. So it's going to take a bit for us to get there. I will not cover this one. 100% I will not cover this one. I will absolutely not cover this one. I'll just leave it at that. But no, yeah, I will not be y'all's guy or gal for that one. This is the West Memphis 3. These 3 teenagers were wrongly convicted for the death of those 3 kids. and they were released from prison 2010 or 11-ish, around there. And it matters now because the West Memphis Three are trying to get the DNA tested to prove that they're innocent. And the state of Arkansas is seriously trying to deny doing that, which is fucking asinine, but we'll get into it for sure. We could do that. We could do that. If they do this trial live, I will do live watch with y'all. How about that? If they do the Vallow Daybell trial live watch, I will do live watch with you. I see the comments. I see some of y'all are on the same page, but it depends on which one you're referencing. Because one's a red herring. Oh, absolutely. Absolutely, yes. I do. Yesterday, we have not said anything about it, but yesterday it became public knowledge that I know the Holtz. So we did not announce that to everyone, but yesterday made that clear. So the Holtz have done part of theirs, so that'll get edited and go out. So you'll hear from them. Clint, of course, will get back on. Maybe Jen and Mary. I tried with Bowman. Me and Bowman, we were trying hard to get it scheduled, but we'll see. But I will say this though, I'm done with Duggar for sure. So like, when I'm gonna finish out, like I'm gonna record the sentencing hearing from yesterday and talk about that and get the remaining interviews up. I'm gonna see it through, but I'm gonna see it through in the next week or two. Like, I need to be done with that before I look at that skeleton come out of the campsite that we looked at earlier. That's a great idea too. %. I'm glad some of y'all know about this case already. Okay. So, God, this is going to sound so fucking Arkansas. Jesus bless. My Arkansas is about to show. My Southern girl. This is opposite of me, so I got my Southern girl is about to show. This is an alligator snapping turtle, and just so y'all know, I am obsessed with turtles. I am obsessed with turtles. I have 2 turtles. They're 12 years old. I'm obsessed with turtles. But ironically, turtles came into play with the West Memphis 3 case. And so I printed off these alligator snapping turtles. Like, that's one that's actually from Arkansas. That's huge. This is another one, and about the anatomy of alligator snapping turtles, and their, more specifically, the anatomy of their mouth and their eating patterns based on the season and with the bite patterns. Basically, I did in-depth research on fucking alligator snapping turtles for Arkansas, and there's a reason for that. So my real good critical thinkers here can put 2 and 2 together. The reason there's so much research on the alligator snapping turtles is because I think they caused these marks. And I got the math to make it math. Girl, Google alligator snapping turtles. I swear. Blow your mind. I'm so jealous. I'm obsessed with turtles. I mean, I am. I have a wall of like collectible turtles, and I'm just a weird person. I'll own it. I don't even care. I love that I have found my people. There are other turtle lovers in here and people that have turtles. Ugh, I have found my people. I truly have. My brain knows no bounds. My brain's doing a million things at once, always. Always. Yes, this is correct. Alligator snapping turtles are, just Google when we get off here in a second, just Google alligator snapping turtles and you'll see what I mean. And then if you're a media member, go to the West Memphis 3 file and trigger warning, okay? But I mean, honestly, if you're going to be a true crime subscriber, you should know like what's coming without that trigger warning. But if you're a media member and you want to know what I'm talking about as far as these alligator snapping turtles and this, go to the West Memphis 3 case and go to autopsy crime scene photos. More specifically, autopsy photos. And you'll see this, and then you'll know. If you're from the South, you'll know. I ain't even worried about it. If you're from the South, you'll get it immediately. They did. They did. And see, that's the thing. Like I said, covering it live, people are going to ask questions and jump ahead, and like my ADHD will be frazzled. So either I'll have to tell it in chapters and we just take notes in the comment section and then afterwards do questions just on what was discussed, or I'll have to do videos with information and then do a live to discuss the chapters of information that we've gone over so far. Because my ADHD will not be able to do people jumping way far ahead and having to stop and explain stuff like that. I mean, if you're a media member, there's thousands of documents for West Memphis 3 already on the Google Drive for y'all. I have over 15,000 documents. I just have to get them all on there. But there's a lot. Any other questions about Duggar or West Memphis 3 or Depp or anything before I go work on Duggar until 3 o'clock in the morning? I mean, I don't blame people for jumping ahead because clearly when I'm watching something, if I know what's coming, I'm like what I did earlier. I didn't intentionally mean to jump ahead. It's just I was like, I'm thinking out loud and I happen to be jumping ahead. But with the West Memphis 3, it's 30 years of very complicated evidence that we have to go over. And I'm going to need everyone to really hone in on critical thinking skills and understanding each section so that when all the information comes together, you know what's going on. Ed, just go listen to the season 1 of my podcast and I'll cover the whole trial for you. Season 1 of the podcast, I do the entire thing. Not that I recommend doing that case. I honestly don't. Spare yourself if you don't know. There's a lot to take in with the West Memphis 3. And that's the thing. Like I said, like it's going to be a lot. It's going to be a lot. And some of the issues with the West Memphis 3 is like, I'm going to be explaining some stuff to y'all and you might not know why it matters, but you'll understand later why it matters, why the pieces come together. So it's really hard for me to think about how to segment the information to you guys, but I'm just going to do the best that I can and we'll work it out. We always do. We'll figure it out. You guys are appreciated. I mean, this would not be fun without you guys, and there would be no podcast or YouTube or TikTok if y'all didn't listen and contribute. And so, yeah, I give all the credit to y'all. Oh, see, Lori did the deep dive. How does someone become a media member? So if you go to thesojofiles.com, you request to use the website, I'll approve that you can use the website. I know that sounds crazy, but it's safety measure. I mean, I pretty much approve you unless I notice a name, which you don't have to worry about that. So if you go to thesojofiles.com and you request to use the website, I'll approve it. Once you do that, you can purchase a media membership. And the media membership is when I'm covering a case online, I'll get the legal documents, I'll get the police reports, I'll get evidence, I'll do research, and I keep all of that in a folder. And the media membership gives you access. I put you on my Google Drive. Now, once you get the media membership, you can see everything on the website as far as that goes. But it's easier for everyone if you download the Google Drive app and I add you to the Google Drive and you view the documents that way because you can see the notes and it's thousands of documents. But I'll say this. If you do not like looking at legal documents, crime scene photos, stuff like that, you will not like it because that is what it is. It's basically all of my research and I'm letting y'all have it so that you can go through it, help me look at things, look at it at your own pace. Maybe you move faster or slower than I do on here. And so that's what it's for. But if you are not the type of person that wants to go through police reports and legal docs and research and stuff like that, the media membership is not going to be for you. But if you do, then it's great for you. Are they doing it tomorrow? I slept through today. Y'all know that. So are they doing it tomorrow? Do we know? Okay, court tomorrow. Okay, so we'll be here tomorrow. I'm glad y'all said something. Lord bless. Okay, 9 o'clock. I'll be here. I promise I'll be here tomorrow morning. Okay, we will be here. Any more questions on Depp, on Duggar, on West Memphis 3? Any more questions? West Memphis 3, we will start after all of this. Discovery file. Here's your discovery file with all the stuff. Yeah, that's basically, yeah, it's like it's a discovery file of all the documentation evidence. Yeah, that's it. Okay, yes, I'm going to go do my podcast because it's going to take forever. I'm going to lose my voice, I'm sure, halfway through, and it's going to be wild because I should have already recorded the letters, and I didn't do that because I was doing Depp. So I didn't get the letters done. Now we've got closing, so I'll be behind. But you know what? Like, people can rush. I'll tell you what, this is one thing that's funny about being a reporter. Whatever. I categorize me however you want. I don't care. Random chick. It doesn't matter. But when you cover these things, when you're in court, they get a piece of information and everybody just hightails it outside because they want to be the first to report it. I don't give two shits about that. Once somebody runs out and reports it, it's already done. So, like, why am I going to run out to my car and try to, like, who cares? Once it's out there, okay, you got 12 years, that'll spread like wildfire. Who cares? I sit in there and get all the information, and then I go over it in depth later. So, no, I'm not going to be the first one to break to you that he got 12 years, but I'll be the one that's going over it in depth. And there's so many cases like that where people, like, rush out to get the information. I'm not a fan of doing that. I want to, like, do it right. Anything else? Anything else? My nails are fake as fuck, y'all. You can go to Sally's Salon, get you some fake nails, paint them, glue them on, snip them, file them, boom. Cheap nail kit. I buy my nails off, so full disclosure. If y'all see me with nice nails, they're fake. 100%. Just keeping it real. Okay, 9 a.m. tomorrow, which is 8 a.m. for me. So I will see you guys at 8 a.m. tomorrow. And we will go from there. I may or may not check in on TikTok about Duggar. I don't know how I feel about that. We'll see. We'll see. But yeah, I'm glad to be back too. I missed you guys yesterday. I really did. Because y'all know how I feel about the Duggar case, so. All right, I'll see all you chunky alpacas tomorrow. Love you all.